Can you hear me okay?
I can, Ken.
Okay, good. I sometimes have trouble with my computer audio, so I dialed in on the phone line and it went through the process and we don't have a password. And so I
Oh,
couldn't use the computer, the phone dial in. But if you can
How
hear me okay on the computer
you
audio,
doing, Ken?
I'm well. Bert, how are you today?
Good, just peachy.
peachy.
Where's Susan? Oh, there you are. Hi, Susan.
Hi. I was gonna hide
Yeah.
for a while.
Huh? What?
I was gonna hide for most of the day. So
She's going for the plausible deniability.
exactly.
Susan, do we have separate Zoom logins for our networking or no?
Nope. I'm just gonna hit a button, and God willing, everybody's gonna go where they're supposed to go.
You think you can do that, really?
Bert, don't jinx me right now.
I won't.
So anyway, yeah. The first one will work. I'm fairly positive it's getting the next one set up after that, but it looks like I have 4 hours to make sure that happens. So anyway, so we will get started at 9:15. I put that in the chat box. Students are encouraged to submit questions in the chat box, and we'll try to get to them during the day, during the program or the panel that they are asking questions for. So afterwards, we'll be sending out to all the students an evaluation form. We'll send it by email, and along with any handouts that might be referenced to during the day, we'll just send those out afterwards via email, and then just complete and return the evaluation form so we know how we do on our first ever virtual law student program. So thank you all so much for registering. And thank you to our fellows for volunteering to speak and present. It's a whole new world. So, all right. Okay. What? Oh. Just for those that are on right now, the breakout sessions will be meetings with one college fellow and approximately 3 to 5 students. Those sessions are 30 to 40 minutes long, depending on if it's the morning or the afternoon one. And some people have had to drop off. So college fellows, if you have less than what you thought you were going to have, it may be because somebody's had to cancel this morning. I've gotten a couple of cancellations, but students, this is your opportunity in a very small setting. Like I said, anywhere from 3 to 5 students with a college fellow to chat and talk about whatever you want to talk about. So hopefully it's labor and employment law. So I see that Peter has put something in the chat box. If anybody wants to download the document, you can do so. Thank you, Peter.
It's a document that I think is going to be relevant to our conversation later on.
Perfect. Okay. And I just downloaded it too, so I can send it if anybody needs it after the fact. And there's our esteemed moderator, Marty Mellon. And I know John Runyon is on. So I'm so glad I did that. Spotlight video.
Susan, should we start precisely at 9:15?
I was hoping so.
And good morning to you. Good morning to everybody.
Good morning, Marty. Please tell me that's I only have one speaker, Marty, who hasn't registered yet.
And what time is that speaker scheduled to go on?
This afternoon.
Oh, we're good. Then that's not my problem. That can be Rich's problem.
Oh, excellent. Thank you for that. So I'm just, Mike Kramer, I see that you are there.
Where is Mr. Kramer? He's sitting outside somewhere, or is that a fake background?
No,
Yes, I'm in Michigan, Bert.
Oh, go blue, where?
North of Muskegon and south of Ludington.
Go blue.
So blue.
That's right,
Hey,
Adele.
Adele.
Well, Mike, I've got you beat. I'm in New York City where I am quarantining with my brand new grandson.
Oh,
That's pretty
congratulations.
fantastic.
Mazel tov, Marty.
Thanks.
I'm in the Upper Peninsula in Marquette visiting my mom.
All
Well,
right.
at least it's not January up there.
Yeah.
I remember once, years ago, when I was with the firm, we represented Marquette General Hospital, we had an R case hearing, and we flew up there on good old Repugnant Airlines, if you recall Republic.
Yeah, we called it Wounded Duck.
Yeah, or Repugnant, and all I know is the snow was up to the gutters on the houses. It was unbelievable.
that sounds horrible.
My
Yeah.
mom worked at Marquette General for like 40 years. She was a speech therapist there. But we used to have to like dig paths out, that were over my head to
Yeah.
the sidewalk. And you'd
Yeah.
have to like, stand in the street and so somebody could back out because they couldn't see the cars coming from the snowbanks.
I actually have a vote no video that Marquette General used to defeat a steelworkers organizing drive that I use in my labor law class when we discuss, board regulation of campaign propaganda.
Mike
Got a case
Kramer.
up there
real
right
quick.
now with the Michigan Nurses Association.
Yes, Susan, go ahead.
You had mentioned when emails that we had going back and forth about a PowerPoint.
Yeah, we don't have anything like that.
Okay, no, I was just gonna say, if you ultimately did have something that you want me to hand out to the students, send it to me and I can send that afterwards.
Yeah, no, we're all set on that.
Okay, good. Sorry, I meant to email you and forgot. So,
No problem. Morning, Ken Seatman.
Good morning, Mr. Kramer. You doing any caricatures these days or writing any plays?
I'll draw you during the course of this morning's Zoom meeting.
Yeah, I'll be looking forward to that. I'm certain flattering rendition.
There you go.
all right, so we got about 3 minutes to let some more people jump on
Yep.
and we can.
Mike, you could have done that Geico commercial where she does the caricature of the artist with the big billed hat.
Yeah,
Maybe you could sell your services.
Geico was unwilling to pay my hourly rate, so.
What a shock. So,
It's how they save you money on car insurance.
exactly. Well, let's see who this is. Okay. All right. I'm going to turn off my camera, but I'm here. And I'll probably mute myself, but I'm here if anybody needs me.
Hey, Ken, it looks like you're in the office. Is that
I
right?
am.
Good place to be. We have a lot of Michiganders on the phone here, or
Good.
people that used to live in Michigan. I was gonna, they had a big gun shop on our way driving up. I was gonna get an assault rifle so I could go protect the governor at the Capitol.
It's embarrassing.
Ah,
When we arrived here, Adele, I stopped at the local marathon station, and they had a sign out front that showed that they carry all the essentials, and it just said 3 words: liquor, flags, jewel pods. So, can get anything you need there.
I was teasing
Morning,
Tim
Nigel.
Hawks, who's in Milwaukee, about holding my breath through Wisconsin because they have this big spike, and I think they're probably going to go on the can't come here list for Illinois soon. He said it's not too bad in Milwaukee. I think it's Madison and some of the areas that La Crosse, some of the areas that have universities that are having the spikes. And
Yeah.
Michigan's not doing too badly. I think the governor's done a good job of controlling it.
UW-Madison had a big spike as soon as the students went back. We've got lots of friends who have grandkids who were there, and everybody got it.
That's where they were planning to take our governor, once they.
Right. That's right.
okay, it is 9:15, so let's get started. Welcome, everybody. I'm Marty Mallon. I'm a professor at Chicago Kent College of Law, a former member of the College of Labor and Employment Lawyers Board of Governors, and chair of the committee that organizes this program every year. I want to thank my fellow committee members, and I want to thank all of the fellows of the college who are here today. You have really come through for the students. We have the largest turnout of fellows in the history of this program today. And all of those fellows are here for one reason and one reason only, and that's to support you, the students who are with us today, to help you develop as the next generation of labor and employment lawyers. I also want to thank our Student Steering Committee, who are a great source of ideas for moving this program to a virtual format. And if you are a 1L or a 2L or a 3L part-time student, that is, if you have another year after this year or more to go in your law school careers, I want to encourage you to volunteer for the Student Steering Committee for next year's program. Committee members meet by email, so it's not onerous, but it is very important. You'll receive a survey to complete an evaluation of the program at the end of the day, and there'll be a place there where you can indicate your interest in serving on the steering committee for next year. Or you can simply email Susan Wan, S-Wan, S-W-A-N, at laborandemploymentcollege.org. And I also want to thank Susan, who has just been amazing in organizing this event and pivoting from what, in prior years has been an in-person event to make this happen in a virtual environment. Couple of quick housekeeping announcements. Please stay muted until the networking breakout sessions. But if you have questions or comments, do put them into the chat. And I will be monitoring the chat while I'm moderating the program. And to the extent there is time, I will kind of summarize those and put those to our panelists. When we move to breakouts, you will be in groups of 3 to 5 students with a college fellow. And you will automatically move to your assigned breakout room via Susan's magic. So you don't have to do anything, just stay logged in. And do take advantage of this. Think of it as a kind of speed dating. Again, the fellows are really the elite of the labor and employment bar in Illinois, Indiana, and Wisconsin. They are here for you. So do take advantage of those breakout networking sessions to ask questions, get their contact information, help yourself develop. So with that, I'm going to introduce John Runyon. John is the immediate past president of the College of Labor and Employment Lawyers. He's practiced labor and employment law for 48 years, representing unions and individuals. In addition to being the past president of the college, he's chair-elect of the State Bar of Michigan's Labor and Employment section. He chairs the committee that's responsible for publication of the Michigan Bar Journal. And not surprisingly, he's a recipient of the section's Distinguished Service Award and of the Federal Bar Association's Bernard A. Friedman Julian Abel Cook Civility Award. So John, welcome to the 7th Circuit from our neighboring 6th Circuit.
Thank you, Marty. As Marty indicated, my name is John Runyon. I'm the immediate past president of the College of Labor and Employment Lawyers, and I'm standing in for our president, David Borgen, who is an avid hiker and is out hiking today somewhere in the Wild West. I practice union side labor law and with a small Detroit firm, and I also represent individuals in a variety of employment matters. It's my privilege to welcome each and every one of you on behalf of the college. And I'd also like Marty did, thank our tireless executive director, Susan Wan, and each of the fellows who have donated their time on a Saturday for this program, especially Marty Mallon, who's done so for a number of years. The College of Labor and Employment Lawyers was founded 25 years ago. It's hard to believe. And from the start, its mission has been not only to promote achievement, advancement, and excellence in the practice of labor and employment law, but also to establish by example standards of professionalism and civility for labor law practitioners. I encourage each one of you to visit the college's website, click on the About button and scroll down to Principles. There you will find a one-page document, although the type is small, the College of Labor and Employment Lawyers Principles of Civility and Professionalism for Advocates. Do yourself a favor, print out a copy and read it, and then do your best to follow those principles. I started practicing labor and employment law nearly 50 years ago in 1972. At the time I joined the State Bar of Michigan, there were 12,000 lawyers, 12,000 licensed attorneys in Michigan. Today, there are almost 4 times that many. I'm sure if you checked, you would find that the number of lawyers has also increased exponentially in the states within the 7th Circuit, including Illinois. What impact has this increase in the number of lawyers had on our profession? Lawyers now advertise on buses and billboards. Lawsuits get filed that would not have been brought 50 years ago. A management attorney recently told me that he could not risk taking the case to trial because an adverse verdict would mean that he would lose the client. Competition for clients is so intense that some lawyers take shortcuts or resort to Rambo tactics that were unheard of when I first began the practice of law. These attorneys mistakenly believe that their clients expect them to employ such approach, and perhaps some do. Technological changes have also played a role in increasing the lack of civility in the practice of law. Although the computer and e-filing have in many ways made the practice of law much easier. Believe it or not, when I started, we still use carbon paper. These changes have also brought about ethical challenges. Some lawyers, myself included, have inadvertently distributed privileged communications by mistakenly hitting send all or forgetting to scroll down to check an entire email chain before replying. I will talk about your role if you're on the receiving end of such an email in a moment. Other attorneys fail to take a deep breath and reflect a moment before hitting the send button and emailing opposing counsel a message which they may later come to regret. The COVID-19 pandemic has brought about a number of changes in the practice of law, and I predict that some of these changes will be with us forever, long after we've developed a vaccine and only wear masks on Halloween. These changes have required that many, I would say most lawyers, practice from their homes like sole practitioners without the mentoring and guiding hands which assisted me when I began the practice of labor and employment law. Because I did not have the benefit of attending a program like the one you're taking today before graduating from law school, the guidance that I received was indispensable to me as I was learning to apply the few principles I remembered from my law school professional responsibility class to the everyday decisions one makes on the fly as a labor law practitioner. The COVID-19 pandemic has also brought ethical challenges and additional stress into the lives of many lawyers, particularly older lawyers like me who are not as comfortable with Zoom, WebEx, LoopIn, or GoToMeeting. For example, how do you tell whether a witness who is testifying remotely is consulting a document while testifying or is being coached by opposing counsel? The isolation required by the pandemic has also meant that I've had to figure out on my own how to share documents during the Zoom hearing without consulting one of my younger colleagues. I suspect that virtual conferences like today's and arbitration hearings and depositions via Zoom are one of the consequences of the pandemic, which we will decide to continue long after the necessity for them has disappeared. I also guarantee you that someday during the life of your practice, particularly if you stay at it as long as I have, there's going to come a time when your professionalism and the college's are going to be implicated in a decision you have to make. Let me tell you about a recent experience of mine. I was representing a labor organization in a grievance arbitration proceeding involving a small municipal police department. The grievant was a woman sergeant who had been passed over for promotion to chief and then fired by the man who had leapfrogged over her into the chief's position. Prior to the arbitration hearing, I had made a request for relevant documents and had been in frequent email communications with opposing counsel, who was an experienced attorney from a large management side law firm. One day I received an email from him with attachments, which I could immediately tell was not intended for me because it started, "Runyon has really stepped into it this time." I did not review the attachments, but I could tell that opposing counsel had attached suggestions from the chief for cross-examining the grievant. That information would obviously have been very helpful in preparing the grievant for hearing. What was I to do? I did not hesitate. I did not consult either the grievant or my contact at the labor organization. I immediately deleted the email and advised opposing counsel as well as my client that I was doing so. You can better believe that I carefully prepared my client for cross-examination, and she did wonderfully, even without the benefit of knowing the questions which the chief had suggested for her. Better yet, the arbitrator reinstated her with full back pay in an opinion and award which excoriated the chief. I'm also happy to report that the grievant has moved on to a larger department which better appreciates her skills and where she is rapidly progressing up through the ranks. Based on my near 50 years of experience, I guarantee you that if you follow the college's civility principles, your clients will be just as successful. You will find greater satisfaction and enjoyment in the practice of labor and employment law, and there will be a lot less stress in your life. Good luck to all of you.
Thank you so much, John. That's a great way to start this program with the students. And I'm going to embarrass you a little bit. When I graduated from law school in 1976, my first job was as a law clerk to a United States District Court judge in Detroit. And already John Runyon was one of the most respected labor lawyers in the city of Detroit. And for me, decades later, it was just such a treat to reunite with him and serve with him on the college's board. Okay, we're going to move on now
Thank you, Marty.
to our first set of panels. We have 3 of them. And following that, we will have the first round of networking breakout sessions, and then we'll have our second set of morning panels. And then we'll hear from Judge Pallmeyer. And then I'll turn it over to my Chicago-Kent colleague, Richard Gonzalez, who will take you through the afternoon, which is really going to focus on your professional development, career advice, and the like. You know, when we have this program in person, as we have the last 10 years or so, there are numerous opportunities for you, the students, to get to know the fellows who are present during breaks, over lunch, over the continental breakfast that we have at the beginning in the morning. And unfortunately, those are not present in this virtual environment. The best we can do are these network speed dating sessions. But I do encourage you, and I know I speak for all of my colleagues in encouraging you to feel free to reach out to particular fellows as things that they're talking about, you know, strike a chord with you. Reach out to them by email, introduce yourselves to them by email, and, you know, tell them, you know, that you were present at today's program, you appreciated what they did, and just strike up a relationship. They are here for you, and they will be receptive to you. So with that, let's move on. Our first panel in the first set of panels is going to focus on recent Supreme Court decisions. I'm going to quickly introduce them in the order in which they're going to speak. Jill Goldie is a founding partner of FICE Goldie, where she represents individual employees, managers, and executives in negotiations and litigation. And she also conducts neutral investigations. During her prior more than 25 years in practice, she held senior level management positions. So she has been on both sides here. In those positions, she represented management with the law firm Cypher Shaw. She also represented management with the City of Chicago Corporation Counsel's Office. And for many years, she was also a corporate officer at Motorola. Jill will be followed by Diane Smason. And in January of this year, Diane became the deputy director of the EEOC's Chicago district office. She started at the EEOC as a trial attorney in 1998, became a supervisor in 2004. For over 20 years, she has litigated a wide variety of matters, including class and systematic cases under Title VII, the Americans with Disabilities Act, and the Age Discrimination in Employment Act. And then we'll have Rob Bernstein, who is a partner at Lehner Muchin. Rob has been at Lehner Muchin for almost his entire career. He's an equity partner representing companies and other employees in their labor and employment law disputes and matters. So I will turn this over to Jill Goldie.
Good morning. I'm going to start by talking about Bostock versus Clayton County, Georgia, which is last term's widely reported Supreme Court decision, holding 6-3, that employment discrimination based on sexual orientation or gender identity is unlawful sex discrimination under Title VII of the Civil Rights Act of 1964 as amended. Among other things, Title VII prohibits discrimination by employers in hiring, firing, and other terms, conditions, and privileges of employment because of individuals' race, color, national origin, sex, or religion. The Bostock result was a surprise to most from a court with a conservative majority. Moreover, the singular majority opinion was drafted by Trump appointee Justice Gorsuch. Substantively, Bostock changed long-standing precedent. For most of the 50-plus years that Title VII had been in place, the vast majority of courts and legislatures had interpreted sexual orientation and gender identity discrimination to belong to their own standalone categories and thus outside the scope of Title VII's protection against sex discrimination. More recently, a split in the circuits had developed. Bostock resolved 3 federal appellate court cases, each of which involved an employer's discharge of a single employee squarely because of his sexual orientation or transgender status. The Second and Sixth Circuits both had held that the terminations were prohibited sex discrimination under Title VII. The 11th Circuit had held the opposite. The Bostock majority rested its decision solely on a statutory interpretation of the phrase "because of sex" in Title VII. And the court built its argument this way. If sex plays any role in the employer's decision-making, it is considered a but-for and thus an intentional cause of the discrimination. Under the but-for standard, if changing the employee's sex would have yielded a different choice by the employer, a statutory violation has occurred. The court offered this example. 2 employees who are attracted to men have identical qualifications and performance from the employer's viewpoint. One is male, the other female. If the employer fires the male employee because he's attracted to men, his sex is a but-for cause of his termination. The court's ultimate holding followed. Any difference in treatment based on an individual's sexual orientation or transgender status inevitably is based at least in part on sex and thus violates Title VII. Based on this analysis, it makes no difference that factors other than sex may also contribute to the employer's decision to discriminate. And it also makes no difference that an employer treats males as a group the same as females as a group for particular purposes. If the employer terminates all homosexual employees because of their sexual orientation, it is still prohibited sex discrimination in each individual case. The scope of Bostock's protections for LGBTQ individuals is already being tested in both employment and non-employment arenas, especially, though not exclusively, by parties with religious concerns. Just a few of the areas to watch. A separate Title VII provision allows religious organizations lawfully to discriminate in employment based on faith. Separately, federal laws governing educational programs, housing, healthcare, and other government services all contain sex discrimination prohibitions, but not all using the same exact statutory language as Title VII. Might the Bostock approach change courts' historical reliance on Title VII decisions in interpreting these non-employment statutes? The Federal Religious Freedom Restoration Act, known as RFRA, prohibits the federal government from substantially burdening a person's exercise of religion unless the enactments in question meet certain high standards. In Bostock, Justice Gorsuch characterized RFRA as a kind of super statute, capable of displacing the normal operation of other federal laws, including possibly Title VII in appropriate cases. RFRA's potential reach goes well beyond the employment arena. And of course, so does the First Amendment in its protections of religious freedom. The courts have carved out a ministerial exception, which can negate some protections under employment discrimination laws for so-called ministerial employees in religious organizations. And a First Amendment case involving the rights of same-sex couples to be foster parents will be before the court next term. Lots of food for thought. Thank you for your attention. I now turn the podium over to my colleague, Diane Smason.
Hi, thank you, Jill, for that, and Marty for the introduction. And good morning to everybody. I'm really happy to be here and participate in this program. Marty asked us to highlight a few important Supreme Court cases. And the one I'm going to focus on picks up a little bit from what Jill just spoke about. She referred to the ministerial exception, and that's what I'm going to talk to you about. So there were 2 cases that the Supreme Court decided jointly recently this summer. One was called Our Lady of Guadalupe School versus Morrissey Beirut, and the other is a case by Kristen Beal against St. James School, both of which were in the Los Angeles area. And on July 8th, so not long ago, just a few months ago, the Supreme Court held in those combined cases in a 7-2 decision written by Justice Alito that the religion clauses of the First Amendment, under what is known as the ministerial exception, exempt religious institutions from laws governing the employment relationship with certain key employees. And so the court here is balancing the rights of people to be free from employment discrimination at their jobs versus the rights of religious employers to decide who they want to employ. But in key positions is what the court is trying to distinguish between. And so in these cases, the court held that the courts could not adjudicate an age and or a disability discrimination claim that was brought by 2 teachers against these private religious schools that had previously employed them. The court found that both plaintiffs fall within the same rule that dictated the outcome in another case that was decided by the Supreme Court in 2012 called Hosanna Tabor Evangelical Lutheran Church and School versus the EEOC. In that case, the court held that when a school with a religious mission entrusts a teacher with the responsibility of educating and forming students in the faith, judicial intervention into disputes between the school and the teacher threatens the school's independence in a way that the First Amendment does not allow. In the Guadalupe School and St. James School case, Justice Thomas authored a concurring opinion in which Justice Gorsuch joined. And the judges that had joined in the majority was written by Alito, and Chief Justice Roberts, Justice Thomas, Breyer, Kagan, Gorsuch, and Kavanaugh all were in the majority. However, there were 2 in the minority. Justice Sotomayor authored a dissenting opinion in which Justice Ginsburg joined. And so let me explain a little. The ministerial exception applies to certain key employees of a religious institution. It's not limited necessarily to ministers or other kind of obvious religious leaders. The analysis of whether someone falls into that exception is whether or not they perform vital religious duties in furtherance of the institution's mission. The court said what matters at bottom is what an employee does. And the employer's explanation and description of the religious functions of that employee are important in that consideration. So the court is giving deference, quite a bit of deference, to the employer, the religious employer, and how they define that employee's duties. And note that this is not limited to just private schools. It will likely apply to other employers affiliated with churches and other houses of worship. And the court is basically saying that religious institutions have protection from government interference with internal management decisions that are essential to their central mission, including the selection of the individuals who play certain key roles. And I highlight selection because the court here is focusing on essentially hiring and termination decisions, like who do we want to work for us? And that becomes important because I'm going to mention a Seventh Circuit case, a very recent Seventh Circuit case in just a few minutes that's a little different. But under these 2 cases, both of these plaintiffs were lay teachers in parochial schools that were maintained by parishes of the Roman Catholic Archdiocese of Los Angeles. Neither of them held themselves out to be a minister, but both had certain duties as part of their jobs. They were primary school teachers, so they were required to teach religion amongst many other subjects. And the court applied the factors from the earlier case I mentioned, Hosanna Tabor, and those 4 factors that the court looks at to determine whether somebody does fall under the exception is what the person's formal title is, what their religious training is, plaintiff's use of that title, and the important religious functions that the person performs. In both of these cases, the district court found in favor of the religious institutions and dismissed the plaintiff's claims, saying they fall under the ministerial exception. Both of these plaintiffs then appealed, and on appeal in both instances, the Ninth Circuit concluded that the ministerial exception did not bar their claims. And one of them, let me say, her claim was an age claim. Morrissey Beru said that she had a part-time position as a teacher, or she was demoted from full-time to part-time. The next year then, her contract was not renewed. And her claim was because they wanted to replace her with a younger teacher. And the church said, no, that's not why. It's because of poor performance issues. In the other case, Kristen Beal, she was a 5th grade teacher at the St. James School, and she told her employer that she had breast cancer and would need time off for treatment. So it's, very sympathetic situation. The employer decided after she told them she needed that time off that they weren't going to renew her contract. So up at the Ninth Circuit, in both instances, the court said those claims are not barred by the ministerial exception because their formal titles are simply teacher, which is secular. They had no religious credentials or ministerial background. They never took their own training. These teachers did not consist of any courses on the Catholic Church. So the Ninth Circuit went the other way and said that these factors, outweigh their significant responsibilities. The Supreme Court then, on the other hand, flipped to the other side and said, no, that's not right. And it cited to the religion clauses of the First Amendment that says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And so they said these clauses prohibit governmental interference in the right of churches and other religious institutions to decide matters of faith and doctrine. And the court said that the school's definition and explanation of their roles is important. So again, it's giving deference back to the schools, as is how the religious institution explains the role of these employees in the lives of the children, that their critical role is to inculcate the faith in these children, even though they also perform other general teaching duties. The court also looked at a couple of factual points, like the employment contracts that these women had required them to carry out the school's religious mission. And their job duties, as I said, included teaching all subjects, including religion. They prepared the children for participation in religious activities, prayed with their students, and attended Mass. In the dissent, Justices Sotomayor and Justices Ginsburg said, no, you're wrong here. What you're doing, for the majority, is expanding the exception in Hosanna Tabor far beyond what it was intended to do. It was intended to be more narrow, and that there's a consensus of federal appeals courts, like the Ninth Circuit, that had consistently concluded that lay faculty, even those who teach religion at church-affiliated schools, are not ministers. And Justice Sotomayor observed that by analyzing objective and easy to recognize markers like titles, training, public-facing conduct, devised a way to separate leaders who personify a church's belief. So she's really focusing on, arguably like the minister, the head of the church, from those who simply relay religious tenets, which she would argue is all the teachers did. They were just relaying the religious tenets. They weren't really the front-facing people of the church. And so then Justice Sotomayor also said that you could rely on Hosanna Tabor in a way that the majority did not, to prevent a church from categorically disregarding employment discrimination laws for non-religious reasons. And then that goes into one last case I just want to mention, because it's in the Seventh Circuit, and it came out very recently, right after the Supreme Court cases tried to make that very distinction in terms of what kinds of decisions, what kinds of employment decisions can a church make on its own, and not run afoul of the federal anti-discrimination statutes. And what they said is, the Seventh Circuit recently found that, they followed the Supreme Court in saying, we're going to recognize that in decisions of who do we want to work for us, so hiring and firing decisions, those are going to be protected. But hostile work environment claims are not necessarily protected. And so in a case that was brought before the Seventh Circuit by Sander Demkovich against the St. Andrew the Apostle Parish in Calumet City and the Archdiocese of Chicago, he claimed that he had endured a hostile work environment based on being gay, as well as some medical issues that he had. And the court said, and he brought the claim only, he was ultimately fired, he brought the claim only for the hostile work environment claim, I think recognizing that he wasn't going to win on the termination issue. And the Seventh Circuit said, yeah, you can't, to the church, you cannot subject employees, no matter who they are, and despite the ministerial exception, you can't subject them to hostile work environment claims. So the Seventh Circuit more recently drew a line there and refused to extend the Supreme Court cases that we just talked about to hostile work environment cases. And so, going forward, it's going to be very interesting to see what the court does with continuing, religious claims. As you can tell, the court is leaning to the right in that area and is giving tremendous deference, and is really, at least in these cases, has been giving tremendous deference to religious organizations to decide on their own who they can hire and fire, and even essentially giving them a pass on engaging in employment discrimination for certain positions. Thank you. I'm done. I will pass it on to my colleague Rob for the last part of our Supreme Court update. Thanks very much.
Can everyone hear me? Hello?
We can hear you, Rob.
Okay,
Yes,
perfect.
we can hear you.
Thank you. Great. Good morning, everyone. Marty, thanks very much for all the work you did with this program. Very much appreciated. Jill, Diane, pleasure to be here with you today. And I also see a number of familiar faces on the phone. So I look forward to better times when we can get together in person. So I hope everyone's doing well, though. My Supreme Court case today is a discussion of the Little Sisters of the Poor versus Pennsylvania case. The decision came down in July of this year, and it involved the Affordable Care Act. And the Affordable Care Act, just in quick fashion, was a major health insurance law that was passed under the Obama administration. And the piece of the Affordable Care Act, or the ACA, at issue in this Supreme Court case was the ACA's birth control mandate, which requires most employers to provide their female employees with health insurance that includes access to certain forms of contraceptives. In 2017, the Trump administration had issued new administrative or agency rules that expanded an exemption from this mandate that I just mentioned to allow private employers who have religious or moral objections to opt out of providing this coverage without any notice, okay? I'm going to come back to these rules and talk about them a little bit later in this session here, but those rules are what prompted the Supreme Court's 7-2 decision recently in this Little Sisters of the Poor versus Pennsylvania case, which rejected a challenge from two states, Pennsylvania
Susan, I think we lost him.
Yeah, I know. I'm not exactly sure what to do about that.
He may not know that he's lost. Maybe email him.
Yeah.
Send him an email. Looks like his internet froze.
I'm trying to, there we go. Stand by, everybody. Although if he is frozen, I can tell you right now, he's not going to be able to get. Rob is not in this meeting, so he must have dropped out and he's coming back in. So does either Diane or Jill want to kind of say anything about where he was headed until he gets back on? No. You're muted, Diane, if you,
Yeah, no, I wish I could, but to be honest with you, we divided up these cases, and so I don't feel competent to speak on that one. I assume Jill would probably feel the same way. Perhaps, may I suggest, Marty, that you move on to the next group, and that if Rob is able to join again, we have him complete his portion a little later, maybe in the middle of one of the others.
That's a great idea. Give me 1 second. I'm just emailing Rob.
I could email him too.
Yeah, in hopes that, you know, his internet is strong enough to get his email, if not the Zoom link.
Right.
Okay, well, one more to chalk up in tales of the pandemic that we can, we'll be sharing around, you know, dinner tables and over wine a few years from now. Okay, so our second panel for the first round is going to focus on traditional union management issues. I'm going to introduce them in alphabetical order, since I'm not sure the order in which they're speaking. That may be my fault. I'm sure they emailed me telling me that, but when I went searching for the email with my link to log in this morning, I found I had over 250 emails related to this program. So it's in there somewhere. So in alphabetical order, we will hear from Tamara Cummings. Tamara is the General Counsel to the Illinois Fraternal Order of Police Labor Council, which is a large public sector union representing law enforcement bargaining units in all areas of labor and employment law. And of course, she's a fellow of the College of Labor and Employment Lawyers. We'll also be hearing from Peter Sung Orr. Peter has been Regional Director of the National Labor Relations Board Region 13 in Chicago since 2011. He has had a 23-year career with the National Labor Relations Board, in which he has also held positions in Washington, D.C. and Honolulu, Hawaii. And then Ken Seitman is a shareholder in Ogletree Deacons, Indianapolis, Indiana office, For over 30 years, he has represented employers in a wide range of labor and employment matters. So I will turn it over to our three colleagues.
Well, this is Ken. Marty, I don't know that you're at fault for not knowing the order, because we kind of went along and had it with me starting, but I don't know that we necessarily communicated that to you. So I'm going to start out talking a little bit about one of the board's cases called General Motors, decided a little earlier this year. But for those of you who are law students and are not particularly familiar with the National Labor Relations Board, it's important to realize that that's the administrative government agency that is charged with dealing with employee/union/management interactions related to employee rights. The unique thing about it is that it is composed of 5 members, 3 of whom are aligned with the party in power in the White House. And so currently there are 3 Republican, so to speak, representatives and 2 Democratic representatives. And so as a result, and as the board's members themselves have stated over the years, board law tends to oscillate a little bit back and forth. So when a Democrat is president, the board law and rules tend to lean a little more towards unions and a more expansive interpretation of employee rights. And when a Republican is president, it tends to lean a little bit more of a pro-business, pro-management tilt in decisions and rules that come out of the board. And this pattern is certainly continuing under the Trump administration and in a series of cases, and to some extent a little bit in the General Motors case, about which I'm going to talk about. I submit, however, that there's a lot to be gleaned favorable for all of us, at least with respect to the General Motors case. It presents a common but an unfortunate thorny scenario, I'd say, is how is it that we analyze whether or not an employer lawfully may suspend, discipline, fire an employee who is engaging in conduct that may have connection to or be protected under the National Labor Relations Act, but does it in a profane or abusive manner. And so, for instance, employee Charles Robinson in this case was disciplined 3 times for 3 different incidents. In the first, he said to a manager during a discussion about having to work overtime during cross-training, quote, "I don't give a F about your cross-training. We're not going to do any effing cross-training if you're going to be acting that way." And the manager could, quote, "shove it up his effing A." In the second incident, during a committee meeting over subcontracting of work, Robinson was informed he was speaking too loudly. Robinson then lowered his voice and in a mocking manner told the manager, "Yes, master, you're Master Anthony. Is that what you want me to do, Master Anthony? You want me to be a good black man?" And then in the third instance, which was involving a manpower meeting, again, something that's clearly protected, concerted normally because of the content of it, Robinson repeatedly asked the same question. And at one point, a manager told him, "Look, let's move on." At that point, Robinson said to the person, "I'm going to mess you up." The manager asked if that was a threat. Robinson replied the manager could take it how he wanted. But then Robinson didn't stop there. He turned on the music on his phone, and very loudly, and it contained profane, racially charged, and sexually offensive lyric. So in each instance, there was a series of discipline that were administered. And the question before the board is whether any or all of the incidents were properly disciplined, or did the employee's protected activity remain protected, such as the employer was unlawful in its discipline. The administrative law judge, applying pre-existing board laws, said the first instance, the employee's conduct was protected, and so the discipline was unlawful. But on the second and third, found that the employee's conduct crossed the lines and went too far. On appeal from the ALJ's decision, the board jettisoned its prior approach, which really, it was confusing because the board had looked at the context of the event, i.e. did it happen in a work setting? Was it on a Facebook communication? Was it on a picket line? The board also had looked at a lot of scenarios like, was the communication to a coworker? Was the communication to a manager? Was the communication to a customer? Or what were the context of the events? And based upon those, had a variety of different tests. What the board found, at least a majority thought, that its prior methods had been not given proper consideration to the employer's right to maintain order and respect, as well as other federal laws such as Title VII that prohibits discrimination and harassment, and also that because of the varying standards, there have been a lot of inconsistent application. And so what the board said, we're going to do in these cases involving an employee's ugly conduct that's in conjunction with protected conduct, is apply what's known as a right line analysis. Right line is a case that had been decided by the board in 1980 that basically dealt with what is the method by which we're going to analyze whether an employee's conduct is an employee is being disciplined illegally for protected conduct. So applying right line, the board said that under right line, the general counsel, which is the party that has to prove the claim, has to show the employee engaged in protected activity. Number two, that they have to show that the employer knew about the employee's protected activity. And three, that there is some level of animus, i.e. the employer disliked the protected activity and there's a causation. There's enough evidence to suggest that the employer's bad view of the employee's conduct, because it was protected, led to the disciplinary action. And if the employee establishes that, or the general counsel, I should say, that shifts the burden. The employee then wins unless the employer bears the burden to prove that it would have engaged in the same conduct anyway. In other words, if we always fire employees who do the following 5 things, who show up drunk, the fact that the person also communicated a protected activity is not going to absolve that employee because there was protected conduct. And so, you know, if we look at it, what we're really seeing in this area is some development, and I think, you know, Peter's, I think, going to touch on this as well, the idea that the board is giving employers a little more latitude towards how they're applying rule and administering discipline. But I thought I'd close with the quote from board chairman John Ring in a majority. He says, "This is a long overdue change in the NLRB's approach to profanity-laced tirades and other abusive conduct in the workplace. For too long, the board has protected employees who engage in obscene, racist, and sexually harassing speech not tolerated in almost any workplace today. Our decision in General Motors ends this unwarranted protection, eliminates the conflict between the NLRA and anti-discrimination laws, and acknowledges that the expectations for employee conduct in the workplace have changed." So with that, I will pass it on to my colleagues who can take us from here.
Thank you very much, Ken. This is Peter Orr. I am, as Marty mentioned, the Regional Director of the Chicago office. I apologize. I'm going to be looking over to my side because I have another screen there where I have my notes. So if I'm not looking directly at the camera, like in some debates where you're supposed to do this, I apologize. So welcome, everyone. And also my thanks to Susan and Marty and all my colleagues who are here and the students. I'm not going to go really deep into my discussion. I just want to add a little additional points to what Ken just talked about in the GM case, which is a significant case in the way the agency is analyzing adverse actions allegedly based on union or protected considered activities. And the difference is this, the reason why it's so significant is this. Traditionally, the National Labor Relations Board has had 2 types of analyses. One for mixed motive cases being where the employer or whoever the charged party has claimed that there are more than one reason why the adverse action took place. You know, union organizing, protected considered activity, but there's also, you know, some type of employment action because of tardiness, work conduct, or something else, which is, so you have a dual reason potentially of why the adverse action took place, which is traditionally right line applied, as Ken spoke about the different factors. The other analysis dealt with single motive cases. Single motive cases are where the individual, there's no question, the individual was fired or terminated because of their protected concerted activity. The question then becomes, was there something that the individual did to lose that protected activity? You know, as Ken points out in the GM case, make some derogatory statements, some threatening matter, some type of misconduct that individual lost that protection. And those are two separated analyses. What GM did was, he said, forget about the single motive analysis. We're going to put everything as a mixed motive analysis. And it's really nuanced, but it's significant. And the significance is, in the mixed motive cases, as Ken points out, one of the elements in order to even get it to the point where you have a prima facie is to establish, the general counsel has to establish there's animus. There's animus that's related to the adverse action. Taking a step back, prior to the GM decision that issued, the board also issued a decision called Siegfried. And if you're like me, I had a hard time pronouncing it because it doesn't look like Siegfried, but it's pronounced Siegfried. And that case, it could be found at 368 NLRB number 120. 368 NLRB number 120 that issued November 2019. The significance of Siegfried is this. It dealt with the animus issue under right line, stating that essentially the animus requirement under right line is the nexus, the causal relationship that's required in a right line analysis. That it is but for type of evidence that you need to establish in order to get to that prima facie. So you take that, you put it into the right line, which now you put into single motive cases. To get to even a prima facie matter, you have to establish that the individual adverse action to have been found unlawful, the employer committed some type of actions to establish nexus, to show animus for that particularized action of the adverse action. In a single motive case, that's really difficult to show, because the reason it's a single motive case is because the individual's adverse action was caused by the protected concerted activity. So we'll see how that develops. I know the general counsel in DC with Division of Vice have been looking at the application of General Motors in single motive cases, and what type of misconduct apply in General Motor cases. So we'll see how that goes. But it is a significant decision. And I should also point out, as Ken did, the political appointees in the NLRB also consist of the general counsel, who is appointed by the president and confirmed by the Senate, serves for a 4-year term. And as you can imagine, it is of the party of the president. So, and the importance of the general counsel of the NLRB is that the general counsel has the unreviewable discretion to whether to find merit in an unfair labor practice case. So it may not even ever make it up to the NLRB board members if the general counsel feels that that case does not have merit, and can then issue guidances, and I'll talk about just in a second, about how the regional directors like myself would have to apply current labor law and what his understanding and theory under the current labor law. So, I mean, there's even a stopgap before it gets to the board. It is the general counsel, okay? Real briefly, as Susan pointed out, I posted on the chat room a General Counsel memo 20-14, and that talks about, the significance of what's going on currently with the pandemic. How are things that are happening with COVID-19? How does that have an impact on the traditional protections under the National Labor Relations Act? And the cases that are in the memo aren't really that unusual in the significance of how past protected concerted activity cases are applied. You'll see, for an example, I'm gonna scroll up real quickly. You'll see in one of the cases that deals with employees asking the employer to have a say in, how to approach what's going on with the with COVID. How to provide counseling, how to do social distancing. This is a counseling center, and the employees, no question, ask in a concerted manner about being involved in that. Again, in the NLRB and NLRA, there's no requirement that if there's no union, and there's no union in that first case, for the employer to have to comply with the demands, but you can't retaliate because of the demands. And in that case, the employer retaliated against the employees for even bringing that issue up. And in fact, told that one lead employee, if you don't like it, essentially, you have to do this if you want a job, which the General Counsel found that to be a constructive discharge because the individual ended up resigning. Again, these are General Counsel's decision to issue complaint to further the prosecution. We don't know what's going to happen in front of the administrative law judge. We don't know how the board is going to rule on it if it eventually makes it to the board. So that's one of the cases that's in that memo. The other case in the memo is a Domino's Pizza case, and it's again another traditional type of protected concerted activity in the arena where employees at Domino's are concerned about how the social distancing, lack of masks at the store is taking place, and they want that to be enforced. So they bring it up to the manager, and the manager says, well, if you don't like it, you guys could take leave. So all the employees walk off. They were told they could take leave, so they take leave. And then they come back a couple days later, to return back to work. All but one of them were allowed to come back to work. That one individual ended up being the person who was clearly the leader of those issues. So again, it's not different. It's not different from what we would have normally seen outside of COVID, but it just highlights what's happening now, a health and safety concern being a part of the protected concerted activity. And the last one I'll talk about real briefly, again, you find it all in that memo, is the case where there's a union involved. It's the Jake 58 casino case. And that case, again, talks about there being a adverse action for union organizing that was successful. The employees voted in the union, and the employer then terminated their leader. And the General Counsel found that to be unlawful. And there's going to be further prosecution on that. The interesting thing, I think, to note about that particular case, however, is that there was an 8A5 allegation in that case, which is a failure to bargain allegation against the employer for the actual layoffs. And in that case, as has been in subsequent cases by the General Counsel, one actually came out of Chicago. It was, and the cases are actually listed in that memo. It was a Civitas case, 13 CA 258725, 13 CA 258725. Those dismissed advice cases are all public, which essentially the General Counsel held or believed that in this emergency situation because of the pandemic, the unilateral actions of the employer was not evidence of bad faith bargaining because of the exceptional circumstances. When the exceptional circumstances ends, that's still up for debate. Excuse me. But that, and as you know, many employers have had to, because of the situation economically, they have the laid off or furloughed employees. That action itself, without notifying bargaining with the employer, was not evidence of bad faith bargaining. So with that, I'm going to turn it over to Tamara, because she's going to talk about something that all of us have in mind for the last year, unfortunately. So go ahead, Tamara.
Thank you. I get to talk about police unions and brutality bystander issues, which I couldn't cover in 7 hours, let alone 7 minutes. So I'm going to focus today on attempting to dispel the myth that binding arbitration in collective bargaining agreements and police unions make it impossible to fire bad cops, which is the narrative you're hearing all over the country right now. Just really basically the history of arbitration in public sector. It's not just police that utilize arbitration to resolve conflicts in their contracts. It's also other public sector workers, firefighters, teachers, sanitation workers. And it varies from jurisdiction to jurisdiction, but generally speaking, when you, in binding arbitration, both sides pick the neutral arbitrator, which means he or she has to be fair and objective. Otherwise, you're not going to get work because one side's never going to pick you. They generally have no ties to any particular community or politics of any particular community, and they are experts in labor and employment. And again, generally their decisions are final and binding. There's a lot of data on the win-loss records of unions generally, and also specifically in the police union. Let's talk about what the data says generally. There's a lot of studies, and I don't have the sites with me today, but if you want these specific studies, send me an email, I'll get them to you. There was a Minnesota study across all industries, all unionized industries, private and public, and it covered 20 years on termination cases only. And the study found that in 52% of the time, terminations were upheld, the employer won. 20% of the time, the union won, so the termination was completely overturned. And in 28% of the time, there were split decisions. So in other words, the termination may have been overturned, but the employee still was disciplined and with an unpaid suspension of some length, 30 days, 60 days, 100 days, 5 days, whatever. So how does that general win-loss rate compare to police unions? Well, it exactly correlates. So there's a lot of studies here too, but I'll point to a specific study done by a law student, and it appeared in an ABA journal article that studied police termination arbitrations only and found almost exactly the same win-loss rate as any other industry. Terminations were upheld 53% of the time. The union won completely, overturned the termination 23% of the time. And there were split decisions where the decision to discipline was sustained, but the discipline was reduced, was about 24% of the time. So generally, in all industries, including police, over 50% of the time, the employer wins termination cases, around 20% the union wins, around 20% split decisions. So contrary to popular belief, arbitrators are not biased in police termination cases, and police unions aren't so powerful that they're winning all these cases any more than any other industry. So, and on top of that, you have to take into account that only a small fraction of termination cases actually go to arbitration. I've been representing police officers in some way, shape, or form for 25 years, and I will tell you that I've signed more resignation agreements than I have taken termination cases to arbitration. And I think my colleagues in this niche would say the same thing. So, and what happens in those cases where we do win, why do we win? Well, frankly, some sort of police department error. There was an inadequate investigation. There was not sufficient evidence of misconduct to sustain the allegations. The officer's procedural rights were violated, the department didn't consider mitigating factors. So for example, an officer who has a 25-year history with no discipline was not taken into account. So the question is, why are police unions and arbitrators being blamed for so-called bad apples remaining on the job? And I would have to say, frankly, it's politically more expedient to blame us than to admit that perhaps your department has a little bit of dysfunction. And I'll give you an example. This was a high profile, and it's not just data. These are real life examples that are all over, that are happening in the paper every day. I don't know if you recall the tragic, horrible shooting at the school in Broward County some years ago, where so many students were tragically killed. And there was a deputy that was accused of basically cowardice, that he allegedly hid rather than go into the school and take action, which horrifies any officer I've talked to, and personally myself as well. Well, the deputy was fired, and an arbitrator gave him his job back. Do you know why? Because the police chief missed a statutory deadline for filing the charges. Very basic step he could have taken, should have taken. Do you think he admitted to the public that he screwed up? No, he blamed it on the unions. He blamed it on the arbitrators. Very simple example of how a very basic procedural protection was missed. The department screwed up and now is trying to shift the blame to the unions and the arbitrator. So what are this anti-police union rhetoric? What are they looking for? Well, first, some people are arguing for unfettered discretion among chiefs and sheriffs to fire and discipline as they see fit. And I don't think I have to give you examples to convince you that unfettered discretion to fire and discipline anybody by anybody is not a good practice. They're also arguing that only discipline should only be reviewed by police boards or merit boards. Well, those tend to be inherently unfair. That's why we started arbitrating discipline in the first place. They're pretty much unilaterally chosen by the mayor or the leader of a jurisdiction. The board members have political allegiances to certain people, may have lunch with the chief of police, and they frankly aren't necessarily experts in employment law. And their decisions tend to be, in some cases, rubber stamps of the chiefs or the sheriffs. So that is sort of what caused this whole industry to go towards arbitration in the first place. I'll give you another example of that. And this is a real life example in my own life, where I represent, I won't say the jurisdiction, I represent officers in a jurisdiction in the Chicago metropolitan area. I've been there for 15 to 20 years, negotiating contracts, handling discipline, whatnot. It's a very big department, about 200 officers. And all the years I've been there, there's only been one termination case that went to hearing. There's been resignations and whatnot. And I was at the negotiation table yesterday, and this officer was terminated. They won. And the city attorney said, well, because we think you really came close to winning that arbitration, we want to propose that all discipline that is serious goes to the police board, because we almost won an arbitration. So, and it boggles my mind, because obviously something's working out there. They won that case, they did it right. The cases that were close to termination ended up being resignations, but they're still kind of buying into this whole thought that arbitrators are for some reason reticent to fire police officers, and it's simply not the case. Anyway, so I can go on and on about this for hours, but I think I just want to leave it with you all with a final thought. First, arbitration is working very well and fairly. Second of all, I always say no one hates a bad cop more than a good cop. When bad cops are bad apples, I'll say, end up lingering in departments, in my experience, what I've seen, it's because there's been a failure in one of four areas. a bad hiring decision, bad supervision of the officer, bad evaluation performance enhancement practices, and improper investigations, disciplinary action. I can't tell you how many times I have a 25-year officer who they want to fire, and I say, well, what's the problem? And they say, well, he's been a bad apple his whole career, but there's not a piece of paper in his file that says he's been disciplined. So those are the 4 areas: training, hiring, supervising, discipline. That those failures in those areas is, in my humble opinion, what leads to bad apples not being weeded out sooner. And the union has no role in any of those things. Marty, I'm going to throw a kudos out to Marty, did a great op-ed on this idea. Perhaps rather than demonize unions, employers might want to consider getting us more involved in the conversation about how officers are trained, how officers are supervised, who should be hired, who shouldn't. And I think the discussion about fixing problems in policing would be a lot more productive. So that's all I have.
Thank you so much to all 3 of you. We've kind of fallen a couple of minutes behind schedule, but that's important. So Susan, I'm going to ask to make sure we do have 30 minutes for the first round of networking breakouts. So kind of let's try to adjust the schedule to the extent we need to. So our last panel is going to focus on diversity and inclusion issues, which have been very important in the workplace for quite some time, and have certainly received much greater public prominence in recent months. Mike Kramer, again, I'm introducing in alphabetical order. Mike Kramer has practiced employment law for his entire career, including the last 15 years with Ogletree Deacons. He has served on the firm's Diversity and Inclusion Steering Committee, and a large part of his practice focuses on diversity and inclusion issues, doing lots of training on bias, discrimination, inclusive leadership, and anti-harassment. Nigel Tillman is a partner with Proskauer, where he leads the employment law practice in the firm's Chicago office. He focuses on class and single action litigation in a variety of employment matters, and Sherry Boyles is managing partner of Jacob Burns, Arlov, and Hernandez, a union side firm where she practices traditional labor law, ERISA, and employment law. Her first job out of law school is with the NLRB, but since then she has spent her entire 30-year career representing unions and working people. I pass to them.
All right, thank you, Marty. Good morning, everybody. And really great presentation so far. I thought we'd start briefly with sort of the concepts of diversity and inclusion. These have been around for a long time, but have really been in the forefront this year, frankly, for many of our clients and, in our practices. Diversity basically means there are people from a variety of backgrounds in your workplace. Inclusion means that those people are being included. And the other term that we're now using when we talk about diversity and inclusion is equity. So one of my Black colleagues who I do a lot of training with shorthands it this way. Diversity is you're there and people of different backgrounds are there. Inclusion means you're coming to the cool office party, and equity means you get to pick the music for the party. It's a very rough shorthand, but and I didn't make it up, but it's kind of what the concepts are. We're going to kind of bounce back and forth between Nigel and Sherry and myself this morning, and we thought we'd focus on two things: how diversity and inclusion fits into our practices as labor and employment attorneys, and then sort of where our respective law firms are on diversity and inclusion issues. And we have three, very different law firms among the three of us. So if we can, let's start with Nigel Tillman. Nigel, can you tell us a little bit about how diversity and inclusion has been and is part of your practice as a management side labor and employment attorney?
Hi, I'm sorry. Can you guys hear me?
Yes.
Great. Thanks. Good morning, everyone. Excellent presentation so far. Thanks for having me. One of the things I have to say is at the onset is one of the reasons I love this area of practice, labor and employment, is because it's really so tied to our society. And it's so tied to promoting or addressing the notion of fundamental fairness with respect to, you know, race, sex, gender, sexual orientation, et cetera, in the workplace. And, you know, I tell anyone who would listen that are in law school that's considering different practice areas to really consider it, because you certainly can make an impact on society doing this type of work. And as Michael said, given social and what I call the fundamental fairness movements across the country that we've seen in the last year or so, it is having a profound impact on the companies, and it is forcing, you know, companies to take a long, hard look. Not only companies, I should say, every institution. I'm on the board of a museum. We're looking at that. You know, I have clients that are that are colleges and universities. They're looking at it. It's really making all of our institutions focus on taking a hard look at their policies and practice to simply understand whether or not they are fundamentally fair and whether or not they're giving everyone a fair opportunity to move forward in the organization and to contribute to the organization. So that said, in order to really help our clients understand that, they turn to us, they turn to employment lawyers, because, you know, in general, you know, there are no laws that govern diversity and inclusion. There are no laws that require diversity and inclusion outside some exceptions in the government agencies. But in the private sector, there are no laws that require it, and there are no laws that prohibit it. Although I will put an asterisk to that and said, I'm sure you've all heard of the recent executive order that the president put forward that purports to, or that will suggest he wants to prohibit federal government agencies and federal contractors from providing what the order describes as divisive and un-American anti-racism training. You know, there are a lot of challenges to that, and so we don't know sort of where that's going to go and what that's going to lead to, but that type of training is of course a part of diversity and inclusion. And what we have done, what our clients who are government contractors have in fact turned to us, and we have been advising them at this early stage on sort of, you know, what it means for them, what they can or cannot do, and whether or not as a fundamental process is whether or not they can actually move forward with the trainings that they have had planned already. So, you know, that's part of what we do. We will help our clients sort of analyze these types of orders or rules to figure out sort of what they can do in order to help them achieve their goals. The other things we do in this practice is to help them achieve their goals, and primarily the big focus is recruiting and hiring, with a focus on increasing diversity. And we look at that and we try to advise our clients about that with the goal of not running afoul of Title VII and any other state and local statutes that prohibit discrimination in hiring. Because of course, you know, arguments can be made that if you're focused on diversity and inclusion in your hiring, that you may be also discriminating against people who do not fit into the classifications that you're looking to diversify your organization. So that is a big area that we look at. You know, some clients are more aggressive than others. Some are more conservative than others. You know, I'll say some of my clients are very aggressive, and they have been aggressive in the past, but especially in the last year, my clients are getting much more aggressive in terms of what they want to do or what they feel they have to do in order to rectify the lack of diversity in their organizations. And so we're really moving that forward. And I think employment lawyers are at the forefront of helping our clients achieve those goals. So some of the things we do is we help them develop questions, make sure the questions don't run afoul of any particular statutes or laws or case law. You know, we talk to them about recruiting methods, where they can go, how far they can go in terms of trying to identify qualified, diverse candidates to bring into their applicant pipeline. We also advise our clients on focusing and increasing diversity in pipeline initiatives, meaning sort of where they'll go to attract the diverse colleagues that they're looking to hire or people they're looking to hire, and also programs within the organization that are geared specifically to increase diversity in leadership within the companies. So looking at programs that our clients can utilize to help give diverse young associates, for example, at law firms, or younger folks who are just coming into the business, putting them in opportunities where they'll get good experiences and developmental experiences so that they can, will remain within the company and continue within the company towards promotion into the senior level executives. We also have clients that look at it from the other end. So our clients are coming to us and asking us, what can they do to attract a more diverse board? When I say board, I mean board of directors. And also, how do they attract more diverse leadership at the C-suite level? So, in short, as I said, we really get to make a significant impact on our society because everyone works, and everyone works in companies for the most part. And if we can help guide our clients towards a more fundamental fairness and diverse organization that are inclusive, I think we really have an opportunity to change the world.
Thanks, Nigel. Marty and Susan, what is our hard stop for this third panel here? Can't hear you, Marty.
I needed to unmute. So we were at, let me get it. So we were at 10:40, but feel free to go a few minutes beyond that since we're at 10:40 right now.
Sure.
Because we got a little slack. We'll catch up. We'll have that first networking session at 35 minutes rather than 40, and we'll be fine.
Okay, great. So Sherry, as somebody in a firm that represents unions and employees, tell us about how diversity and inclusion works both in your practice and in your law firm.
Sure. Thank you for putting this together, everyone. It's great to see so many people participating. I would echo everything that Nigel said about what we're trying to do and what this area of law allows you to do as a practicing attorney. I think it's amazing. From a union lawyer's perspective, maybe mine's a little different because I counsel clients on recognizing the racism and the sexism and all the isms that go along in the workplace so that they can represent their members both in a grievance procedure and discipline and or in negotiating their contracts. But on the other hand, I also represent unions as institutional employers. So I do a lot of what Nigel has talked about. We talk about trying to get more diverse leadership in the unions to reflect their members, because the members they come to us as they are, and that's great because we have a wide variety of diverse people that are our working folks. So I get to do it from both perspectives, and that affords me the opportunity to see it from those two different perspectives. From a law firm idea, we're a small 9-person firm. We're fairly diverse. We're not as diverse as we'd like to be. We're always trying to do better because we want to reflect our clients and we want to understand what's going on out there. When the George Floyd murder occurred, as a firm, we collectively sat down and we had some, frank conversations about, are we doing enough? We profess to be part of this movement, and the labor movement has always stood for solidarity and equality, but it's also been a movement that's had discrimination within it. So how do we help to change that? And one of the things we did is we sat down and we wrote out a statement on what we thought we should be doing and how we should look at this. And not as, that's where it ends, but that's where it starts. And we tried to give some thought to the things that we want to do as a firm. And maybe I'll give Susan the full statement and she can post it later so you all can see it. But we came to, after discussing things, 3 things we really wanted to do, and we have already started to do. The first is to donate our financial resources and time to organizations that are dedicated to erasing racism and racial inequality and providing services to communities in need. And that's separate and apart from doing, our work just with our labor organizations. We also want to, and we agreed to donate legal resources to our clients to provide them the training to help them live by the principles we've all said exist in the labor movement. And then just as a core tenet of our practice, to redouble our efforts to help people who are denied opportunities in the workplace and beyond, just because of their race, color, sexual orientation, religion, any of the reasons we all know people face discrimination every day. The way we look at it, working is hard enough just to show up and do it. And to have to deal with these other things, we're all in this together, and we have to try and help make some significant changes, in the labor movement, in the workplace, in law firms. And I'll end with that, Michael.
Great, and I'll add a few thoughts before we adjourn for the breakout sessions. As I said, diversity and inclusion for labor and employment lawyers has been at the forefront for years, and we like that it has now become a bigger priority for businesses out there. A couple of things to note, practice-wise, I've been doing training on anti-harassment and anti-discrimination for many years, but in recent years, clients have opened up a little bit more to the idea of doing a deeper dive on things like bias, including explicit bias and implicit or unconscious bias. And we feel like those trainings go a lot deeper and really resonate with people and aid understanding. We've also been doing more training on the concept of allyship. That many people in businesses and law firms have privileges of various sorts. So I've not only got my white privilege, I've got my senior partner privilege. I've got my male privilege, and I can exercise those to be an ally for people that don't share the same privileges. But obviously it's not just white males who are senior partners who have privileges. There are lots of different ways that people can exercise their own advantages to assist and be an ally for people who don't have all the same set of privileges. The other thing that I would note is, as a law firm, and Nigel's firm is a big general practice firm that has a great emphasis on labor and employment, and they're really well known in that area. Sherry, as you heard, is a firm that represents unions. Ours is a management-focused labor and employment firm, and we're spread across 53 offices around the U.S. and Europe and Mexico and Canada. So it's a little bit different. But I think as a firm, we've done some things that, we're pretty happy with, but we need to keep improving. We have business resource groups. So we have a Black attorney resource group, an Asian attorney resource group, Latinx, LGBTQ, family, women. So all these different groups, and many people are members of more than one, exist so that people can have safe spaces and colleagues and allies to talk about these issues and try to continuously improve things in our own law firm. We also have had for 10 years at least now, a full-time staff just focused on diversity, equity, and inclusion for our law firm. And we've tied it together with professional development. A lot of law firms are pretty good at recruiting a diverse array of talent, but they have found it harder to develop and retain those people until they become senior partners. So we tie together professional development with diversity and inclusion and equity. And hopefully that helps too. And then lastly, in the wake of George Floyd, our firm started what we call OD Act, which is our Equal Justice Task Force. And it's got various subcommittees, one on criminal justice, a couple inward facing, trying to, again, improve our own diversity, inclusion, and equity efforts within our firm. And then we have a voter education subcommittee, which I co-chair, and we've got dozens and dozens of our attorneys working the Lawyers Committee for Civil Rights under Law's National Voter Hotline and getting pro bono credit for it. So there are a lot of things that we do in our practice and that lawyers and law firms in general can do within their firms to promote equity, diversity, and inclusion. And hopefully those are things that you all students will be thinking about as you venture out into your practice in the coming years. So thank you all very much for the opportunity. I don't know if Nigel or Sherry want to add a final thought before we go to the breakouts.
I think we've covered it.
Yeah, I do too. Thanks for having us.
Thanks, everyone.
Well, thank you. That was just fantastic. And thanks to all of our morning panelists. If I can just grab a personal privilege for 60 seconds here. Our law school had a reception back in May for our students of color who were graduating. And one of our alumni speakers at that reception, a Muslim woman who has been very successful in the legal field, suggested to everybody, don't just seek out a mentor, seek out a champion. And I would share those words to all of our students who are here. Yeah, you want to find mentors, but you want to find champions, people who will actually not only mentor you, but champion you in other environments. We're going to break. Susan's going to magically transport you to the breakout rooms. Susan, let's run the breakout session to 11:25 rather than 11:20, and we'll pick up that 5 minutes somewhere else in the program. So we'll see you all back here at 11 in the main room at 11:25.
Hopefully it's working, Marty.
Let's see. Marty, you need to unmute there.
Yeah, if you have the pre-assignment all set up, I think you can just go to breakout and
So if people that are not assigned, like Bert, Diane, hold on a second. Diane, for whatever reason, it's not taking. Jerry is off. So hold on just a second. I'm going to try to get the Bert and Howard, you are basically off the hook. Joel, you're not until this afternoon. Jeremy Glenn, you're not until this afternoon. Catherine Hartrick, I'm going to send you to yours now. Marty, you are not assigned.
right.
Ken, you're in the afternoon. I have
Susan,
you.
I need to do it this morning.
Joel, I can't switch it now. I had the afternoon session for you. If you could bear with me for just a second, I'm going to try to get everybody to where they didn't go because it didn't put them someplace. For Jerry Golden, I sent you an email. You're off the hook.
Susan, you want me to switch with Joel?
All the people that I assigned to him wanted union, like were interested in union,
okay.
so that's
Sorry,
why I had
sorry,
done it.
Joel. I could do a good job of converting them.
I mean, I may have to do it, and you can just apologize. So
I would object to your working as a union lawyer in disguise.
I don't know why I cannot find. Hold on a second.
I think there are like 2 students who are still in the main room.
Yeah.
Orlando Alvarado and Tiffany Sanders.
Yeah, and I don't know where. Hold on just a second. I'm trying.
Susan, I'm getting off. I'll see you at 11:25.
Okay, thank you. I'm just going going to assign. Yeah.
It's kind of a mid-sized firm called Hughes Sokol. And I did some management side work, but it was mostly plaintiff side. So it was probably like 75 plaintiff, 25% me.
Very end, Joel, so that would be at 2:45.
Very well, thank you.
Can you do that?
I'll try.
Great, thank you so much.
Bye-bye.
Enjoy.
You too. It's a good meeting. Looks like a good meeting you organized.
We just have to roll with the punches of the technical glitches.
Right.
Susan, looks like, okay, Orlando just disappeared, so presumably he's in his breakout room too. So I think we're good.
Jerry Golden can, I sent you an email, Jerry, that said you were off the hook because only one person in your group showed up. So Jerry, there you are hiding. Yeah.
I'm here.
Yeah, I sent you an email that said, basically, you were off the hook.
I got it, Susan. Thank you.
Okay, I'm sorry.
No problem.
And Joel said he would make every effort to make it back by 2:45 for the afternoon breakout.
All right, and if he doesn't, then I will just, you know, I don't know what I'll do. I'll figure it out.
You might be able to just reassign the student. How many students does he have?
Like he had a lot because he was an afternoon. So I had 1, 2, 3, 4, 5. So we'll see. He had 5 students, all of who had been interested, had expressed interest in union side. So that's why I had jumped on him, because he's the only one for the afternoon besides John Roach, who is union practice. Oh, and Tim Hawks,
okay,
who has still not registered, by the way.
Oh, no.
So I've been waiting to hear from him. So let's see. My schedule last I was up and when a client, oh, guess what? Oh my God, it was in the email you responded to. Tim just responded and said, sorry, everything was really crazy this week. How do I register? And I was like, it's in the email if you scroll down.
Just resend it to him.
Yes.
I know it gets frustrating, but you know. We'll just razz him about being a problem child.
Exactly. At least he's registering. So let's see, Diane Smanson said she has nobody in her room. And that's number 17. Wow.
I just hope the no-shows weren't any of my students.
Well, I'll let you know. She had 5. They had all, one, Cervantes had canceled this morning. And then Coty, Deer, She, and Teweldy.
They don't sound familiar. Phew, big sigh of relief.
Yeah, so right now you're the only one that's not assigned. I am more than happy to assign you somewhere if you want to.
Unless you need me, I'm happy to just take this little break.
Yeah, so yeah, Ellen McLaughlin, nobody showed up in her room. So that was 3. No show. And no show on Diane.
Oh, it's disappointing, but unfortunately not unexpected. I'm going to run to the restroom. I'll be back in a couple minutes.
Okay. Tiffany Sanders said she wasn't going to be here because PM/only. I knew I wasn't losing my frickin' mind.
And it might help to ask them like how it works in house, you know?
Yeah.
Yeah. So what else, Jim?
You know what? I noticed that somebody else has joined the discussion with us.
Oh.
So yeah, I'm just gonna let her give her a chance to introduce herself and see if she has any questions too.
Oh, okay.
Yeah, this is Susan. I'm not exactly sure why Tiffany's not allowed to be joined in. Tiffany, are you there?
I'm here.
Okay.
Oh, hey.
Okay.
Yeah, I
I'm
don't
gonna
know
go.
if you can't see me. I messaged you, Mr. Behar.
Yeah, no, I saw your message, but I unfortunately, I didn't know how to let you in because I don't seem to have control over that.
Yeah, no, I automatically put people. It was pre-assigned. So I had moved you there, Tiffany. So anyway, well, I'll let you guys go since it's.
Oh, thank you.
Uh-huh.
Hi, Tiffany. I'm Jose.
So it looks like Jean is on.
Yep, I see Jeannie.
Hi, guys.
How are you?
Good morning. Hi, Susan. How are you?
I'm good, Jean. How are you?
Good, good. Hi, Marty.
Hi, Jeannie.
Marty,
Are you
are
still
you
in
New York
Minnesota?
still? Yeah. I know. I'm in Wisconsin, actually.
Oh.
And I'm at my sister's cabin.
Wow, nice.
Yeah. That's why I didn't sign up for the breakout sessions, because I just wasn't sure about my bandwidth, you know. I wanted to like reserve it for our session, you know. And Marty, are you in New York?
Mm-hmm.
Did you guys rent are you at your daughter's, or did you rent a little apartment or something?
We lucked out so amazingly. So, you know, our kids are both, our daughter and son-in-law are both NYU faculty.
Uh-huh.
So they rent their apartment in a building that NYU owns.
Oh, nice.
There's an emerita faculty member one floor up from them.
Oh,
Who
fabulous.
had gone back to her native Vancouver, British Columbia for the fall. She was just happy to sublet her apartment,
Oh,
which was
Marty,
sitting there
that's
vacant.
wonderful.
So our son-in-law's parents and Joyce and I jointly sublet the apartment.
Oh,
So it's great.
that's
We're just one
wonderful.
flight of stairs above them.
That is
And,
great. That's the best way to do it too, because you're not right on top of them, you know.
Exactly,
and you
yeah.
can- but you're close enough that you can offer support at any minute, you know.
Yeah, and otherwise, you know, we would not have been able to deal with the New York 14-day quarantine.
Right. Oh,
So,
right.
you know, we're able to quarantine. Well, Joyce has been here for over 2 weeks now, so she's free. She can wander the streets, but I'm still stuck in quarantine. So we're able to quarantine and still be with them. Whereas if we're staying in a hotel, we would not be able to leave the hotel.
Oh, that's wonderful.
So it's, yeah,
Wow,
I've been
but
able to
we have
work
to-
from the
I like the
sublet.
quarantine.
You know, it's a gorgeous sublet, huge 1-bedroom, beautiful views. It's amazing.
Nice.
Uh,
Nice.
And Catherine, our younger daughter.
And
we're
where
going
are you?
to-
Are you down by NYU?
Yeah, Washington Square.
Oh, Washington Square. Yeah, nice.
Yeah.
Nice. Oh, is New York deserted on the streets though? Oh, you haven't been out, right?
I haven't been out, but LaGuardia Airport was totally deserted.
Wow.
Midway Airport was a madhouse. You wouldn't think there was a pandemic, but LaGuardia was totally deserted.
Wow.
There were only 42 people on my flight from Midway to LaGuardia.
Wow. Interesting. Interesting.
Yeah.
So how, I keep
how
wanting to
was-
go back to Chicago, but I'm gonna have to quarantine there because Minnesota and Wisconsin are bad
Right,
places.
yeah, for
Yeah.
the city has the quarantine rule.
Yep. Yep.
Yeah, or you're welcome to crash at our place in Oak Park, and then you're free to wander the streets of Oak Park since we don't have a quarantine.
Oh, I didn't know that actually.
Yeah, the quarantine is only the city,
Wow, I didn't realize that.
but in New York, it's statewide.
Right. I thought it was statewide in Illinois.
Mm-mm.
Wow.
So
So
Marty,
hard
when
to
you
keep
were
up
in the cab riding from LaGuardia to your apartment, when you were in the city, was it people outside on the streets? Was it normal? Was it quiet or kind of normal, but not really?
So the taxi took the Triborough Bridge and then down the FDR Drive. So I didn't really get to see many streets. But you know, the FDR Drive from, except for between, I'd say around 75th to around 42nd Street, there it was stop and go. But other than that, we were just cruising.
Yeah.
And I've never, you know, midday on the FDR Drive, I've never cruised.
One thing I did hear actually is that more people are driving into New York and Chicago rather than taking public transportation or cabs. So there's more private cars for the amount, but still there are so many fewer people.
Well, our son-in-law's parents, they live in the Philadelphia area. And in the past, when they come up to visit, they just hop on Amtrak, but they've been driving.
Yeah.
Well, yeah, nobody wants to be on the train with other people around, I guess. So, you know.
I worry about the trains. I worry about mass transit. Oh, God.
I know. So I, you know, Marty knows this, but I also do a little side gig for the College of Workers' Compensation Lawyers, which is basically patterned along our college here. And they do their induction dinner for new members is held during the midwinter meeting of the ABA's Labor and Employment Law, either the Work Comp Committee or the TIPS Work Comp Committee. So it goes kind of back and forth. So they canceled March's one in New Orleans and rebooked it for March 2021. And I just found out yesterday that that's going to be canceled now too. So
yeah. We're talking about
the
National Academy of Arbitrators in June in California. Who knows? You know.
Well, and it makes me nervous because we're getting ready to sign the contract with the Beverly Hilton to redo what would have been the induction dinner this year, next year. And, you know, anyway, I don't even know what to say, you know. So whether or not
that would be November, right?
Yeah, but you know, what if, you know, if we book it based on 400 people,
right? And people may not be traveling even if they've gotten the vaccine.
Exactly.
Who knows?
Exactly.
Or how to negotiate it. It's got to be flexible in negotiating those terms under these circumstances.
Well, we've been going back and forth with them, and we just actually, the section has formally signed their contract. So I asked the Beverly Hilton contact, like, can we have the same force majeure, you know, impossibility clause as they got? Ours are not, you know, ours are done together. And there's no way we can do ours if they ultimately can theirs. And if they have a better deal, then that's going to cost us a lot of money. So anyway, they just sent something back the other day that said, here's what their language says. Are you okay with that? So anyway, so I hope, you know, it's just all so surreal. So
it is. It is. We've had the force majeure of all times, huh?
Yeah, exactly. So learning more about that clause in all the years that I've been signing contracts.
Have you ever had to? We've had to do it a couple times with the academy.
Yeah,
at least once because of storms, you know, because of hurricanes in
the Miami meeting.
Miami. Yeah, we canceled Miami once, but who would have ever foreseen this?
I know. You know, and then, you know, it's so funny is because most of the standard force majeure clause are like, you know, acts of God and war. And it's like, well, what about a pandemic?
Yeah.
You know? So anyway, so it's just been interesting trying to, like I said, I've learned more about it than.
Yeah.
I mean, I always read through them.
Looking forward to this one on civility.
Is this the
Susan,
street?
that looks like a good session. The session on civility that we've got going on, it's on Thursday of this week, I think.
With the judges in DC. Yeah. So they're real hyped up about that one. So.
Yeah. Well, I'm seeing some of it in my practice too, I think, you know.
Well, you know, it's funny. I said to them, because they've planned this one along, like during the summertime, they planned it. Not that we weren't in a different space in the summer as well, but, you know, I think it was all done with the idea that we might be on our way back into court, but you know, I said, do you want to change anything, like the focus on virtual? Who the hell's going back into a courtroom anytime? And they're like, no, that we've already talked with the judges and this is what they want. Like, okay, well, I guess it'll be relevant in
It's always relevant too. It's always relevant.
Susan,
that's what they said.
Susan, am I in the right place?
You're in the right place for now, Tim.
Welcome, Tim.
So, yeah, you are on this afternoon starting at 1:20 is that panel, and then the breakout session will be after that. So you are more than welcome to sit right now. They're in breakout sessions, and we'll call them all back in about 5 minutes.
Okay, good.
Oh,
So
now there's 4 unassigned participants.
oh, that's good. I'll get off and then come back.
Oh, no, you're fine. Yeah, okay. So I was gonna say, if you wanna come back on, just make sure you use the same link that you just used to join us.
Got it. Thank you.
Okay, thank you.
See you later.
Okay. So,
I sent this bio of myself this morning.
What was that?
I was just saying to Marty, I sent you a little bio of myself this morning, Marty.
I
don't
got
know if you've been on your email.
Okay.
Although I figured you could have done it anyway.
Right. All right, so I'm gonna, Marty, you tell me when, and I can broadcast that the meeting rooms are gonna shut down. It's 11:19, I guess.
Yeah, let's just give him 5 more minutes. It was originally going up to 11:20, but let's just, since we went 10 minutes over with the first round, let's just give him 5 more minutes and then bring him back.
Okay.
We'll just cut their lunch break by 5 minutes.
Yeah, they can all turn their cameras off and eat anyway, so.
Yeah. Well, that's what we were going to tell them to do anyway.
Yeah,
right.
Yeah. Yeah.
As you noticed, I couldn't wait. I was too hungry.
Yeah. I know, I made sure I had something to eat before we got on here.
Yeah, I had to remember that to bring it to the office because it's not like I could run out to Subway and get a sandwich.
Yeah.
Of course, I forgot a drink, so.
Uh-oh.
That's why God invented water.
I know, but I have to have my,
something in it.
Yeah. No, not like that, like soda.
Oh, looks like someone has returned from a breakout room.
So Jordan May was with Pat Dede, and it was just the 2 of them. So are you guys done, Jordan?
We had a conversation, and he just said, there's about 5 minutes left before we start, and if I wanted to use the bathroom or get a drink, to just take a break. So.
Okay. All right. Did you find it helpful?
Really helpful. Yes.
Mm-hmm. Okay. Mm-hmm. He's a good guy. So. Okay. So Pat, I'm going to email him and say he's done.
Jeannie, what order are you guys speaking in?
We haven't spoken to each other. So I sort of thought you were moderating this actually, Marty, but I don't care. I mean, I can go first.
I'm just going to introduce you alphabetically. So Lisa,
okay.
Pat, and you. And
okay. I thought we would just kind of have a kind of a conversation.
Sure.
Would be the best way to do it. I mean, I'm going to talk mostly about just how the Zoom hearings are going and Zoom arbitration.
You're kind of fading in and out.
Thing. Am I? Oh, that is not good. This is why I was. All right, I'm going to turn my sound all the way up. Is that better?
Yeah, you kind of you just. It was like your internet connection was a little unstable there.
I'm a little worried about that, but I've got it on my phone, and I have my. Oh, okay. Just
sit
go
right
straight.
there and don't. So when the conversations
Okay.
are happening, I'm going to try to spotlight you all, Marty, but I'm not having that button that says you can spotlight more than one person at a time.
Okay.
So, so we can try and see how that goes. Right now I'm spotlighting on you, Marty. So when everybody comes back in, they're going to see your mug.
They've had their fill of that by now, I'm sure.
Right. So in any event, so some people are coming back. No, not really. I just sent the message out and just said 3 minutes. They'll give them 1 minute warning and then hopefully it'll close the rooms. Then I got to figure out how to get the next setup. So I'm not sweating as much as I was about a half an hour ago. So, oh my God. So in any event. Okay. So Pat needs to come, oh, he'll, okay.
Just gonna refill my water glass. Be right back.
Okay. Was okay? Was it okay? Okay. All right, people are coming back in. Time is up for 30 minutes. Okay, I am going to close the breakout rooms now.
Very good.
And turn my mic off.
Okay.
Hi, Jeannie.
Hey, Sherry.
Okay, I think everybody's back. I hope our little breakout networking or speed dating sessions went well. We're going to have a second round of panels here. And we're switching gears. So we're now focusing on the pandemic, right? And first, we're going to talk about how the pandemic has affected the practice of labor and employment law. And then secondly, we'll be talking about the labor and employment law issues raised by the pandemic. So our first session on how the pandemic is affecting the practice of labor and employment law. It is affecting that just like it's affected this gathering and has affected, you know, your classes and how they're being conducted and the like. So I'm going to introduce our three speakers again in alphabetical order. Lisa Calloway has been practicing management side labor and employment law, focused on labor relations, discrimination defense, and counseling for over 30 years. She currently is a partner in the law firm Engler, Calloway, Baston, and Schrager, which is a 100% female-owned law firm. Pat Dede is a graduate of Loyola Law School. He's a former federal prosecutor with over 30 years in private practice. Since 1996, he has headed the litigation practice at Hogan, Marin, Babo, and Rose in Chicago, where his focus is labor and employment law, commercial litigation, and white-collar criminal defense. And Jean Bonhoff is a full-time arbitrator in Chicago. She's been doing that for over 25 years. She has served on numerous so-called permanent panels, but we all know they're never really permanent, in very diverse sectors, including steel, rubber, communications, hotels, airlines, state, local, and federal government, and get this, Major League Baseball. And in addition to being a college fellow, she is a member of the Board of Governors of the National Academy of Arbitrators. So I turn it over to our very distinguished panel.
Thank you, Marty. I'm just looking for my co-speakers here. I'm happy to jump in here just to in the order of alphabetical order, and you know, I would title this session I thought I've seen everything in 30 years of practicing in labor and employment law. So kind of fascinating. And I know everybody who is who's on the line today, and certainly who has been practicing, would say the same thing. Again, thank you for having me today. I think this is, unfortunately, it'd be great to do this live, but it's really, to be able to do it in this format at all is really great. So really enjoyed the breakout sessions. I think that's a great idea and a great way for students to have their one-on-one discussions. You know, I'll talk about a couple of things. You know, our panel is talking about the workplace during and after the pandemic, specifically issues and concerns. So I'm going to stay away from all the remote workplace stuff, because we certainly have others who are speaking about that. You know, I think the question everybody wants to know is, how long is this going to go on? We didn't know it was coming. Nobody expected it. I'm not going to get into the politics of all of that. But what we were able to do amazingly in this area, and I think as labor and employment lawyers, we do frequently have to flex and be, you know, our world changes fast, I guess. And issues, the thing that's so fascinating about this area is that, you know, you think you've seen it all and then something new comes up. So, you know, now we deal with issues, certainly in our virtual world, of somebody standing up on a Zoom call and they forgot to put their pants on, or, you know, walking past, I happen to represent some school districts, and, you know, kids are in e-learning, and mom walks by the back of the kid's computer, and, you know, if we're lucky, she's wrapped in a towel. I've had worse circumstances. So, you know, dealing with these issues in the workplace has been really challenging. You know, I think specifically some of the issues are, you know, how are we dealing with this? We have the FFCRA, the Families First Coronavirus Response Act, effective April 1st of this year, and this provides paid sick leave and partially paid FMLA leave, Family Medical Leave Act leave, for employees. I think one of the questions that comes up, this is set to expire December 31st. I'm going to go out on a limb here and say I don't think we're going to have a vaccine by then. And so I think one of the real questions here is, will this be extended beyond December 31st? I think this is not anything that's going to happen anytime soon. We've got some funding bills that, you know, that are stalled right now. But, you know, real question, because if we do go beyond December, if this legislation does lapse as it's currently supposed to do, what do we do about that? Are we providing any kind of a stopgap for employees? And of course, we're going into flu season, and we're likely to see more issues coming up. Requests for accommodation under the Americans with Disabilities Act in particular, but certainly some of our other anti-discrimination laws. I have seen requests for accommodation on the employer side that I never imagined I would have seen before. And dealing with, in the school context in particular, teachers who want to continue to work remotely, but even coming back into the employment, into work, and are we providing the PPE, and how are we making our workplaces safe? Diving into that same issue, mental health issues in the workplace. I think we are only seeing the beginning of that. And I think this is really going to be a burgeoning area in the future in terms of how has this pandemic, how has this affected employees in the workplace? And I think we're going to see issues of stress. We're going to see PTSD increasing. There's issues of trust, I think, really, and in the best of circumstances, oftentimes we see those issues between employees, between employers, and particularly between employers and unions. And I think, how are we going to deal with those trust issues moving forward? So I haven't even touched on potential litigation, when this is all over. Certainly, but I'd like to turn it over to one of my co-speakers at this point, because I know we've got a number of people to speak and a lot to say. So either Jean or Pat, do you want to jump in here?
Yeah, let me jump in, I think, because I was really focusing, and I think my topic, or at least my subtopic for this was, a saying that is apparently attributed to Erasmus, that, in the land of the blind, the one-eyed man is king. And that's how I feel, because before the pandemic, I had done, I think, one remote telephone deposition in my 35, 40 years of practice in the private sector. And since March, I've been engaged in expedited discovery that involves 6 all-day Zoom depositions, a 3-day evidentiary hearing in a federal court, all by Zoom or the federal equivalent. I had an oral argument in the appellate court of Illinois, all by Zoom, and I'm going to have a personnel board hearing next week, all by Zoom at the city of Chicago. So, I mean, to Lisa's point, it's not going to end anytime soon, at least if you're worried about graduating into some area that this is all going to go away. I think that at least everybody's prediction on the litigation side is that expect to be working this way remotely till this time next year at least. So I think that's the reality. And I also think, we blew through a number of, road signs, or how you want to talk it, speed limit signs here. The resistance before the pandemic to do anything remotely in litigation was pretty high. People always felt that, you had to be in the same location, you had to be able to see things. And I think that may be true in some unique cases, but people have found a way to function, at least in the, in arbitrations and hearings and litigations. I'm not really convinced in labor negotiations it's going to be the same, because I think there's, forcing people to sit down together, I think, is part of the dynamic. But in terms of doing, 75% of the things we normally do in litigation remotely, I think is kind of going to be the future, because I think it also, as crazy as it sounds, there are certain benefits to doing things remotely, at least in my practice. Unions become more and more, diverse in terms of where they are, and so that it becomes easier for me to represent a client downstate Illinois if I don't have to actually physically go there and drive there, and I can do a hearing remotely. I can do, multiple things even in Chicago on the same day that I couldn't do before, because I had to be in Waukegan for a hearing in the morning and a deposition down in, out in Downers Grove on the afternoon. So, but I think it's also presented a challenge for the actual practice of law. And I think, it's forced people to be more organized. Yet also you have to prepare for the worst, and don't expect the technology to work, I think has been my experience. We were in federal court and, we had the judge and a bunch of lawyers and witnesses, and, we couldn't talk to anybody for about a half an hour, 45 minutes. So that the hearing got kind of hijacked by the technology. I think that, there are certain, benefits to doing it. And I think that, at least in my cases that I've been involved in, you find ways to do it. In fact, thinking about what to tell this audience, there's going to be a great need for young lawyers who know how to work all of these technological advances that are going to continue to be made. And I have a picture, we have a picture now in our office. We used to have a picture of kind of the wall of fame for, grandchildren and babies and all those kind of things of the staff. Our IT guy took a picture of the associate of mine that worked with me on the hearing, and she was in her office, I was at home. But she had 5 screens open in her office, 4 monitors in her laptop, because we were pulling up exhibits and going through discovery and having the open chat box. So if you learn to do this, Zoom technology and becoming Zoom proficient, I think is the way of the future. And hopefully Marty would be smart enough to add some Zoom remote proceeding classes for the litigation groups and some of the law firms. I think that's really going to be helpful going forward. And I guess I'll turn it over. I guess the last thing I would say about this, and this is really not my litigation itself, but the clients, I think, are also going to adapt. I was involved in early May. Our firm represents a arbitration board that's kind of unique here in Chicago, that is between construction union locals who are fighting over work jurisdiction. And the practice in this board that was formed in 1926 to hear these cases is that they don't want any lawyers involved. So it's all the business agents and the representatives, and they were forced to do a Zoom hearing. And that hearing turned out to involve 87 exhibits. There was one party that offered 500 or 5,900 pages of documents, all done by remotely and by an arbitrator with no attorneys. And it was, completed in a day, and the arbitrator was able to render a decision, and 3 days later, 26-page written decision. So I think people can expect to, we're all going to adapt. This is going to be, unfortunately, the wave of the future for the next, and I think it's not going to go away. So I think what we've learned here is that we can do things remotely, and I don't think there's any going back. So, get ready for that. Thanks, and I'll give it over to Jean.
Good morning. I may take my my video off actually at some point, because I'm having a little bit of connection problems this morning. I'm out of my office, but I guess at the moment, I guess I'm okay. Marty, you'll let me know if I'm not coming through, and I'll take my video off. I'm an arbitrator, as Marty said, and I decided early on in the pandemic that I would really not only make a push to learn how to do video arbitrations myself, but also to work to make this kind of expertise available to other arbitrators and to advocates. And so I joined the National Academy of Arbitrators. Both Marty and I belong to the Academy, and the Academy, in order to get into the Academy, for you students who may not be familiar with us, you have to be an experienced arbitrator. You have to show that you're acceptable to both sides. You have to have some experience under your belt before you even become a member of the National Academy of Arbitrators. So we set out to form a video task force in March, and we have now created a number of training programs, both for arbitrators and for advocates, in how to do this new video arbitration. I myself have done now over 25 days of video arbitration. Something saying my internet connection is becoming unstable, so I'm going to take my picture off. Anyway, I have had a very good experience with things where we've had to shut down for more than 5 or 10 minutes in order to fix some kind of technical difficulties. We've had all kinds of, what's been interesting to me is the different formations in terms of the video arbitrations themselves. So in some of my video arbitrations, everyone has come in remotely. In other video arbitrations, the parties are together with their witnesses. Sometimes they're all together, both management and the union together with all of their witnesses in one large room. And only I come in remotely, together with their witnesses, management may be together. So in each of these different kinds of situations, we've had to become flexible and adapt to how that particular situation can be handled as a video arbitration. Some of the concerns I know Patrick talked about, these very document-rich cases. One of the things we talked about at the beginning when we started doing video arbitrations is, are there going to be some cases that are better to do as a video arbitration than others? What I have found is that we can handle both contract cases and discipline and discharge cases. I'd say I've had about half and half in terms of my own practice. We can handle both kinds of cases, and we can handle these very document-intensive cases. In fact, I'm finding, because what I do with my documents is I send out a Dropbox invitation to people so that I get all of the documents in one place before the hearing. And then when we hold the hearing, I actually call up the documents myself in Zoom and put them up on the screen. And what we're finding actually in some of these very document-intensive cases, it's actually faster for me to pull it up on a screen that everybody can see in front of them than it is for everybody to shuffle through their documents and wait for everybody to find Union Exhibit 22. So actually, I think that it's, in some ways, it's more efficient than maybe some of the normal way that we do it with hard copies. One of the questions that keeps getting posed to me is, can the arbitrator make a credibility determination? Can the trier of fact, can the arbitrator, can a judge make a credibility determination on Zoom? And what I have found is that a couple of things I think are worth saying about that. One of them is that, I'm going to try to start my video again. One thing I would say is that sometimes I think that advocates, and as you're learning in law school as well, can overplay the amount that an arbitrator being there with them or watching how they move or watching their, how some kind of body tick or some kind of body language to determine credibility. What I'm trying to do when I determine credibility, first of all, I don't know the witness. I've never met the witness before. Some people who are definitely have the facts on their side can be very nervous when they're testifying. Other folks can lie without, showing anything on their faces. So arbitrators, I would say, to put a whole lot of emphasis on how the witness acts at the hearing, unless there's perhaps some change in how the witness acts where they're testifying one way and then they get to a particular question and something changes in the way that they testify. The thing that we're looking at for credibility is the internal consistency of their testimony. And also, is there some other kind of facts in the record that tend to support their testimony or not support their testimony? So those, and the other thing that I am telling people too is that if we're in a hearing now, everybody's going to have a mask on. So if you want me to look at people's facial expressions, it's not going to be very easy anyway. And the other thing is, when I'm normally in my office, I'm out of my office today, but when I'm in my office, I've got the 3 big screens too. So when I bring the witness up, first of all, I pin the witness on Zoom. So the witness is right there, their face is in front of me, and 27 inches or 24-inch screen, I can see every little twitch of their eyebrow. The issue, I think, is something that we're working through, but I think that it's not really a detriment to the video arbitrations. The other thing is that one thing that I think is proving very useful in video arbitrations is these breakout rooms that we have in Zoom. So normally when we hold an arbitration, of course, the union may want a caucus room, management may want a caucus room. The arbitrator may want to take the advocates out in the hallway and talk to them about something. I can set up rooms for all of that in Zoom, and people have become very adept at popping into their rooms and popping out, and when we need to do that in the hearings. So that has been a very useful function. We're just creating a virtual room instead of walking down the hall to a caucus room, you know. And also in mediations, I've done a couple of mediations this summer too, and it's worked very well. I can be in the room with one set of parties, and then I can move to the room with the other set of parties. Everybody's coming in virtually, but it almost does get to feel like an actual virtual room as you're going between one room and another. So I'm finding that the technology is working very well. Arbitrators have adapted to it. I never would have predicted, and I'm sure my children never would have predicted, that I could have adapted to it as well as I have. I agree with Patrick that these kinds of skills, and those of you who are coming out of law school now, they're going to be great skills for you to have, because I think beyond the pandemic, we're going to be using more of this kind of video, these video proceedings, you know, depositions, not having to travel. I think there's going to be a lot. It's going to keep going, and there are a group of some of the arbitrators who have decided they just cannot learn the technology, don't want to learn it. And they are relying on, what they're doing is bringing in younger lawyers or younger folks to just go ahead and work the technology. I'll sit here as the arbitrator and do my thing, and you know, you put people into breakout rooms and you pull up the documents and that kind of thing. So I think certainly right now there's a market for that as well. All right, I think I'll end there. I'm sure you folks have questions, and I know we need to move on to some other speakers. Thank you.
So we have about 5 minutes left before we move to the next panel. Let me ask Lisa, Pat, for example, what other kinds of things are you doing remotely? Are you engaging in negotiations remotely? What about investigations and things of that sort? How has the pandemic affected that aspect of the practice?
Yeah, Marty, I would, it's been a combination. I think I was back at the bargaining table live for one of a manufacturing contract in May. That was a little soon. It was, you know, we were all wearing masks and you know, trying to be 6 feet away was pretty difficult, because there's just not a, you know, in an environment like that, you just don't have a room big enough. I'm doing a lot of negotiations remotely. I actually concluded a contract using interest-based bargaining. So, you know, there's traditional bargaining, which most of us know about, but interest-based bargaining is, it's a very visual, typically it's a very visual, it's a very, a process that has to occur live. We often use, you know, we now use technology for it, but often would use, you know, like butcher block paper and put it up on the walls and write ideas down. So that was a little more challenging, but we got a contract using it. So, you know, I think our lot, labor and employment lawyers, are very flexible, and we have to be. And so I think we're just, you know, my question is, I happen to be an extrovert. I want to go back to the old way. My concern is that this is going to be our new norm. And, you know, once we get a vaccine, I'm hoping that we will go back to the old way of doing things.
Yeah, I think, you know, I haven't had a lot of negotiation, you know, that I've done. Most of the negotiations was finished, like the firefighters, our firm finished it up before March, so that contract was done. But I think in grievances, I think, I found, at least in the city cases, that they were more hampered by the fact that they hadn't gotten fully, up to speed on having the ability to have Zoom meetings and that kind of stuff. It's because of the bureaucracy. But as somebody said, I think it's going to not go away because it's more efficient and it's going to be cheaper in some ways, not having to travel for expert witnesses or bring people in. And we had a hearing, in federal court here in Chicago there was one witness who was not allowed to travel because of the international's travel ban, and it kept all its agents. He was in West Virginia. There was another witness downstate Illinois. All of them, would have otherwise had to come here and stay overnight, and that cost would have been incurred by everybody. So I think people are going to find ways to make this more efficient, but I don't disagree with Lisa that there is something to be said. I think, and maybe the other people in the panel talk about it, I think the bigger issue going forward is for how do you mentor younger attorneys and people right out of school remotely. I just don't think that's I can't imagine what business model can work that way, just because of, I find it hard enough to work with the lawyers that I know that have been doing this a long time on Zoom or having conference calls. But I think that a young lawyer who wants to sit in or wants to be able to hear things or wants to come in your office and just talk about a problem, it becomes much harder, when we're all working remotely. So I think there's going to be a drive to get back to the office in some capacity at some point, but I don't think in terms of the other aspects of the practice that we're going to be able to eliminate remote proceedings going forward.
Yeah, and stay tuned, because one of our sessions this afternoon is really going to focus on how mentoring and job hunting and job interviewing and the like, and networking in a remote environment. And I'm anxious to hear what they have to say. Yeah, I'll just add one personal thought, and then we'll move to the next panel. But I'm on a particular arbitration panel. I do practice as an arbitrator in my so-called spare time. That is under a nationwide collective bargaining agreement. And so all of my hearings until recently have been in the Chicago area and in the Cleveland area. But then a few months ago, and I assume every other arbitrator on that panel, got an email from the parties asking, are you doing in-person hearings? Are you doing remote hearings? And I responded. And so now next month I have a hearing that's out of Miami. We're doing it remotely. And I kind of wonder, when the pandemic passes and things are back to more normal, whether they're going to keep that and in effect use us all as a national panel rather than little regional panels with continuing to do remote hearings. Okay, we're going to shift gears, but Lisa, Pat, and Jeannie, thanks so much, and do stick with us and feel free to interject as the discussion continues. But we're going to shift gears now. Lisa got us started a little bit and look at the kind of legal issues that are surfacing in the workplace connected to the pandemic. So Rebecca Salauda, I'm sorry if I butchered your last name, Rebecca. Rebecca has practiced exclusively plaintiff's employment litigation for 24 years and since 2007 as a solo practitioner. She's served on the National Employment Lawyers Association's executive board and as its executive secretary, and currently serves as president of the Employee Rights Advisory Institute for Law and Policy after serving as its founding executive secretary for 10 years. Her practice is located in the Milwaukee, Wisconsin area. And Diane Subley is a fellow of the College of Labor and Employment Lawyers and also of the American College of Employee Benefits Council. She's a co-editor-in-chief of the Bloomberg BNA Workplace Harassment Treatise and a contributing editor to the Benefits Law Journal. She concentrates her practice in labor and employment, benefits litigation, and tribal law. And I'm also happy to say he's an adjunct member of the faculty at Chicago Kent. So we'll shift the discussion to Rebecca and Diane.
Unmute. So here's that technology part. I am going to all right, I'm trying to, it says that the host has disabled participant screen sharing, but I would need to share my screen to show our PowerPoint.
So
There,
Susan,
got it. Yep.
Okay, you got it? Good.
Yes. So, all right. So yes, this is us. We're going to be going through things rather quickly. So I know on behalf of me and don't mean to speak out of turn for Diane, but if there are issues in here that you have questions on going forward, here's our contact information, and certainly feel free to follow up with emails asking, what did you mean by that? Or because there's a lot going on, as people have been indicating. So I want to start off really by what I think the biggest thing I have learned. People have talked a lot about essential workers since COVID has started, but I think that it is something that anybody who's going to practice in labor and employment law needs to really embrace, and that is that no work is insignificant and all labor has dignity. And one of the things that I have really observed time and again throughout my career is the pride that people take in their work. And sometimes I'll hear a job and I'm like, dang, I couldn't do that. But somebody loves it. And that's why there's so many different kinds of work and why it's so important, and why all employees that you work with in these areas deserve to be seen with respect and dignity in the kind of work they do. Just looking back, I sucked as a waitress. Could never support myself on that. Is an example that there's a lot of different types of skills out there. And so I think that that's just really important to remember as a labor and employment lawyer.
And Rebecca, I'm just going to add to that, that as our law students become lawyers, they're lucky to have heard today that we're in an industry that allows us to work remotely. Some of us are considered essential, but at my law firm, we figured out really early that the essential people at the firm are not necessarily the lawyers. Nonetheless, I was really heartened to hear what Ogletree was doing through Mike Kramer's remarks. I want to reinforce that even though we have lost a wonderful mentor over the last couple of weeks for women in the law, and for everyone in the law actually, over the last 40 years, that there is still unconscious bias out there, and you're going to see that in the slides that we present, and that it's important during the pandemic and post-pandemic that we work together collegially, as we do in the College of Labor and Employment Lawyers, to find solutions through diversity, inclusion, and equity efforts. So I'll turn it back over to you, Rebecca.
Sure, thank you for that. So just also emphasizing that one of the impacts of COVID is just the disproportionate impact that it has had on people of color, on the working poor, and on mothers as opposed to fathers. And some of these statistics bear that out. You can do a lot of looking and find addition, but really keeping in, as we've had segregated job types that has led to a disparate impact. And one of the things Diane had raised in our conversations before this is a concern about as people have been making these good efforts at increasing diversity, when layoff decisions come, sometimes those people are the first to be laid off. And so what will that impact be? And Diane, I don't know if you wanted to add to that.
In terms of calling them back, I think the statistics that we see also reflect the balkanization of the working poor in industries where there's a lot of customer contact. Yeah. And certainly restaurants, retail, hotel, agriculture, construction. I think everybody's poised, holding their breaths to see if there's going to be a second surge here, as Europe is perhaps experiencing with future orders for shutdown, even if other states are opening up. And certainly we saw even in Texas, additional shutdown orders. So in terms of coming back from either furlough or layoff and coming back into the workplace, the folks that have these, that show these statistics, the Latinx, the Black, the Native American, the immigrant, tend to be working in industries where there's more customer contact, so that will be difficult for them. Okay.
So then getting into sort of specific areas of law, as we've been talking about remote working, that's where you're seeing a lot of the challenges when it comes to the Fair Labor Standards Act and challenges of working from home for both employees and employers, of timekeeping, both employers trying to figure out how to best do that timekeeping and employees trying to manage how much time they're working. There are some statistics out there showing that people are working a third more than they did before now that they're working from home. And making sure that hourly workers are getting paid for every hour that they're working. One issue that I see is as just thinking of, and I like Diane, how you'd mentioned about seeing who the real important people in the law firm is. I have an attorney on the other side who has her long-term assistant is retiring this week, and you can just see her practice sort of deteriorating as she's trying to keep up. But you know, as we lawyers may be working at various wonky hours, if you're emailing, texting your support staff, are they expected to respond? And if that is outside of the 8 hours, they're entitled to be compensated for that. You also have issues of family care responsibilities where maybe students working from home and a parent may need to do some supervision during the day and being able to carve out that time during that. So those are some of the issues I know that that folks are talking about and looking about when it comes to wage and hour work. Diane?
The only thing I would mention is that a couple of my clients were doing this even before the pandemic, and that was they'd switch to electronic timekeeping for their non-exempt, and they actually have their exempt people filling in their calendars electronically. So timekeeping remotely will probably rely upon the very same problematic timekeeping slips that we have for law firms everywhere. So you just need to be prepared that they can keep track of time, even break time and meal time. There may be circumstances where you would want to take a look at state law, because there may be a way that policies can be formed to show that people, like in California, you have to actually, you're encouraged to leave the workplace. Well, does that mean go to the kitchen and get a cup of coffee? Well, those kinds of things may need to be built into those electronic programs.
Yeah, especially in California where you can't even walk outside your house for this.
That's right. That's right. Exactly.
So other issues, and we've touched about this a little bit before, but discrimination claims that are really coming to the fore now. Family care responsibilities. There's Hastings College of Law has a center in which they focus on family care responsibility discrimination, and they're looking at stereotypes of men and women in the workplace based on what their perceived responsibilities are with respect to family care, not only children. I'm sorry. My Siri is deciding to talk to me. 1 second. Sorry, just threw my phone away. So yeah, looking at family care responsibilities, Price Waterhouse and the more recent Bostock talk about stereotyping in that sense, and that importance. Diane, if you want to talk about Martin Marietta, because that was one that you had brought up.
Well, thank you for letting me do that. It's also one of the 3 cases that Justice Gorsuch's opinion relies on, but Martin Marietta was an early case in the 70s. We used to call it Sex Plus, and there was an assumption that women who were applying for positions would be the primary caretakers of their children, but not men. So that's the kind of stereotype that we're talking about in terms of family care responsibility. So they would ask, what are the ages of your kids? And then if they had primary school children, probably wouldn't hire those women. Okay, that's the kind of Sex Plus stereotype that's now back in the forefront in Bostock.
And what's interesting, setting aside what you think about the actual current Supreme Court nominee, I see it playing out there. I mean, the number of commentary that I've seen about, wow, we have what will it be like? She has 7 kids, well, you know what? Justice Scalia did too. And why wasn't there that examination of his ability to be a justice in light of that? I think so. That just really emphasizes that this has not gone away and continues. And the statistics we showed before about mothers having a harder time getting back to work than fathers. We've also seen an increased discrimination against Asians. One stat I saw is that there have been 2,000 reported instances of discrimination or hate crimes against Asians in light of the constant talk of it being the Chinese flu or whatever you want to call it. And also, I have seen, in recent years, really an increase in discrimination against Blacks, much more overt discrimination than I had seen in the past. Some people are feeling like it is much more okay to use language and say things that I thought were a part of the past. So these are some of the things that we're seeing come to the fore. Dan, did you want to add anything?
I was just going to say, not to mention the noose harassment cases, where you have to have almost the noose around the neck to have it be severe or pervasive enough. Yeah, it's a little bit disturbing that we seem to be moving backwards in some areas.
Yeah. Other issues, just illegal assumptions about the ability of older workers or the ability of individuals with disabilities to safely return to work. It is inappropriate for employers to assume that an employee who is 60 or 65, whether or not they're safe to come back to work, or whether an individual with diabetes is safe to return to work. It is necessary for them to give those employees all the same choices and let them make those decisions that they would like. And Diane, if you'd like to add.
Thank you. The resource that is listed at the bottom of this slide, if you can get into it, you may not be able to get into it through WYSK, but that is the most recent in September. And it has a very helpful set of questions and answers on all different discrim laws, and the one in June as well. There's a technical assistance Q's and A's. At the end of the one that is listed here, there's a wonderful list of OSHA and other agencies that provide suggestions about safe environments. In terms of the ADEA, the Age Discrimination and Employment Act, federal at least, there really isn't, according to the EEOC, an accommodation requirement for older people, but older workers. But the employer is free, as Rebecca has just been telling us, to provide flexibility as long as they're not just making an assumption that the older worker can't come back to work because they're over 65. There needs to be some sort of dialogue. It can be maybe shortened a bit if there's some kind of emergency, but you really do need to make individualized assessments. And the only thing that I'll mention about direct threat is that in the most recent guidances, the EEOC is taking the position that that is an extremely high standard. So I suppose if the militia showed up at the governor's office and one of them were an employee, we might have the direct threat in a quick circumstance. But I mean, we all remember the cases where there have been employees that show up with guns to work. And the question is whether COVID is just another form of gun at this point. I think that we're going to see pushback on people who want to come back to work without wearing their masks, regardless of what a test might show. So we all need to be prepared that there could be direct threat litigation later. Okay.
Just a sign of the times that that's not a hypothetical that you're talking about a militia showing up to work. On the guidance though, I would say I have found in general, at least in Wisconsin and also some of the federal, they've done a fairly good job of providing a lot of pretty good guidance. So that's when looking at trying to understand these things, that's really a good first place to go is the EEOC, the Department of Labor, or your state or local government. Also on discrimination claims, we have issues of medical privacy. The ADA prohibits sharing of medical information. And so that creates this tension about, you know, if somebody is diagnosed with COVID, how do you trying to share that with others in the workplace without sharing specific information? So sort of a general, somebody who works in this department has been diagnosed with COVID, you know, everybody should be tested. You know, how do you do that without identifying the person? And so I think that's going to be a challenge going forward, because I also think it's necessary to try and share if somebody has been in the workplace who's been diagnosed. GINA, the Genetic Information Non-Discrimination Act, prohibits asking about the medical condition of family members. So while you can ask employees if they've been in contact with anybody with COVID, you can't ask if, say, their spouse or some, I guess it would be like your mother or your child has it. So being careful with that. And then, you know, just the tension with contact tracing and quarantine. Dan, if you want to add.
Actually, no, I think you had covered it in talking about the ADA. So that's the idea that we had talked about yesterday. So I'm happy to go on to the next slide if we can.
Okay. And if you want to start off with this.
Yes. As everyone now knows, there have been lawsuits against the governor's EOs, executive orders. But I want to reinforce for the law students and other people on the phone, in our forum today, that there are still some state orders. For example, in Michigan, although the lawsuit dealt with 2 statutes, the lawsuit began in the Western District. The federal judge there asked for an advisory opinion of the Supreme Court, and the Supreme Court dealt with the 2 statutes that were addressed in that lawsuit. Another state department, relying upon a different statute, has issued similar orders for safe reopening. And individual counties and individual localities have also kept in place mask and safe social distancing and safe reopening orders. So we have a situation where there will be a lot of confusion, as I'm assuming that there has been confusion in Wisconsin. And I just wanted to bring to the attention of the group that there was the decision that is in the second bullet that caused the Department of Labor to revise a portion of its regulations to apply now to certain healthcare workers who had been completely exempt, and that's available at the website that you see. And we had 3 days to get that into place and people about what remote work could be and when they could tell our employers that their school systems had a particular kind of schedule and whether they needed to have some kind of leave in order to be home with their children because they had no other childcare. Do you have any comments on this slide, Rebecca, before we move?
No, I think you really covered it.
Okay, so if we could move to the next one. So I'm at least sitting in a state with a governor's executive order that said that work, the most recent, before the decision, said that work that can be performed remotely must be performed remotely. So then the question becomes, well, if everybody's at home, what expenses can they deduct and how can they deduct them? And what are the tax implications? So while there is no real way to deduct the expenses for working at home after the Tax Cut and Jobs Act on the federal level, one needs to look at state law. And for those of you who will be working in Illinois, there is a state statute that allows people working remotely at home to deduct necessary expenditures. California talks about all reasonable expenditures. So you're really going to have to check state law. And the other tax implications were just raised, I think, by Mr. Zuckerberg, who has made public that because he's got so many people working remotely and moving out of the high cost area of Silicon Valley, that they're going to adjust and reduce the pay of people who no longer are working in the market that justified their higher pay rate. And then for tax implications, you have to think also about the people who are working out of state. If I'm in Michigan and I'm working in Illinois, I'm lucky because the states have a regional pact in terms of tax credit. Other people might not be so lucky. And it's going to complicate things for people who work out of the country. For caretaker leave, just so that you understand this, the recent guidance says that it will depend upon intermittent leave. And they've always viewed, according to the most recent guidance from the DOL, the technical assistance that I have cited on the previous slide, they've always believed that intermittent leave required the agreement of the employer. So if you happen to have a student in Michigan who's in a school system that offers a hybrid schedule where kids go to school Tuesday, Thursday, and Friday, and they're prevented from going to school Monday, Wednesday, and whatever other day I've forgotten, but it's half and half a week. The days that they're prevented from going to school are days when the school is closed as to them. And therefore, each day, to prevent this from being intermittent leave, each day of that kind of closing creates another day of the leave under FERCA, and those leaves will of course end at the end of the year unless they're extended. So this expanded emergency federal Family and Medical Leave Act leave that's expanded will be considered to be a separate day of leave so that they don't have to get the employer's agreement. However, if, for example, you have somebody working at home and they can work for a couple of hours, but then a couple of hours they need to be helping their student because the student is doing remote or distance learning, and then they'll go back to work, that kind of intermittent leave requires the employer's agreement. So you really are going to have to look at what the situation is in your home state for reopenings and for remote or distance learning. If you could advance to the next slide.
I was just going to add one thing.
Sure. Sorry.
That you reminded me about when it comes to expenses. So going back to minimum wage issues, if you have if an employee, an hourly employee is, or really any employee is required to work from home and they incur added expenses that they have as a result of that. So say somebody who didn't have internet access and now has to purchase internet access in order to be able to do that. If those expenses bring their hourly income below minimum wage, that could be a wage and hour violation. And so employers are going to need to really be careful about ensuring that they cover those costs.
Right, that they may have to adjust their employer policies on reimbursement to those that are COVID related from remote work. Absolutely. Okay, if we can, thank you for advancing. A lot of employers have said that working on site, even after reopening in these uncertain times, will be voluntary. So that is an option, except for essential workers. The question that we will see, I think, come out of all of this jockeying back and forth is whether an essential worker who then says, no, I have a family member who has tested positive and I do not want to go in and then go back home and expose that family member, or I have a family member with autoimmune problems, and the worker has brought it up. Does that mean that that essential worker can be told, okay, I'm sorry, but you just don't have that job anymore? What we've been seeing is a very reasonable discussion between workers, whether essential or not, and certainly our healthcare providers have had those kinds of discussions because they had to be on the front line. One note that I will just mention: the Michigan Senate, after the lawsuit that resulted in an indication that the two statutes on which the governor had relied could not be relied upon, has essentially extended unemployment comp for workers, but they've tied it, there's a bill that's tied it to employer liability immunity. So when you folks think about whether we're going to have this wave of lawsuits after all of this shakes down, you may need to have on your radar that there might be state legislation, and depending, there could even be national legislation at some point offering employers some kind of liability. Safety precautions, as you know, there are certain tests that are advised, others that don't give you as much information and you might require further testing, serological tests that they're trying to perfect, all of which doesn't really tell us whether someone could get reinfected or have a recurrence. So in terms of coming back into the workplace, there are certain things that can be asked of employees, yes or no answers, in terms of what we currently know as symptoms. They can be asked about travel in a particular place. But one thing I've been concerned about is I have clients that, for example, have people come into the office and then get tested for temperature, and then a list of those people with their temperatures is written out next to their names. I'm not so sure that is helping keep the privacy of that information. And then certainly we've had everybody understands that PPE can be required and social distancing can be required even under the most recent federal guidelines, and disinfecting of common areas. And you can ask that there either be no visitors to the premises. We do not have visitors if we can possibly avoid it. We do remote meetings with our clients, for example. But if there are visitors to the premises and they report, then you have to do contact tracing in addition. So those are the re-entry issues. Emerging issues are those that I've listed. Accommodating the high-risk employee would include, I believe, making sure that you are engaging in an interactive dialogue and an individualized assessment, as I mentioned before. So I would strongly urge that you look at the source material that we gave you, and within that source material, the list at the end, and start with the technical assistance.
And just to add, these are very real issues that folks are facing. Two examples I can think of. One sort of emphasizing that accommodations under the ADA are only required for the actual employee. So if the employee is an individual with a disability that requires accommodation, that is protected under the ADA. But if the employee has a family member with a disability, that is not required to be accommodated. And so one example I can think of is a woman who I spoke with who was faced with the very difficult decision of return to work, or where, in light of the fact that her child has extremely severe asthma and potentially infecting her child. And so these are horribly difficult decisions that people are facing. Another client, woman that I spoke with, has several very significant disabilities that make her at high risk. She hadn't really left her home, had everything delivered, was working from home, and her employer insisted that she return to work or face termination. They claimed that they had done everything they could to make the workplace safe. 10 days after she returned, because she couldn't afford to lose her job, she came down with COVID and has been in and out of the hospital for 2 months now. So these are not easy decisions that employees are facing, and so I just share that.
With regard to, I am so sorry to hear about the second person.
Yeah.
With regard to the first, at least until December 31st, if your child, if there's a question about a family member with autoimmune problems or a child with asthma, there is a way to indicate that through a doctor's certification so that they can use one of the leaves under FERCA, at least until December 31st if it's not extended. And if you would advance to our last slide.
Diane and Rebecca, can we kind of wrap
this
up
one is
super
our
quickly?
very last slide. That's
Right, 'cause we're cutting into the judge's time right now.
That's very good. Here you go. We're done.
Yep.
Rebecca, can you give me back control?
There we go. Great. Okay. Well, that was fantastic. And sorry we kind of ran out of time. Let's take, instead we had advertised a 10-minute break, but let's hold it to 5 minutes. Feel free to, grab something to eat during Judge Pallmeyer's address, and stay logged in. And then I'm going to turn the moderating function over to Joe Tilson, who's a fellow of the college and a former chair of the ABA section on labor and employment law, who will introduce and moderate for Judge Pallmeyer. Thank you so much.
Thanks, Marty. We'll get started at 12:37.
Rebecca,
Yeah,
can you switch me back to the host?
all right. How did I, let's see.
Yeah, so you should be able to find my name in the participant listing and then click on the little dots next to my name and say make host or something like that.
Got it. Yep. Oh. Yep. Done.
Thank you, ma'am.
Good. I almost logged off without doing that. That would have
been. Oh my God, don't tell me that.
All right. I need to run. Thank you so much. This was really enjoyable.
Thank you so much for participating. Appreciate it. Okay. Wow. Okay, there we go. All right, so I see Joe, Marty. Okay. And Judge Pallmeyer is on. Okay. Joe, are you there?
I'm here. I told everybody 12:37, so I was going to give them the benefit of their last minute.
Okay.
And we can extend Judge Pallmeyer by the 10 minutes. So we don't want to cut her short. We can just move the whole schedule back 10 minutes.
Joe, I was just going to say, I know that we had talked about if students wanted to ask questions to just direct them to put it in the chat.
Yes, did they direct it to everyone or just to me?
I was about to say you can either way. If you want to do that and have them put it to you, then that way you can review them and go through them. So anyway, I just wanted, that was just a reminder.
Yeah, I assume Judge Palmer, you don't want to be fielding chats as you're speaking. So,
it'd be easier. It's easier if you pass them along. Yeah.
Okay. All right. Well, it's now the appointed hour. So let's get started. Good afternoon, everybody. As Marty said, I'm Joe Tilson. I'm a management side labor and employment lawyer here in Chicago with Cozen O'Connor. It's my privilege to introduce to you today our keynote speaker, Chief Judge Rebecca Pallmeyer, who, of course, is the first woman to become the Chief Judge of the Northern District of Illinois in its 200-year history. Judge Pallmeyer was initially appointed to be a district court judge by President Clinton in 1998 after having served as a U.S. magistrate judge for 7 years. Judge Pallmeyer is particularly appropriate to be our keynote speaker today because Judge Pallmeyer actually began her career as a labor and employment lawyer at Hopkins Sutter, and then she became an administrative law judge at the Illinois Human Rights Commission, primarily presiding over employment discrimination cases. And I tried one of my first cases before her as a young lawyer. Judge Pallmeyer has been an extremely active leader in a wide range of bar associations, most recently as the secretary of the ABA's Labor and Employment Law section. Actually, back in the mid-'80s, I nominated her to succeed me as the chair of the Chicago Bar Association's Young Lawyers Labor and Employment Law Committee. It was a while ago. And then she promptly received the Hilliard Award for the Most Improved Committee. And needless to say, she's obviously been showing me up ever since. Judge Pallmeyer has also very generously donated her time to educating young lawyers on employment law and the practice of law in general, as illustrated by her presence here today on a Saturday. She's not only a brilliant lawyer, but she's full of practical advice for young lawyers launching their careers, as you will see. So please turn your cameras on and listen carefully. Judge Pallmeyer, thanks again so much for joining us today. The floor is yours.
Well, thank you. I have not been showing you up for years and years, Joe. That's not true. But it has been a pleasure to be as involved with the labor and employment bar as I have over the years because it is such an interesting area of the law for me, and I'm going to talk about that in just a moment. I have not been with you all morning, but I did listen to the last session. That was a pretty deep dive in some of the legal concerns that have been generated by this current era. And there are significant ones, and they're going to change, and they're going to change from month to month and certainly from year to year. But it's a great idea for you to get to see what goes on in the minds of lawyers and the concerns that they have right now. A moment or two to discuss the time that we find ourselves in right now. You know, in Hamilton, we know the song, How Lucky We Are to Be Alive Right Now. I don't think anybody's really singing about how lucky we all are to be alive right now, having this session over, you know, a video conference platform as opposed to in real life. I can tell you that the Labor and Employment Law Section Council does this every year. If you're still a law student next year, I'm imagining you'll hear about it and we'll be welcome to sign up, and I hope you'll be with us in person. Among other things, it's always nice to, you know, get to know one another at the cocktail hour and over lunch or whatever social are. But the substantive concerns, the substantive news that you're getting, you can get over a screen, and I know that you're familiar with that, those of you who are in law school, because you're doing that right now every day when you hear from your professors. So I'm not going to suggest that this is the luckiest time. I didn't choose to be chief judge when knowing that I would be guiding our court through what has really been an unprecedented series of concerns. Just decisions about how we conduct trials, how we space people out, what regulations we're going to impose in the building, all the things you just heard about what do we do when somebody in our building has tested positive? How do we proceed? What arrangements do we make to allow people to work remotely who must? And is there any real need for people who are completely safe to come in? Maybe everybody can work remotely at least. But although this is not something we would choose, think of this as the great challenge of a generation. You law students and I and the lawyers that are participating in this session today, all of us, we're facing really an unusual and unprecedented challenge, and it falls on us. It falls on us to make this, to succeed in this challenge. And I don't want to suggest to you that it's going to be painless. All of you have had some exposure to somebody who's been really hurt by the virus. Even if you haven't directly had some family member or friend who's been ill, the fact is it's affected your lives because it affects the way you study. It affects what goes on in Washington. It affects the presidential race. We are also dealing with a time of economic uncertainty, in part because of the virus. We're dealing with a time of great racial unrest and discomfort in the nation. And these are challenges that all of us will need to face and work on together. We can overcome these problems together. And I'm happy to be part of a profession that recognizes the need for that and will do what it can to make things right. That's why this is in some ways a good time. I don't want to say lucky time, but a good time to become a part of a legal profession that is active and involved. And the area of the legal profession that you're particularly interested in today is this labor and employment law area. And I'm going to talk with you about why I think that is a great area of the law for anyone to practice in. First, I want to just point out it will always be with us. We will always have workers in the United States. Now, much is said about work moving offshore. Work is moving to a different setting remotely. Work is now affected by the gig economy in a big way. But the reality is there will always be employers and employees. There will always be disputes. There will always be law to be made, to be developed. Concerns and methods for resolving disputes will always be with us. It is not bloodless. Mergers and acquisitions, there may be some intrigue there and some excitement there, but if you want human drama and you don't want to do, let's say, family law, then if you want human drama, you might want to be in the employment arena, because here is where people feel almost most strongly. Beyond their family, what people in America do for a living becomes really a significant part of their identity, and people care about it greatly. And that's why we have disputes about the smallest things that happen in the workforce, but that are passionately cared about by the individuals that are involved. So you'll find that it's an area of the law where people genuinely are involved and passionate, and that can make it exciting and challenging to be part of the disputes and to help resolve them. It's not a dry area or arcane area. The law changes in all aspects of the law, change all the time. But it's because I stay on top of employment law to the extent that I can, I see those changes regularly, not only statutory changes, but differences in how the courts resolve issues, even in the area of summary judgment and employment discrimination cases, and how the standards for judging those determinations evolve. So it's an evolving, changing area, constantly changing. When I was a new judge, much of what I did involved discrimination claims. We still have a great deal of those. We also have we have labor issues from time to time, although most of those go through the NLRB or other labor agencies, and then ultimately to the Court of Appeals if the court system is involved at all. Very often it's arbitrators that handle those problems. But in the employment arena, in addition to although discrimination was prominent early on and still is a very significant part of our caseload, we now see more and more wage claims. And wage claims have become a larger part of the court's jurisdiction. Now with COVID-19, you've heard about a number of the issues that new circumstance in our lives has generated. But I will tell you that from my own perspective, I have seen it already. We're going to have an increase in numbers of disability claims. We're going to have, whether they're perceived disabilities or real disabilities, we're going to have claims arising out of COVID-19. There are issues regarding family medical leave. The Family Medical Leave Act is relevant, but also there are new provisions coming down all the time from Washington about what leave is available for example, federal employees. COVID-19 is likely to generate more litigation in the areas of age, sex discrimination. I see that emerging because as more and more families are working at home, We are at least seeing some data that suggests that the burden of family life will fall more heavily on women. And what that means for them in the workplace is something that may need to be litigated ultimately as more and more people are working at least a little bit more flexibly at home. The use of PPP money, Congress authorized a great deal of assistance for employers, and there have been, and there will be more challenges brought by employees who say that that money is not being used as it should be to support and assure the payment of wages, but instead is being used for other purposes. And those lawsuits have been filed and will be filed already. I'm seeing simply the fact that the pandemic has resulted in the loss of jobs will mean that there will be litigation, because the people that are retained will, in some instances, be working harder and maybe in circumstances that they view as unsafe or unfair. The people who are not retained will believe that they were discharged or lost their positions potentially for reasons that weren't fair or that weren't applied evenly as compared with other people in the workplace. So there's just a lot of litigation that I see in the future, and areas of the law where lawyers can be involved, making sure that things are as fair as they can be. So if you are interested in this area of the law and you want to proceed with pursuing a career in labor and employment law, how do you do that? Well, what you are doing is exactly how you start. We start with if you're looking for a job in that area, you look around for what lawyers are doing this kind of work and what you might be able to do to help them. You're networking, albeit via Zoom. It's not as much fun as standing with a glass of sparkling water or wine in your hand while you talk to a potential employer, or just a lawyer who might not be interested in hiring you but is interested in sharing insights. But that said, there are ways to make this current situation work as well. Your law schools, many of them have employment law clinics. If you can be involved in the employment law clinic in one way or another, that's great experience that will look good on your resume when you seek a job in this arena somewhere once you graduate or as you're graduating. If you don't have a law school clinic, there may be a lawyer in your community that needs assistance or that you could volunteer to help. And when I say volunteer to help, of course, we don't just mean that you'll be making coffee and making photocopies or potentially even just doing those things that like pure research remotely. But if you can have some exposure to what the lawyer does when he or she meets with clients, deals with clients, and assesses a client's case, that can be extremely valuable to you. So even if you're in a situation where you're just doing it as a volunteer, and I realize that's a challenge for you young lawyers who will have bills to pay and will have to pay your tuition at some point, but if you can do it even as a volunteer, that's a great opportunity for you to get some exposure to a lawyer and some way to say, I know something about this area of the law when you are looking for to get your career started. Finally, I'm going to suggest be a joiner. I didn't always take this advice to heart, but I certainly have done it over the years. Joe Tilson mentioned his involvement in the Chicago Bar Association Young Lawyers section. I was involved in that section as well. I've remained a member of the Chicago Bar Association. I'm now very active in the Federal Bar Association, the Women's Bar Association, the ABA. I'm active in that organization as well. And then there are specialty groups. For example, we know about labor and employment groups. There are groups of labor and employment lawyers that specialize. It's special communities that meet to discuss those issues. I'm part of an organization that is involved in patent law, or at least intellectual property law, and that's another area where you can find some common ground with specialty bar groups. And I'm not suggesting you necessarily want to do intellectual property, but my point is there are lots of organizations that will want you to become involved, and they're great ways to develop, not only relationships, which are important, but skills that even early on, many of the bar associations will want speakers, and even a young lawyer can prepare a presentation, short or long, do some research, prepare a slideshow, and become a little bit of an expert. When I was applying to become a United States magistrate judge, I didn't have a huge amount of criminal experience, and I knew that would be important to the people that were interviewing me. And I filled that gap, at least to some degree, by becoming involved in a committee of the Bar Association that was involved in investigating the practice that the government then had of seizing money from people who are charged with crimes that might otherwise be used for their attorney's fees. And I did kind of a deep dive. I did some research in that and helped to the Bar Association committee to write a paper about it. And that was, not a substitute for being in court in a criminal case, but a demonstration that I knew something about an area that was helpful to me. So what I'm suggesting to you is that being a joiner is not a bad idea. It's a good idea if it gives you an opportunity to maybe write something, present something, and best of all, to establish a relationship with somebody who might then be able to steer you in the direction of an employment opportunity, or steer you in the direction of an area of the law that you hadn't thought of that you find interesting. Those are comments about how to become more involved in the labor and employment field, and of course I'm willing to answer any questions that you might have. What I'd like to talk about for a few more minutes at least would be more general comments about what you need to do as you take on the role of lawyer as you move forward with your career. So these are nuts and bolts things that I would tell any young lawyer, and I do tell any young lawyer, but it certainly applies in your situation just as it does for everybody else. First, you need to learn to write. There really isn't any more important skill. There's no more important skill for any lawyer. It's nice to believe that oral argument is happening all the time, but it isn't. Even oral arguments in the Court of Appeals and our federal Court of Appeals are rare, even though our Court of Appeals here in the Seventh Circuit is quite an active court and hears argument regularly. You're still talking about a fairly slim amount of times that you'd actually be in court talking to a judge. And that's regrettable in a way, but I think we have to recognize that in these current times at least, it's certainly safer for you to do your work on paper and submit your motions and your briefs on paper than it is for you to come to court. Our court, the Northern District of Illinois, has had a real tradition of a lot of face time with judges. I personally love to sit on the bench. There's just nothing that's more of a rush for me than to walk out there and see a number of lawyers in the courtroom waiting to be heard, especially when I feel I've done what I need to prepare and I'm in a position to help them resolve their disputes right then and there. It's really satisfying. For now, we're doing a lot more on paper, as many other courts in the nation do as a routine matter anyway. Things haven't changed as much for some courts as it has for us. I do hope things will get back to, quote, normal at some point in the future. I have every reason to believe that it will. I'm a COVID junkie now, pardon the expression, and I read everything I can about the status of the virus tests and monoclonal antibody work, et cetera. And I believe that there's light at the end of this very dark tunnel. But there are changes that we have made in response to COVID that I think we all recognize are likely to be permanent. And some of those changes will mean that there will be probably more done quickly on paper or in electronic format, whether it's video or even telephone hearings, than we once did. In any case, written communication has been and will remain extremely important. Even electronic communication requires writing skills. Lawyers more and more communicate with one another by email. That's fine. Let me remind you, you know this already, but it never hurts to be reminded. Nothing that's on a computer screen ever goes away, ever. It's something that kind of horrifies me, to tell you the truth, but your text messages, certainly your Facebook posts, all of that is permanent. Some employers, just as a side note here, will look at your Facebook page or all your posts to determine whether you're the kind of person they want to have working for them. So you need to be careful about what it is you post and say. But even in your email communications, recognize when your professional email communications I'm talking about, recognize that those might someday see the light of day, by which I mean, when we get motions to compel an employment case, or in any case, a discovery dispute, what we'll often get is copies of a string of email communications about how the lawyers communicated about whether or not something ought to be produced or whether or not something had been produced. And the language that's used in there is important to us. So an email that sounds like a respectful letter is likely to be a lot more persuasive to me than a quick, angry screed, which is obviously, it's tempting, but it's not always very, very effective. So when you are communicating professionally, and even to some extent when it doesn't feel all that professional, please do be careful about what you say and how you say it. Remember that grammar and spelling really counts. You just look like you're not very smart when your writing isn't very smart. You want to learn what a paragraph really is. With respect to anything you write, less is more. I've learned this, and I still am learning it. You know, nobody is ever as good a writer as they can be. We always benefit from editing, but less is more. And if you can say something in 3 sentences that could be said otherwise in 5, make it 2. You can get rid of a lot of surplusage if you're careful. And this requires careful editing, but it can be done. As a general matter, in any writing that you do, this I would tell anybody, but I especially tell young lawyers because I think it gets missed. Facts are always more important than law. And the reason for that, I think, is that in general, the law makes sense. Not always. There are parts of the law that just will make you scratch your head. You think, what? How did this happen? And you know, you might have to dig into history to find out how things happened. But in general, the law makes sense. And what that means is if you truly understand the facts, if you truly understand what happened, the result should be obvious. And for that reason, I always tell young lawyers, my law clerks, students working with me, be really careful with the facts, comb through the record. Somebody might characterize something in one way that isn't exactly what the testimony said. Or there may be a hole, there may be something missing. This happens all the time where we assume something, but it's not really there. Or there's some critical piece of information that really isn't in the record at all. Nobody's told us about that. And that missing information is what maybe drives the case. So facts really do matter. A final observation, this is applicable to all aspects of law, but certainly to employment lawyers. I often hear lawyers say, well, you know, I was never very good at math, that's why I went to law school. You know, and I cringe when I hear that, not only because I myself love math, I almost majored in math, I love math. But beyond that, what's more important than that is math is important in every area of the law. So often I see in employment cases, but in other cases as well, people have really gotten themselves tied up in knots about some legal issue only to find out that the damages are very, very small. And if the damages are very small, it would have been much better for your client to have settled that case early on. So think hard about the math always. You might want to always begin every case with, what is this worth? Which is not to say a legal issue doesn't need to be litigated if there's no money involved. That's not true. There are legal issues for which we need the court system, we need the decisions to be made, we need rules to be laid down, we need analysis, we need precedent. Absolutely true. But it's always important for you to assess whether the case you're working on is the one that requires the kind of effort that you're putting into it. So think about that. I'm going to make another comment that I think is more of a general one for lawyers doing anything, not just labor and employment lawyers. And that is, burn no bridges. You don't have time for everybody. You don't have time for every relative who's going to call you and ask you to write their will. You don't have time to do that. But you have no excuse not to be kind to everyone. There's just nothing that you will find more as you get older, and I'm older than you are, most of you, more important than having a word of kindness or a relationship with somebody that comes back for you. I've known Joe since he was a lawyer before me in that case that he mentioned at the Human Rights Commission. We've been friends ever since. There's really no reason when you're in any situation in life to allow the fact that we're busy and we've got a lot going on to justify being snappish or difficult. And I will say this when I tell you this, this is really kind of a do what I say and not what I do. I'm preaching to myself as much as to anybody else that personal relationships are critical in the law. The people that you're in law school with right now, some of those people are going to be friends for the rest of your life. And they're going to be there for you when you need them. And that you're going to refer work to them at some point, and they'll refer work to you at some point. And you will need them sometimes just as a sounding board to say, hey, what do you think about this? Or can you help me with that? Or my law firm is downsizing. I need some help. Have you got any advice or suggestions? Reach out to the people who are around you, because anybody can be there for you, just as you can be there for anybody else. So it's just a piece of advice I'd give any young lawyer. I feel myself lucky in some ways to be part of this era. The law is notoriously slow to change. We do things in our court that are really kind of arcane. And because of COVID, we've been, let's say, leapfrogged into the 21st century. It hasn't always been fun, but we're learning a great deal. We are seeing what can be done more quickly, more efficiently, more safely. And we're learning to do that in what I think is a moment of crisis, but a moment where people really are recognizing that it's time to reach out to one another. So I hope that you will recognize with me that this time is revolutionary, and that's not always bad. And I hope that I'll see some of you in real life in court. If not in court, then on a video conference or maybe at a telephone conference. I hope you will be practicing this area, and I hope that I'll be hearing from you. Joe, do you have questions? Does your group have questions?
Yes, we have a bunch of questions, and thank you so much for your inspiring comments, Judge. Actually, I have two related questions. One is, how do you differentiate between good written advocacy versus over-the-top advocacy that hurts a case? And a related question is, can you please comment on civility in briefs and the importance of a fair presentation of the record?
Well, I'll start with a fair characterization of the record. We have this, the rule in our Northern District of Illinois, 56.1. Many district courts have rules akin to that rule. And not all. Some of the courts have said, no, we don't want anything like that. But what that requires is that the moving party in an employment, in a summary judgment motion, identify all of the uncontested facts and then provide citations to the record that establish why that fact is uncontested. And when I get those, I always do, if the sides agree that a fact is uncontested, that looks pretty good to me. But sometimes, even when they agree, it's really not an accurate statement. You always have to look at the source material, the deposition transcripts, the interrogatory answers, documents. And if I see a repeated showing that a lawyer is mischaracterizing or short-circuiting or somehow playing fast and loose with the evidence, his or her entire credibility is lost to me. Remember, I know the law pretty well. In fact, when I get law students or law clerks, they know the law pretty well. I never see a draft decision from. Rarely do I see a draft decision where the cases are miscited or something like that. What they're more likely to do is misunderstand what actually happened, and that is so important. So your credibility in terms of how you assess the record is really significant. With respect to civility in briefs, over-the-top attacks on your opponent will really never get you anywhere. It just sounds silly. It really does. Now, there are times when a lawyer's behavior is truly sanctionable, and you need to draw that to the court's attention. But I got to tell you, it's rare. You're so much better off letting the record speak for itself, and that means don't engage with the nastiness. It just isn't worth it. How do I differentiate between effective advocacy and over the top? A lot of times it's in the language, it's in the tone. It's easier for me to do that when I have the lawyers come to court, because I can kind of see, I can witness the behavior and their demeanor. But as we move to more advocacy on paper, it really becomes a matter of reading that and thinking, is this the way I would talk in my ordinary life? Is this the way I would refer to somebody that I just met somewhere? Would I call that person out for particular, purported mistakes? It's just, you're always better off taking the high road. I think you have a lot more credibility with the judge if you take the high road.
Thank you, Judge. Another question, do you anticipate that the Seventh Circuit and the Northern District will continue with virtual proceedings and or capabilities even after the pandemic? What will the new normal be?
Well, that is such a great question, and I wish I knew the answer. I will say this. I think already the Court of Appeals is using Zoom for its oral arguments right now. And we do not, our court does not use Zoom. It's a long story. We don't need to get into it. But I suspect that the Court of Appeals is likely to at least continue to some degree with that, because obviously the Court of Appeals judges, some are in Wisconsin, some are in Indiana, even those who are in Chicago, some of them have reasons for health reasons or otherwise. They may not want to come to the building. I suspect that they will be doing more things electronically as time goes on. But remember, the Court of Appeals doesn't have that much, they're only in court for oral arguments anyway. Their active court time is less than ours. At the district court level, do I think that we'll go on doing more things by way of video conferencing? Perhaps. I think it's likely that we will do a little bit more just ruling on paper when things come in, as opposed to having people present their motions in court, which can be a little bit, a waste of time, I think, in a lot of circumstances. So I think we will probably be doing more things by way of just ruling on paper or perhaps telephone conferences than we were before. Some of our judges already were doing more hearings by telephone than, for example, I did. And I think that they're probably right in recognizing that it's very costly for clients to have their lawyers come across town, or worse yet, get on an airplane to come to court for a 10 or 15-minute hearing, particularly if that can be handled electronically. So I will say that the short answer to the question is yes, I do think that there will be changes that are long-term. I hope that we will continue to have lots of in-court time. And certainly for trials, doing a trial on a screen it can be done, but I think it's kind of bloodless. I think it's just much more satisfying to have people on the stand testifying if they really have testimony that needs to be given. There's really also something that's lost when we don't have juries come to the courthouse. And let me say that right now I encourage everyone, bench trials. I say this over and over because we can easily physically distance you in our courtrooms. Our courtrooms are large and spacious. We can get people spread out wearing masks. You can be safe in a bench trial. In a jury trial, we do make arrangements to space out the jurors, do that effectively, but it is a lot more challenging. And for obvious reasons, the more people you get together, even with masks, the more risk you're generating. That's the reason I'm right now discouraging juries. But in general, I love them. And the reason I do, and the reason I hope that after this is all over, we do resume a lot of jury trials, is that nothing is better for showing the rank and file, the people out there, people in the community who aren't familiar with the court system. Nothing is better for showing them what we do than putting them on juries. And it generates a lot of respect, is my experience, for what we do and for our system. And that is very satisfying to see jurors who knew nothing about the process come away from it with a feeling that, well, it's not perfect, but it's fair. And that's why I hope we do resume a very, very active jury trial bench when COVID is a matter in the rear view mirror.
Thank you, Judge. So you've already covered a few of these, but can you share with us any other pet peeves that you have with young lawyers or older lawyers, and if you have any new ones during the pandemic?
Well, all judges get tired of the cases where, there's a motion filed every week. We just feel like, I'll never get it all decided because they keep filing new ones. That just drives you crazy. I'm very much a nit when it comes to grammar and spelling, and I hate it when people make the it's mistake, IT with the apostrophe in the wrong place. And I hate, this is rampant, and I know that the language will change, so I'll be left behind. But the lie, lay, and lane mistake. Oh my gosh, if I hear about somebody laying out one more time, I'll just scream. You don't lay out, you lie out. So with these, little things like that, it just drives me kind of crazy. But in general, I would say there's no reason to include pages and pages of boilerplate in your brief. The judges know the law. You don't need to tell me the summary judgment standard. Believe me, I can recite it to you in my sleep. Lawyers will do that all the time. There's really no reason for it. Lengthy disquisitions about what the law used to be and how it is now, you don't really need to do that either. Focus on the facts. Give me as much information as you can about what actually happened, because the law, as I say, should, you know, the results should be pretty clear. I do object to lawyers who are unkind to one another and file lots of nasty comments in their briefs. It gets you nowhere. I don't like that either. In general, though, I would say I think the lawyers, for the most part, I'm not all that critical of the lawyers. I think they're doing what they can. It's not an easy situation that we're in. They're working hard. They're generally, you know, struggling. Many of our lawyers are struggling with, you know, the concerns of the pandemic. They're trying to homeschool their kids, or if they're not trying to homeschool their kids are on Zoom and their bandwidth is sucked up by the children, and they're trying desperately to get their work done. And at the same time, you know, maybe an elderly parent or, you know, a neighbor that needs help. I think the lawyers are really under a big challenge these days, and I'm not all that critical as you might think.
Great. So here's another interesting one. I'll just read it to you. This must be an interesting time to be a judge in a common law system, being in a position to start setting precedent with novel COVID cases. Can you speak a little bit about how you personally approach cases like that, where you don't have any prior case law to reference when making a ruling?
Great question, and you know that it's very much true that we are facing issues that are just brand new. The one I like to talk about is, you know, you law students have heard of the force majeure clause. I will tell you, I heard about force majeure maybe, you know, in law school and maybe during a bar exam, and I don't think I've had a case about the force majeure clause ever till now. And now there are half a dozen at least. And by that, I mean these acts of God. What is the insurance implication of COVID? Who has to pay for what? We have a number of cases filed by, for example, hospitality industry, which has really taken it on the chin because of the virus. And they are wondering whether they have business interruption coverage for that. And there's a lot of litigation going on like that. What do I do? Well, I do exactly what the lawyers, I would think, do, and that is I look at a horn book. I'll start with, you know, the basics. I'll start with a horn book or, you know, a treatise of any kind. Even law review articles, and those of you who are thinking about, you know, writing law review articles, my suggestion always is, you know, don't write about something that's really unusual. Write about what's going on. Write something about cases that are coming up right now, because judges are not going to look at a law review article that's about something that's really theoretical. They just don't have time. What they might look at is an article that addresses legal issues that are coming up right now. And that's why, and if you can be helpful, if you can say, well, this hasn't been looked at in, you know, 20 or 30 years, but here's what they were doing back in the, you know, in the 70s or 80s, and how those, you know, precedents might help us today. That's very helpful. So again, I do just what you do. One of the real advantages for me of my job, you know, being a judge is wonderful in a lot of ways. My big complaint right now is it is just an enormous amount of work. It's just overwhelming right now. But one of the things I love about being a judge is most lawyers, you know, 5-10 years out of law school, they're not doing a lot of legal research anymore. It's the brand new lawyers that do that. Well, it happens, I love doing legal research. I just love it. I really love cranking up Westlaw and looking at cases. And my job means that's what I do. So in spite of the fact that I've been out of law school a number of years, I read cases on Westlaw every single day. That's the way I learn, just like the law students are learning. You know, what are the judges saying about it? The law is a really interesting discipline. You know, in most areas, the people that are advancing the discipline are professors, right, doing research and writing articles in professional journals, in academic journals, I should say. That's not how the law advances. The law professors are writing articles in law reviews. But what advances the law actually is legal decisions. So we really do, in spite of the fact that we're not necessarily the brain trust that these professors are, we are the ones that are you know, creating the law and developing it and making determinations about how it's going to move forward. So we really do look at one another's work. We do research. We look at, you know, the treatises or the you know, the horn books that have been developed, and we work from there.
Okay, another great question here. Thank you so much. Any advice on how to professionally call out, characterize, misrepresentate, call out / characterize misrepresentations by opposing counsel?
I read a brief this morning where that happened. The lawyer says, you know, my opponent says this in his brief. Respectfully, that is not true. And then the lawyer cited the portions of the record that he believes established that what his opponent said was not true. You don't want to say he's a big fat liar. You know, he said my opponent once again is you know, playing fast and loose with the truth. Don't use expressions like that. Just say factually this is not accurate, or this is not true, or the record shows that the record to the contrary establishes blah blah blah. In other words, just point it out to the judge. The judge will catch that, you know, you've just caught your opponent in a falsehood. The judge will catch that without you being over the top.
Very good advice. Thank you. Does the judge herself or does a law clerk write her opinions?
I have, right now I have 3 law clerks. Usually I just have 2. And I think it's fair to say that I write about 1/3 of my own opinions myself from scratch. My law clerks write the other 2/3. They'll do the first draft. But there is not one thing I can say with utter confidence that has gone out of my chambers that I haven't looked over really carefully and made a lot of changes to. Even the best law clerks don't write in my voice, so I will rewrite things quite a bit. But I like to write, and I will often write from scratch, very often. I'm working on opinions right now from scratch. I like to write. I like, as I say, I like to do research. That's very satisfying for me. So I like the opportunity to write as well.
Thank you. So I think we have time for one more. Do a lot of your employment cases actually go to trial? And if so, how are they different than other types of trials?
Well, I do a lot. No civil case none of the civil cases goes to trial all that often. Do a lot of my more employment discrimination cases go to trial more than others? It's hard to say, perhaps. One thing I would point out about that is that, you know, there's the sense that judges are issuing or granting summary judgment all the time, so that, you know, very few cases go to trial. And in fact, more cases are being resolved on summary judgment than by way of trial, or even than used to be. And that's ever since the trilogy, trilogy from the Supreme Court back in the day. Summary judgment, which was sort of disfavored, is now kind of a favored way of resolving disputes where there are no real genuine disputes. But don't assume that just because any judge has a lot of published decisions granting summary judgment, that the judge grants summary judgment all the time and never goes to trial. Don't assume that. Instead, what you have to recognize is that the judges will not write a lengthy decision often when they're just denying summary judgment. Because if you know a case is going to trial anyway, you're not issuing something that's final or reviewable. So you might just walk out on the bench, back in the days when we would actually go to court, and that's going to come again, I hope. And you might say, okay, the defendant has argued that they're entitled to summary judgment for the following reasons, and I find disputes about this issue or that issue, and that's why summary judgment is being denied. So that might not ever get published. I do try from time to time when I'm denying summary judgment to publish something, just so it's clear that, you know, not everything is a grant that gets published. But the reality is that more often than not, you're going to deny summary judgment in a short order or from the bench. Now, will those cases then go to trial? Yes, in some cases they go to trial. And when they go to trial, they are they're tried, I think, as well as any other area of the law. Judges, the employment discrimination lawyers are not bad trial lawyers. They are not uncomfortable in the courtroom. The most important thing is that you feel comfortable in the courtroom. And that means sometimes if you haven't done it much, you go sit there and watch for a while and realize, well, I can do this. You know, it's encouraging to watch lawyers make mistakes, and you can think, well, okay, it's still okay. But the reality is that in the employment arena, as in many arenas, if we do deny summary judgment, the case is very often going to settle at that point, because the employer will realize, I might have some liability here, and will be afraid of what a jury might do. I think employers are often fearful of juries because they read about big awards that get made. The reality is that juries are no more, no more friendly to plaintiffs than anybody else. Employers win cases that go to trial all the time. I think one of the things that's gotten easier about employment discrimination trials over the years is we have very, very good pattern jury instructions now. The amount of work for a judge at a trial, there are two areas where it's hard. Picking a jury is hard because you get a lot of pushback from the jurors and it can be kind of dicey and uncomfortable. You don't want to say something stupid. You're doing a lot, the judge is doing a lot of talking, and that's uncomfortable. And then when you instruct the jury at the end, that's hard. In the middle, it's fun. The judge is just sitting there saying sustained and overruled and listening to it. And as I say, these are interesting cases. They're not bloodless cases. It's good entertainment. I don't try cases for my own entertainment. I take it seriously. These are real problems for real people that need their real problems resolved. But the reality is that for a judge, the challenge is getting the law right and getting the jury picked. So now that we have pretty good pattern and jury instructions throughout the Seventh Circuit, it's a lot easier.
Well, thank you so much for your excellent advice and sharing your wisdom with us. This was really an extraordinary session, and we deeply appreciate it, Judge Pallmeyer. Thank you.
Well, thank you for including me. I'll look forward to seeing you again very soon, I hope.
Thank you.
Okay, thank you so much, Joe. Thank you so much, Judge Pallmeyer, for giving of your time. Whoops. I think I'm muted. Can people hear me now?
We can hear you.
Great. Okay, thank you so much, Judge Pallmeyer, and thank you so much, Joe, for giving of your time. So let's take a 5-minute restroom break, and when we return, my Chicago Kent colleague, Richard Gonzalez, is going to take you the rest of the way as we focus on your career development. So everybody be back in 5 minutes.
Hey, Joe, do we automatically get sent into the breakout rooms?
Hi, it's Susan. Yes, you will automatically get sent into the breakout rooms when it is time to go to that part of the program.
Thanks, Susan.
Uh-huh.
What happens to those of us who don't have a second breakout room?
you can say goodbye. Or you can sit and watch the afternoon session, so.
Okay, we don't sign off, we're just
Yeah,
in limbo.
you're only in the morning though, right, Joe?
Correct.
Okay, so your duties are pretty much done, but we'd love to have you stick around.
I wouldn't miss it.
So. And
And
we'll get
to encourage people to stay, there is going to be a contest for our panel with one prize.
one prize, okay. And you're not sharing anything more, Catherine?
No, they have to stay for our panel to find out more.
Okay, there you go. You've heard it. Rich, I see you're here.
Yeah, how's my audio?
Sounds good.
Good.
So once we get going, I'll make you the spotlight until, I'm gonna try to keep up with people talking on the next panel. I'm assuming it's not as much of a interactive as much as it is each person's gonna have a couple of minutes.
Yeah, I figured 8 minutes would work, so we're gonna do Marnie, Chuck, Adele, and Robert, and then Catherine.
Okay. Perfect. Thank you for letting me know that.
How long is the block scheduled for?
It was only, what, 40 minutes?
That's what I thought. Yeah.
Don't worry, I'm keeping my jokes short today. Don't worry.
No, I'm just threading the needle and having to get to Wheeling. It's crazy.
So, yeah, so we're about 10 minutes behind, it looks like, according to the schedule. So we'll have an hour and 15 minutes for the two panels in this session. So an hour and 15 minutes is 75 minutes. So, 35-ish minutes for each group. Somewhere
So
around.
Rich, it means I'm gonna have to take off before, if questions are at the end, I'll have to take off before, but.
Good.
Rich will answer your questions, Marnie.
Sure, but you might not like.
Perfect,
He's good at that ad-libbing kind of stuff, right, Rich?
I have a stand-up comedian for a son. It's a problem.
Give out my direct line and tell him to call at 3 a.m. When my farm worker clients call me.
Yeah, exactly. Oh my
They
God.
leave their houses at 4:30 in the morning.
Yeah, we have to wait until 9. So. And then, Marty, you're not going to intro? We can just start with Rich?
They've heard enough of my voice. Rich is far more entertaining than me anyway.
All right, Rich, I'm going to spotlight you right now. It is 1:30.
Should I go? Ready for me?
Absolutely.
Okay, hi everybody. I'm Rich Gonzalez from Chicago, Kent. And yeah, I knew Judge Pallmeyer was going to talk about its and its because she's come to speak at my classes many times over the years. And every single time she talks about its and its. And her theory is that an exam that is an A should automatically go down to an A- if you make that mistake. So every, half step grade every time. So I wasn't surprised that she mentioned it.
I have never said that. I have never said that.
Oh my. I was going to refuse to participate today if this event wasn't in person and without masks. I wanted to be able to shout at people and interrupt the speakers, but they cannot talk me out of that. So we're on a tight time frame. So we're going to do like 8 minutes per speaker. And And listen, your campaigns have agreed to these rules. So don't make me be a Chris Wallace here about the time, okay? So we're gonna start with Marnie Willinson, who is just, I've always felt one of the brightest stars on the plaintiff side. Her firm represents plaintiffs in both individual and class work in discrimination, civil rights litigation, and like her website says, wage theft. So you can tell which side she's on when when that's what your website describes. In 2017, the firm filed suit on behalf of more than 1,500 women who are correctional officers and healthcare workers at Cook County Jail, who had been subjected to an amazing pattern of sexual harassment. One cute note about her, she was once a partner at the same law firm where Barack Obama worked. So I'm gonna turn it over to Marnie.
Thanks, Rich. Appreciate it. Is my audio okay?
Yes.
Okay. So thanks for having me. It's good to see everyone remotely. And appreciate this opportunity to tell you about my work and to provide advice to young lawyers and so on. So Rich gave a little bit of an overview. What I like to do is talk a little about my firm and then the trajectory that I took to get here, and maybe give some pointers at the end. So my practice is typically myself and one associate and sometimes a law clerk. So I'm not actually solo. I consider myself a small firm. I do all plaintiff side work. Although I didn't necessarily open my firm with the intention of only doing employment work, that has been pretty much exclusively what I've done since 2010 when I opened my firm. So I am a decade now into this and I do love it. I love having my own practice. And I have carved out a bit of a niche now representing mostly first responders, and particularly, but not exclusively, women. So Rich talked about one of the cases I have. It turns out now that we have the class certified, it's 2,000 women that work at the Cook County Jail, and they've been horrifically sexually harassed by the inmates in the jail. So we have a certified class right now. It's about 1,100 correctional officers, 500 medical personnel, and then some courthouse deputies and so forth. So I have that case. I have been suing the City of Chicago Fire Department since 3 months after I opened my doors in 2010. It was not my intention to perpetually sue the Chicago Fire Department for gender discrimination, but here I am. It's been a bit of a whack-a-mole type circumstance. So I represent currently 12 paramedics who were hired by the fire department and terminated based on the use of what we believe are discriminatory fitness tests. Prior to that, I litigated 2 class action cases involving the hiring of women firefighters and paramedics, also subjected to discriminatory fitness tests. And on the paramedic side, I can say they were actually discriminatory because we went up to the Court of Appeals and we won the case on appeal with a ruling from the 7th Circuit that the test was discriminatory. So I've represented all these women in lawsuits against the fire department, including continuing to now. And then I have a Monell case against the City of Chicago Police Department related to what they call their special functions division. And so it's like all the prestigious special operations unit, the mounted unit, the canine unit, the dogs, the explosive canine handlers, the Marine units, the rescue divers, the helicopters, and the SWAT team. And there are virtually no women in any of these units in the Chicago Police Department. And then my last large case that I have right now is a hiring case. This is not for women. It's not a sex discrimination case. I mean, there are some women. It's a racial discrimination case in hiring. We're about to file for class action of a class that would be thousands of Black applicants to become correctional officers at the jail. And we've run the statistics, and it shows that white applicants have 4 times the chance of being hired as a correctional officer at the Cook County Jail as Black applicants. This is a pretty devastating scenario for the applicants because these sorts of positions have historically been a way that Black working class men and women pull themselves into the middle class or even out of poverty. So these are important cases, and I have somehow carved out a niche doing that. So how did I get here? I wouldn't say it was meandering, but it was not an entirely straight trajectory. Out of law school, I had a fellowship at the Chicago Lawyers Committee for Civil Rights, which is a not-for-profit here in Chicago that does mostly impact litigation, and I was on the Economic Opportunity Project, so I was doing primarily but not exclusively employment work. I then went to the law firm. I did that for 4 years. Then I went to the law firm that Rich was describing, which was the small firm. Barack Obama at the time was already in the state Senate, so he was of counsel. So I didn't work directly with him very often. He was in the office. And I did voting rights cases. I did employment cases. And that's where I started doing wage theft litigation workers. One of my partners at this small firm, actually, most of his practice was representing farm workers out in California. So that was very exciting because I speak Spanish and was a Latin American studies major, so that was an excellent fit for me. I stayed at that firm for about 5 years. Then I went back into the not-for-profit world and became the litigation coordinator of a not-for-profit called Farm Worker Justice, which does what it sounds like. And I was litigating wage theft cases for Farm Worker Justice. And they're actually located in Washington, D.C., so this was a lot of remote work on that litigation, which was not in Washington, however. Our litigation was all over the country. And then I started my own firm. So I think part of my point here is your first job does not have to be your last job. And for me, the most exciting thing has been landing in something in an area of work that is just such an exceptional fit for me. I feel really passionately about it. I was an athlete in high school, and so somehow, I mean, it is just very exciting for me to be able to sue to strike down discriminatory fitness tests for women who are really tremendous. So the thing I love most about my work are my clients. And that's not always the case, but I really believe in what I'm doing, and we've had some good outcomes. A significant one was in a case where we had the great fortune to be reassigned to Judge Pallmeyer after our appeal. So that was wonderful. And there was a question about trying an employment case. I've actually tried a damages trial in an employment case in front of Judge Pallmeyer. So she does do some employment discrimination trials. I can vouch for that. Let me tell you my pointers. One is follow your passion if you can. I mean, this is a privilege to be able to do this. I did not really set out to do this particular work. I think some of it was dumb luck. When I was starting my practice, a friend asked me what kind of work I wanted to do. And this fitness test for firefighters had been in place for 20 years. And at my first job, there were a group of women that had charges on file with the Chicago Commission on Human Relations to challenge this fitness test. And the organization I was at and the law firm co-counseling together, they wouldn't file the case. They filed a race discrimination and hiring case, but they wouldn't file the case for the women because, frankly, the male lawyers thought, oh, firefighting, you have to be strong. We're not going to bring this case. So that stuck with me for over a decade. And then when I opened my practice, my client, I told this friend that this was my dream case. And she said, I know someone who just failed that test. So I said, well, I'll be happy to talk to the person if they're looking for legal advice. So, I mean, it was really fortunate. And sometimes the universe just works that way. So I think it's really important to find something that you like to do. For me, it's been really important because unlike Judge Pallmeyer, I don't love to write. And so sometimes this is a lot of drudgery for me. I don't love writing briefs. So I have to believe in what I'm doing. in order to have the discipline to actually sit down and do it. And maybe there's, you know, most of the 50 people on this Zoom love to write, and that's not an issue. But I think you will find if you're litigating that some of it is drudgery, even if you love to write. There is plenty of it that day to day is just so boring. I mean, a lot of discovery. I mean, it just is. So for me, I'm not the most disciplined person. What's worked for me is loving my clients and loving what I do. I have a set of pointers that's really maybe specific to women, but it doesn't have to be. It could really apply to everybody. I like to make the point for women or for men who plan to be very active parents, find a way to make yourself uniquely valuable. Whether that is establishing a network where you can bring in business to the firm where you're working if you're in private practice, or picking up some particular skill. And I can give you 2 examples. One is if you can be outstanding in Microsoft Excel. It sounds kind of ridiculous, but it is extremely useful. I mean, I can say in employment cases, like it is extremely useful on damages calculations. And, you know, we do get a lot of data. So, you know, for example, we may be calculating overtime damages, not just in a wage theft case, but in a case involving back pay, where one of my clients was denied a job or a promotion, and you need to run calculations that include back pay. Someone with skills in Excel is really valuable. And then another thing would be electronic discovery. If you've graduated from law school and you don't know what a load file is, or single page TIFFs, or how to use an e-discovery platform, then I scold your law school or your decision not to take an electronic discovery class, because this is how things are now. Even at small firms, the volume of data is just unbelievable. And you need to know how to do this. And if you can learn how to do this and be really good at it, you have a particular value that's going to help you when you want to have some other priorities in your life. So those are my pointers.
Hey, thank you, Marty. Thank you very much. And in regard to Chuck Baldwin, one of the things that this whole conference is about is reputation and respect. And, you know, Chuck Baldwin has all the credentials, 25 years experience, all aspects of labor and employment law. And this includes knowledge in ERISA, labor arbitrations, NLRB proceedings, wage and hour, trade secret disputes. So he's a jack of all trades on all those subjects. But what I want to emphasize for a minute is reputation. It is hard to develop a good reputation, and it is easy to lose a good reputation. And it's something that we want you to think about as you become attorneys. The respect that people have in the legal community for Chuck Baldwin is enormous. And there's a reason for that, because he exemplifies what an attorney ought to be. So I'm going to turn this over to Chuck.
Thank you. And when I need a PR director, I'm calling you. So I wanted to talk a little bit about the areas of labor and employment law. And you heard from Judge Pallmeyer that it's an area, areas that won't go away, which is so true. But what I've seen is the areas are so broad, more broad than most people appreciate. Particularly, I didn't appreciate it when I was in law school, and I suspect maybe some of you might not recognize the breadth of what comes under labor and employment law. And since really a career is more of a marathon than a sprint, it's nice to have options. And so you also might want to think about where the background in labor and employment law might take you. I've seen people pivot out of being practicing employment lawyers and become senior vice presidents of human resources, or go into being chief ethics officer. So this background, this experience provides you, I think, ranges of experience or opportunities for the future in different jobs. So I think coming out of law school and knowing you have a variety of options, even if you are focusing in what may feel to be a narrow area like labor and employment, It really isn't as narrow as you think. The other thing that sort of, as I was thinking about today, is labor employment has room for everybody. So if you're a recovering tax attorney, you know, the ERISA compliance world loves you. So we have lots of recovering tax lawyers in our firm that do nothing but employee benefits. Or if you're a former engineer, our OSHA lawyers love to have engineers because you deal with so much technical terms and workplace safety. In addition to the traditional labor employment. So the areas of opportunity and work and the range of different things you get to do is really what keeps me interested and has kept me interested in this area for so long. Working out of Indianapolis, I tend to do more. Some of our folks only do immigration work or only do OSHA work. And I always felt that was a little limiting, and particularly when you practice in Indianapolis, you need to be a little more focused generally on the labor and employment world. But it does offer, I think, lots of opportunities. I was reading some, and to prepare today, I read some of the student suggestions about the program and things they wanted to hear about. And one of the things that some of the questions that I thought were asked that were quite insightful were, you know, tell us about the types of personality or skills or personality types that might best succeed in this area. And so I was thinking about, you know, what are those? And I think, you know, being a creative problem solver would be a personality type or skill that would be certainly well serve you in this area. Write well, you're going to hear that again and again probably. In the defense practice, you tend to write a lot of motions, a lot of briefs, and certainly early in your career, being able to communicate with a sense of humor and precision is usually better received than trying to sound like a lawyer. So the advice from Judge Pallmeyer today I thought was really insightful. In fact, I took notes myself to remind myself to less is more when writing, because sometimes you let yourself drone on a bit. So you leave time for editing, please. I always try to and found that to be helpful. If you like to network, I think the law is an area where that is a skill and an interest that will serve you well. And then the one thing you're starting to see, and those of you who are at Indiana University and have taken some of the classes there on legal project management and knowledge management and innovation, recognize how that has become such a part of the practice of law, not just labor and employment, but I think being a lawyer, certainly at a big law firm, we have about something less than 1,000 lawyers, 950 some, and 53 offices. So technology is important to us and our clients. Efficiencies, being tech savvy, and innovation is sort of small I innovation, not some artificial intelligence, but how do I deliver a legal service more efficiently and answer a client's question or solve their problem more efficiency? That's what corporate clients certainly are looking for today, and you'll see a greater demand in that, I'm sure, over time. The last thing I wanted to give you some suggestions about in terms of how you might develop insights about what it is to practice in this area. And I would suggest there's lots of free opportunities for you. Law firms, particularly big defense firms, have lots of free webinars and seminars. So if you're interested in an employment practice, take advantage of some of those programs. We do a lot of them. Look on the websites where you can sign up and you can get free newsletters from law firms, invites to webinars and seminars. That'll give you great insight into what that firm does, what a defense practice looks like. And then there's some books like the Curmudgeon's Guide to Practicing Law, which has been so popular. It's second edition. It's published by the American Bar Association. And it's kind of this old school senior partner approach to writing to a new associate about what's expected. We give it to all our new summer associates in the Indianapolis office. I think it's very well done. I've read it myself. I would suggest that is something you might want to read. And then certain consulting firms have free publications that are like the Law Firms in Transitions done by Altman Weil. You can sign up, you can get that free. It really gives you insights into what issues law firms are dealing with. And they also do something if you're interested in being in-house, chief legal officer surveys that let you know what the law departments are looking at in-house, what's important to them, areas of practice, technology solutions, and what they expect from their in-house lawyers. And then I have that list, and I'll figure out either if you want, you can email me, you can find my information on our the Ogletree.com website. I'll send it to you, or get it to Susan, and Susan will make it available to everyone. But those are, I think, if looking back, if I could give someone suggestions or wish someone had told me this when I was a law student, I would look at these opportunities as trying to really develop insights about what it is to practice law, what people are looking at. Some of these consulting firms talk that, read the things that the lawyers you want to be like, or the firms you want to work with. What are they reading? What webinars and seminars are they going to? What are the articles are they reading about how to find future stars in your associate ranks? I think that gives you great insights about what it's like to practice in that area or that size firm. And then what are the things they're looking for, and what do they consider to be important and to be a star and be successful in the practice of law in that environment. So those are some thoughts, and glad to share my resource list with anyone who's interested.
Oh, thank you, Chuck. We're going to turn to Adele Rapport, who is a University of Michigan law grad, and she is the regional director for the Department of Education's Office of Civil Rights here in Chicago. Now, I was rooting around on the internet, just trying to find out some facts about Adele, and I came across something curious. Here's a quote from some site. "It is possible that Adele was also a regional attorney at the Equal Employment Opportunity Commission." Well, that is actually true. She was, in fact, an outstanding regional attorney at the EOC. So I a little bit of intrigue there. I'm not sure what that message meant. She is very active in the ABA's Labor and Employment Section's CLE committee. She was selected 2013 Government Lawyer of the Year in that section, and very active in bar associations and in teaching. And I want to turn it over to Adele.
Okay, can you hear me?
Yes.
Okay. First of all, I just wanted to mention that I'm not speaking on behalf of the Department of Education today. I'm just going to be talking about the spiral staircase that ended up where I am right now. As regional director for the Department of Education's Office for Civil Rights, we have a 6-state region, and we enforce the federal anti-discrimination laws in K-12, universities, graduate schools, law schools. We have jurisdiction in much of this region. My peer in Cleveland has Michigan and Ohio, but we have most of the rest of the Midwest, and then we also have North Dakota. So we do investigations, and then we're in a neutral capacity in that respect, and then we make determinations as to whether there's been a violation of the law. And then we usually get agreements with the various entities. We handle cases on behalf of students. Their parents or the students themselves may file complaints, but also teachers. Special education teachers could come to us and say, I was complaining that the students weren't getting the services they were entitled to, and I was retaliated against as a result of that. Or also coaches that may say, I was complaining that the girls softball team's field was not equivalent to the boys baseball team field, and and was punished as a result of that. So, we are neutral. We may decide one way or the other, whether there's been a violation, and we do a lot of writing. You have to be a great writer because we write determination letters. And when I was at the EEOC, and I'll talk a little bit about my spiral staircase, we would sometimes, issue what I would call an insufficient evidence letter, would just be a couple of lines. But when we send an insufficient evidence letter, we explain how we got from A to B. And so it's very important to write in what I call persuasively. And by that, I don't mean as an advocate, because I was an advocate on all sides, and I wrote, as an advocate in a civil manner, but, with a perspective. And when I say I want persuasive writing for my staff, I'm talking about people can read this document and understand how you got from A to Z. They may not agree with it, but they will understand it. They will understand what evidence supports your determination, how you've interpreted the law, and how you came to that conclusion. And that can be done in 7 pages. I tell them that's my sweet spot. 7 to 10 pages. You shouldn't need more than that to, explain a determination, a case. So I took a spiral staircase to get here. I started after I graduated from law school with what was Arnstein and Lair in Chicago. And I practiced for 11 years there. I did employment discrimination. I did labor law. I did some wage and hour. I represented, all like big, school districts. I did major corporations, Fortune 5 corporations. And I was able to work with some of the top people in those corporations. So I really felt this was a great opportunity for me to make changes. If I was sent out to a regional office by someone who was 5 levels above the manager of that office and said, I don't see any women, being trained to be mechanics, just wondering about that, this Snap-on tool poster in the locker room, with a half-naked woman, probably not a good idea. I mean, they listened to me. And I had the opportunity to work directly with people at high levels and just, help them prepare for a deposition, get through a deposition. It was very rewarding. But what I discovered, and one of my tips is that you need to be able to speak to everybody respectfully, civilly, and with a sense of humor, and just being really interested in them as people. And I'm talking about the charging parties and complainants and plaintiffs when I was on the management side, the high level managers. It's just, this is a noble profession, and it just is the right thing to do, but it's also, you need to have that skill. So, being a bit of an extrovert and being comfortable talking to anybody from any walk of life is very important. So I was at Arnstein for 11 years, and then my husband was transferred to Detroit. I was in Chicago. He was transferred to Detroit, and because of my activity in the American Bar Association, I had some friends that had a boutique practice in the Detroit area. I went with them for a couple of years. I really enjoyed that. Terrific lawyers, it was boutique employment law, workers' comp, and employment discrimination, labor and employment. It was a lot of fun. And then Don Livingston at the EEOC and I were on a panel together, and I found out that there was a opportunity to be the regional attorney for the Detroit District Office of the EEOC. So in fact, I was there for 13 years. That was not a possibility. That really happened. And, I often rely on examples from, when I talk about my practice from when I was at the EEOC. I'm still good friends with people in the EEOC in various offices, in particular, probably the Chicago office. Always been, friends with people there and, keep in contact with them. But that, was, well, my ideal job. I mean, everything that I had worked before came to be to my benefit to be able to succeed in that job. I would, start every day with what am I going to do for the people of the state of Michigan today? And I had so many opportunities to make changes for individuals who came to us, individuals who were silent sufferers, to change the workplace. But I also, having represented corporations, I didn't assume they were evildoers. I knew they weren't, and that they really wanted to fix the environment. I mean, if I had, and I had at all times, news cases, I usually had 2 on my docket and 2 coming up, and they're horrible cases. And, most of the employers, once we filed the complaint, would come to us and say, this is terrible what this happened. Tell me what you think we should do. We can't figure out who's been doing this, who's been putting this terrible graffiti in the restrooms. We don't know who put this noose up. We know it's causing a problem for our employee. What do you think we should do to fix this problem? And then we would work together to come to a mutually agreeable consent decree. I can't say that happened all the time, but we had a very civil practice in the Detroit bar, and I made an effort to have relationships with the big three so I could call and say, you know, you're about to fire somebody who's a Sabbath worshiper because he's not going to work on his Sabbath again. Just wanted to make sure that that was the decision you wanted to make. And sometimes they would say, oh no, the supervisor got carried away, we don't want to do that. Or I would say, I want you to talk to the complainant in our case who has a disability and all he needs is a scooter. And he's been working for you for 25 years and he can't walk from, you know, this part of the plant to the other part of the plant, which his job requires. So you just need to get him a scooter full time. And, you know, he has access to a scooter sometimes, but, you know, he will, because of his post-polio syndrome, lose his ability to walk if he continues to try to walk to these various parts of the plant he has to be in, and let them talk directly to somebody on the general counsel staff and resolve the case that way. So I really enjoyed my time with the EEOC. Our office merged with the Indianapolis office. So I was in Memphis for a while as the regional attorney, acting regional attorney, and I tried to talk my husband into moving to Memphis because I loved that job. We had Little Rock, Nashville, we had lots of interesting cases and a wonderful court down there. But my husband went down for 10 days and said, you know, you have a lot of nice friends, you know, contacts from the ABA, and it's not as bad as I thought, but I would have to start my career over if I moved down here. I have no connections to this community. So I ended up going again with a friend, my mentor from the ABA, Rick Seymour, and I practiced plaintiff's law in Washington, D.C., and they have wonderful plaintiff's lawyers there. I was very active in the Employment Lawyer Association there, and really enjoyed that, but I missed the government practice. I really liked working in the public interest, and even though you don't get paid as much in the government practice, it was mostly important for me to do that kind of work again. So when the opportunity to become the chief attorney, and I later became the director in the Department of Education's Office for Civil Rights, you know, I was just thrilled to be able to go back there, and I've really enjoyed the work that I do since then. So what I love most about my job is the mission work. I think that's what my staff would all say if you ask them. It's the work that we do. It's getting services for kids who have disabilities. It's fixing problems when, when a coach identifies, an issue with a softball field and getting them to fix the softball field so it's equivalent to the baseball field. So I think that making a difference and acting in the public interest, that's what I love the most. I personally love mentoring. I love having new attorneys come on and watching them grow and develop. Sometimes they leave me, and it breaks my heart, but then, sometimes you just have to let people fly and do something different. Some of them go into private practice afterwards, and they're very successful, and that makes me very proud. And so that's something that motivates me all the time. And that's one of the reasons why, if you want to contact me directly to talk about, the trajectory of your career, I love mentoring law students too. And I love writing. I mean, I do a lot of mostly editing. I don't write a lot from scratch because I'm, reviewing something after it's been reviewed at several levels. And I love meeting with the people who worked on the case and did the investigations and exploring the complexities of the case, but then assuring that we have a high quality written work product every time. I mean, it's going on department letterhead. I want it to be absolutely accurate. I tell all my new attorneys, I love reading fiction, but not on department letterhead. So, I'm holding you responsible for making sure that it's 100% accurate. Similar to Marnie, I would say my dad's advice, may rest in peace, he was a theater professor, and he said, you have to think about if everything in the world was free, what would you do every day for the pure joy of it? And that's the job you pick. That's something that you would show up every morning and say, I get to do this again today. And sometimes, I think Marnie's right, there's a little drudgery in it. You have to have a sense of humor to work in the federal government because there's rules that just don't make any sense in the real world. But, if you have a sense of humor about it, and you just get past that stuff and you think, this is what I do so that I can do this work that I love so much, it makes it a lot easier. Another tip that I would have is join a bar association and be active in it. I mean, every job that I've gotten, and not so much this last job, but virtually every opportunity that I've gotten has been because of relationships that I built in bar associations. So you may be at a point in your life where you want to shift to a different job, or you want to do a different kind of work, and you contact members of the bar association just as mentors, or they might even have a job available. I had my daughter's best friend was in that class that had a real hard time getting a job. And so I just set up conversations with Joe Tillis and other friends of mine who weren't hiring at the time, but were able to give her some advice about, where to look and how to, what would help her to get a job, which she eventually, was able to get a job that she really likes. I would also make sure that you are civil and professional in all the cases, because these relationships, when you're applying to be a member of the College of Labor and Employment Lawyers, if somebody has been, uncivil and nasty and, taken ridiculous positions in cases, not given, professional courtesies, that kind of thing comes back to haunt you. And when people act that way, it doesn't feel good for them either. I can't imagine. How could that person enjoy practicing law like that when they're always angry and nasty and uncivil to people, even if their clients think that means they're doing a good job as a lawyer? It's just not what you've signed up for, I think, in practicing law. I also think that you need to try to understand everybody's perspective. And not assume, try to put yourself in the other person's shoes, because it'll really help you succeed as a trial lawyer, where you can sort of predict, where they're going to go with an argument. But also, don't assume that the way you see things is the way everybody's going to see things. I always say that in mediation, that you have to assume that someone's going to believe the other side's version of the events. And if you can do that, it's a lot easier to settle the cases too. Being a creative problem solver. I love that. When you come up with an idea and say, how about we do this? I mean, I did that in a service animal case, went to Iowa with my team, and, it was a complex case, and we came up with a solution that made everybody happy. And, that was a great trip home. We all felt really good about that. Be concise in all of your communications, not just in writing, because like I said, I like that sweet spot of 7 to 10 pages. I'm sure that Judge Pallmeyer likes a sweet spot where you can be very concise and just keep cutting and cutting. And I'm a 5-draft writer because I'm always trying to find ways to cut. But you also have to be concise in your communications. So if somebody comes into my office and says, here's a complex matter, one, I do not like them to dump that on my desk and say, what do we do? I want them to come into my office and say, this is what I think we should do, and this is why. A, I considered B, and here's the problems with B. I considered C, and here's the problems with C, but let's talk about it, A, B, and C. And we may end up coming out with B or A or C, but at least they have presented a problem, and they've concisely presented a solution to the problem. So I think being concise in your verbal communications is also important, not just an oral argument, but in every communication you have with people that you work with and on both sides. If you're on the plaintiff side, you say, here's the thing that my client needs. Here's the precise things that they need. And then saying, I know you have something to say about this. And that's why, we're willing to take, less than what we would if you didn't have something to say. But here's what here's the issues, when you need a reference or something like that. So I guess that's, that's my story. I would always encourage people to go into the practice of labor and employment law, because it is passionate. People feel passionate on both sides. If somebody's been sexually harassed, it's horrible. It's life-changing. And 1 out of 3 women have been. We do a lot on college campuses, and it's very hard to read those files. By the same token, in the labor and employment field, if somebody has been wrongfully accused of sexual harassment, it's a career ender. And people take that very passionately. People, if you say you made this hiring decision based on race, people take that very passionately too. They say, no, it was qualifications. Here are the things that this person lacked, and how dare they say, that I made this decision based on race. So there's always passion on all sides, and sometimes not just with the individuals involved, but with their families. Their loved ones are very passionate about it. So I don't want to overspend my time, so I'll stop talking now. I'm like a little wind-up doll. I can just keep talking forever about this.
Thank you. And the final presenter on this panel is another of those folks who can do it all in labor and employment law. And Robert Block is a Northwestern graduate. He was a field attorney for the NLRB before private practice. And I would think it's fair to say this is probably the most prominent labor side firm in Chicago. He is general counsel to many unions, including the Chicago Teachers Union. And he advocates for unions on regulatory, legislative matters, but also represents individuals, negotiates employment cases, severance agreements, wage and hour issues. So I always admire that. So I'm going to turn it over to Robert Block.
Thanks, Richard. Can everybody hear me?
Yes.
Great. I guess I'll start by talking about my firm, how it got started. I graduated law school in 1984, spent 2 years as a field attorney for the National Labor Relations Board, and then went into private practice. I started my firm in its current form in 1991. We were 2 lawyers. Today we have 15 lawyers, and we focus on union representation, union benefit funds, and some individual work. In the early days, we had almost no clients, no union clients. We did a lot of individual work, and we spent a lot of time suing unions on behalf of their members to make them more democratic. We built our union practice basically by taking cases that other people didn't want. I did a lot of work in connection with trusteeships of construction unions, mostly mob-run unions, to get them cleaned up and democratic. Represented a number of very progressive unions throughout the city, like the Chicago Teachers Union, the SEIU, and sort of slowly the practice was built from there. And I'll say this, I truly love my practice. I look forward every day to going to my study to do work, but even going into the office now and then. In an era when working people and people of color are getting screwed every day, we really work to transform the system because the laws on the books will give protections to individuals, but in my view, collective action is the only true path to worker power. The thing about the practice is, unlike management, the unions can't afford huge legal bills. And so as a union lawyer, we do it all. I spent a lot of time negotiating contracts, dealing with strikes, a lot of litigation, federal and state court, labor boards, arbitration. I advise unions on internal matters, their elections, their tactics. And we get hooked into the broader social movement, which is very exciting. Because a lot of organizations that are fighting for civil rights and civil liberties, they look for support from unions. And so we get involved in that. And we spend a lot of time trying to devise new ways to achieve equality, dignity, better quality of life for people. You also get a chance to be very up close and personal with the elites, politicians, industry leaders. You spend a lot of time in the room with them. And the clients are just wonderful. You establish lifelong relationships and personal friendships that grow out of it from representing a union for 20, 30 years. And it's a really pleasant part of the practice. And you can make a decent living at it. Better than government, not as good as management, but you can do okay. The practice is always changing. It's fast moving. You've got strikes and injunctions, and the laws are changing a lot too. And you play a role in shaping the law, but mostly you just feel the ground shifting under your feet half the time, especially in the public sector, for better or worse. Maybe better in Illinois, not so good in Indiana and Wisconsin. And these days, of course, playing mostly defense. I'll say a word about the COVID pandemic. It has totally transformed my practice. When it hit, everything was absolutely dead for about 2 months, scared the hell out of us. But since then, we've been very, very involved in COVID-related issues. And I'm probably, it's one form or another of an emergency proceeding every week to try to make sure that people have protections from contracting COVID while on the job. In terms of a practice pointer, everything Judge Pallmeyer said was pure gold, really good. And the thing that resonated with me, and I think resonated with just about every other speaker, is the number one thing to do is learn how to write well. When we're hiring a lawyer, it's the first thing we look at, the writing, because we find that concise writing generally reflects concise thinking. So I wasn't that good of a lawyer or that good of a writer, and I'm still working at it to get better. But it's worth every minute you can devote to it to sharpen your writing and be a good communicator. Because again, as Judge Pallmeyer said, most of your advocacy is going to be written. Thanks.
Oh, well, thank you. Thank you to all of the panelists. I appreciate it. I'm sure the audience did. And so we're on a tight time schedule. I'm going to turn it over to Catherine Hartrick, who is an entrepreneur. Catherine is a think outside the box, creative kind of person. She's done an amazing number of things. She's practiced employment law at Seyfarth Shaw. She's been a senior corporate counsel and HR officer for huge, globally, publicly traded corporations. She's been a deputy commissioner at the City of Chicago Commission on Human Rights. And she now runs a very, very impressive firm that provides legal and investigative and coaching services that has sort of brought together all of the experience that she gained. So I'm going to turn it over to one of the most creative people I know, Catherine Hartrick.
Wow, thank you. Good afternoon, everyone. I'm Catherine Hartrick, and similar theme that everyone said is do what you're passionate about. And I have to say, for my career right now, with Hartrick Employment Law, I mostly do investigations, and I love them. And with the pandemic, I've been able to pivot into doing them virtually from my third floor office. Highlight for you guys, I am providing with our materials resources for law students, which really capture a lot of what the advice you've gotten from the speakers and Judge Pallmeyer this afternoon. Also, one thing to highlight, I've also attached an article that's called Networking for Introverts, but it actually has great advice for all lawyers and great advice for networking in this COVID-19 environment. And it's going to be provided with you. It was an article from the ABA Journal. Also, there's another article, 6 Degrees of Lois Weisberg, which talks about how Lois Weisberg had this broad network of people. And again, is a great way to meet people. So we have a panel, and our discussion is going to be, how do you do things remotely? We are going to have Adele Rapport, who you just heard, who is going to be giving a government perspective, and she's going to be addressing resumes and interviews. Also, we're going to have Tim Hawks, who is out of Milwaukee, Wisconsin, and he's going to be talking about remote mentoring. And then last but not least, we're going to have Jeremy Glenn, who is from the management perspective, talking about remote practice and team meetings. Before I introduce our panelists, though, a little bit about our speakers. Adele, you've already met, and you've heard about her spiral staircase. Tim, interestingly, in the late winter of 1975, he organized and escorted one of the first integrated delegations of South Africans around the United States for the State Department. Also, Jeremy, his dad out of Iowa was a veterinarian, and Jeremy helped deliver his first foal, a newborn horse, when he was 5 years old. Also for me, when I got my job at Cypher Shaw, my dad gave me a signed autograph picture of a labor leader. And this is the part of the prize. In your chat feature, and only for law students, not for speakers, the third person who correctly identifies who this labor leader is going to get a Starbucks coffee card with me and a free coaching session. So are you ready? Who is this person? And Jeremy is going to help with identifying who it is. Third person. Jeremy,
there we have it. We had 3 correct answers instantly. Congratulations, Philip Jones.
Okay, Philip, we're going to contact after, and coffee's on me, and some further coaching on networking. With that, I'm excited to introduce to you, reintroduce to you Adele Rapport, who's going to be talking about resumes and interviews remotely.
Okay. Just mention to the panel that I just hired 7 people. That's very unusual that we get to hire so many people, but we've had a lot of attrition. So, and I'm hoping I'll get to hire a couple more. Now, before people get so excited, like, oh, you know, this is we always hire people who have some experience. So I'll talk a little bit about, you know, how you get the experience that gets you into the government. But Justin, I've been doing hiring since I started, you know, practicing. I was on the hiring committee as a young associate, as a junior partner, as a partner, and I did hiring at the EEOC, and I'm doing hiring now. So, you know, I'll just try to give you, you know, some of my tips from, you know, my side of the table, looking at resumes and interviews, and particularly doing it in this remote environment, because I did hire all 7 of those individuals remotely. And, you know, when we start looking for 2 more, I hope that would be remote hiring as well, I would anticipate, because it'll hopefully be soon. So in terms of the resume, I think this applies to anyone, but, you know, our first cut is of the resume. So if you're applying through USA Jobs, for example, and it says they need your bar admission card, you must give them the bar admission card, because it won't even get to the people that are looking at resumes if you don't follow the directions and have your bar admission card. And applying for a job when you don't have that yet, that says you must have it, you know, you're just going to be cut from the consideration right in the beginning. I mean, so, you know, it'd be better to try to have an intern position, but you need to make sure that, you know, you have the qualifications for the position. I also think you need to have a short resume that really has, you know, where you went to undergraduate school, where you went to law school, any awards that you got in law school, any organization or associations or journals that you were on. I always look at that very carefully. Oh, this person taught legal writing. You know, writing's very important. This person was on the International Journal, Labor and Employment Law Journal, or any kind of writing, you know, on the Law Review is very important. Or they were in a society. They tutored children, and, you know, as an activity that's on, you know, activities and interests, or maybe you were Teach for America for a year, and, you know, in between. Make sure there are no gaps, because that always creates questions. You know, why is there an employment gap here? You might have a perfectly good answer to the question, but, you know, better to have, you know, your employment listed. And so that's really what I'm interested in, is, you know, looking at the top, you know, where did somebody go to school? What were their activities while they were in school? You know, grade point perhaps. It's always good to have foreign languages. If you have that, you know, put that on the resume. And then, you know, if you worked as an intern, what kinds of cases you worked on that may be relevant to us. You really need to tailor that resume to us, because, you know, we do education, we do civil rights. So you want to emphasize those aspects of what your experience has been. Now, for the interview process, what we do in the government is we use a hiring plan, and we stick to the hiring plan, and we make sure that everybody has the same opportunities in that hiring plan. So before the pandemic, we did 2 levels of interviews, and we would have, say, my chief attorney and a team leader, a couple team leaders, or my program manager would be a 3-person panel, and they would go through the resumes. They would pick the most highly qualified individuals according to our checklist, and then they would interview them in person. And then they would recommend to us, say we were hiring 2 people, they might recommend 6 people for an interview. and then a panel of very high level people, my boss, deputy assistant secretary, principal deputy, and me, the selecting official, would be on the second panel, and we would do a live interview. And I remember one time somebody asked to do a remote interview when she was in Chicago and was able to do a live interview, and I thought, oh, she must not be very interested in this position, you know, or she would come in. But now, of course, everything was remote. So, you know, I was a little nervous about that because, you know, I think it's very important to be able to judge someone's credibility as a witness and also their genuine interest in doing this kind of practice, their understanding of the practice. And I thought, you know, the tech systems, and there's always problems with it, and, you know, it's going to be a disaster. But, you know, you do what you have to do. And of course, we did have tech problems. The interviewees had tech problems. We had tech problems, but we got through it. So, but I would say if you're going to do a remote interview, it's very important that you test your system first, because then at least you can honestly say, I tested my system. So you want to test it, make sure that your background looks good and that you look good in the background. So wear a suit. I wear suits for the interviews, for the remote interviews, and the other interviews, wear a suit, because, you know, and you assume that that's a sign of respect for the people that are on the panel, but also I think it makes you feel like you're in an interview, you know, this is important and you're going to, you know, answer these questions directly. You know, it is also important that there be no typographical errors in the resumes. I mean, those don't, you know, the deputy assistant secretary, if you know, if you don't get Office for Civil Rights correctly, if I get a letter to Mr. Adele Rapport, you know, that's not going to make it, you know, even into the consideration. So make sure that you have, you know, your one-page resume that's very clear. Sometimes I get resumes, just to mention, you know, 5-6 pages for somebody who's 2 years out of law school, and I think I wouldn't do that for myself. And I've been practicing almost 40 years. Well, 40 years, Joe and I've been practicing. So if you're on Zoom, you know, sometimes people use that, you know, false background, which I think is fine. But what I found with some people is they disappear in and out of the background. So all of a sudden you can only see half their face and it's fuzzy, and that's distracting. It's also distracting if you're looking at yourself instead of at the people that are interviewing you. So you don't want to be constantly focusing on yourself. Make sure that the audio works, and you know that you're able to answer questions precisely and concisely. You know, listen to the question. We ask the same questions of every candidate, and occasionally there might be a follow-up based on what the individual said, but you need to read your audience too. So if we ask a question, for example, explain a complex case that you handled and why it was complex and how you approached it. If you're droning on and on about some, you know, case that you handled and you can't see that you've lost your audience, that's a problem. So you need to be able to focus on them. And the other thing that I would also caution you is, you know, often in interviews, people will ask you about work that you've done, and maybe work that you've done as an intern. Whoa, I worked on this very important case for, don't say it. Because I personally don't think that's appropriate in an interview that you discuss, you know, the work that you did on a client's case and identify that client in the interview. I mean, that should be sort of a privileged communication. So you don't have to, and don't say things that might let the person identify, you know, what the case was about. But you can still talk about the complexities of a case without identifying the party. I mean, if it's a published opinion and, you know, you want to say, well, you know, I worked on, like, one of my team leaders worked on a Supreme Court case that had been published while she was at a law firm. And so, you know, of course, she could mention that she worked on that case. She was on the list of attorneys who were on the brief for the case. And that, of course, you know, was a very impressive resume for her. So I think that, you know, you want to be enthusiastic about the position that you're in. But one of the things that, you know, we speak in a neutral voice. And so when somebody says, I'm passionate about the law, I'm passionate about, you know, the rights of one side or the other, that's not a good thing. You know, we want to hear that you're, you know, that you're able to examine things very, you know, on both sides. You're able to look at the evidence and, like a judge, make a call on what the evidence shows. And you need to prepare, you know, look at, if you can find out who's on your panel, do a little research and find out what they've been working on. I was very impressed with one candidate who said, gee, I noticed you got a great result in this case. And it was a sort of a cutting edge case. And I was impressed that she had done enough research to find out that I personally had worked on that case, because it was a very important case. It had 12 mediation sessions, had been a lot of time for me. So look at the accomplishments of the office and what the criteria for success of an office is, so I'm very into timeliness. And so, you talk about I make sure the trains run on time. That's one of my strong suits. And, I also just would say it's a difficult market. So, try to do everything that you can to make yourself, take mediation courses, intern for judges, do everything that you can so that your resume is going to stick out from the rest. And because I do try to hire a range of experience, from very experienced people to people who might be only 2 years out, but have disability experience that we need in our office. So I think my time's up.
Yes, so thank you, Adele. Our next speaker, but before that too, Jeremy or Tim, is there anything you'd like to add with respect to resumes and interviewing?
Yes, from a management perspective, she's right. It's going to be a tough market, but preparation will be the key to standing out. So one way to prepare, I would suggest for those of you interested in labor and employment, is check out firm webinars. Firms like Cozen O'Connor, Ogletree, Seyfarth, we've done dozens of webinars over the last 6 months. Go to the firm website, find a webinar, identify with a topic. Maybe it relates to a class you have, a note you've written, but use that as a launching pad to form a connection when you make a phone call or have an interview.
Excellent. It is, so another book that's really good is called Never Eat Alone. And I think that's where, to the extent you've written something and you see a speaker, send it. Again, this is really the opportunity to be creative. With that, we're going to keep going. Tim is going to talk to you about remote mentoring. Tim Hawks.
One of the reasons I've been invited to address this particular topic is that I have worked very closely with an associate that we brought onto with a clerk that we brought onto the firm a couple of years ago, and who we offered a position in May of 2019, and who we are grooming to assume my practice because I intend to retire next year. So during the first 2 years of working with him, I was able to have in-person contact, develop a good relationship, sociable, that I think is almost always better in person than virtually. But since last March or even late February, that has changed to having a virtual mentoring process with him. The reality is, though, it's been a very intense virtual experience over the last 8 months or so. So in order to prepare for these remarks, I tried to organize the thoughts that I've had on how to mentor, or better, how to be a mentoree in this process. The first suggestion I'd have is to organize by virtue of the priority of technology that you're going to be using with your mentor. So, and there are 5 that I can list, virtual media that you could be using. The first is email, second is text, the third is a two-way phone call, the fourth is a conference call, and the 5th is a Zoom meeting. And there are some communications that are better suited for one technology than the other. So if it's just a quick note, I'm going to be there, don't worry, I'm going to be 5 minutes late, or actually probably not good to be 5 minutes late. But if there's an emergency short communication that's logistics in nature, text message is fine. If you have a short communication or a draft of a memo that you're communicating, email is fine. If you have to have an in-person conversation, but it does not have to be a Zoom, it's not a conference, it's simply a two-way call, then grab the phone and make the call. Although an email asking whether or not your mentor would have some time free later in the day would be advised. And then when you schedule the time, go ahead and make sure that you make it. And then the conference call, and this is interesting because now in my work with this particular associate, we're meeting with my clients, and some of them, so these clients have been 30 years of relationships. So it's important that he join me in those conference calls. And I think on those particularly, we're sensitive to what the client wants and what the client's limitations are. So if the client is on the road in a car and just has his cell phone, a Zoom call probably is not going to work. If, on the other hand, the client's in his home or his home office or her home office or at their regular offices, then it's important, and probably Zoom would make the best sense. And so if you're working as the mentee in that situation, coming on the Zoom call is very, very, very helpful. I think it's important to identify what the nature of the conversation is. Is it social? Sometimes it's good just to check in. If you're the mentee and you haven't talked to your mentor for a while and just want to catch up and make sure everybody's doing fine, it's great just to drop a note, perhaps a note or a phone call just to check in to see if everything is working. If you have time that's available to work and want to do more, never hurts to write or call to see whether or not your mentor has work for you to do. Casework is the nature of a conversation on casework. So if you're drafting a complaint or drafting a brief in support of a motion or drafting an arbitration brief, or either for management or for the union side, that's a more intense communication that may involve reviewing the draft, may involve going over a draft that you have prepared as a mentee and that the mentor has either marked up with redlining or with comments in the margins. And for that purpose, a Zoom call is helpful, in my opinion, but it's also helpful if you know how to use the shared screen feature when you're going over the draft. And on casework, even there's subcategories on casework. If you're talking about sales or marketing, if we're talking about with my mentee working or this associate working on a question regarding developing a marketing brochure, for example, that's one level. If you're working on litigation, that's yet another level. And choosing your level of technology is important for those differences. Zoom setup. If you're a mentor or mentee, having acquired some skill in the Zoom setup is really important. So if you, the few things that I could share is lighting. You can see Catherine's well set up with lighting in the background and sort of fairly even light across the surface. I'm here in my office and have too much light overhead or off the windows. It can be distracting. It can be very distracting if it's extreme case. The elevating the laptop. So it's really, this is simple advice, but if you set the laptop up and it's too low, the laptop's going to be looking at your chin and up on the face. So in this case, I found that How Arbitration Works 7th edition is just the perfect elevation that I need for my laptop. And Adele's already spoken about the virtual screen. I want to second that. You've got to be real careful. Their virtual screens can work, but they can also become a real problem if they're not working well.
And if we could, so just to allow Jeremy some time, and I don't want to cut you off, any closing remarks?
No, that wraps it up.
So with that, so thank you, Tim. And Jeremy, if you have anything to add with the remote mentoring, I know you had some, but if not, I'll let you address the remote team meetings.
You'll get 2 for the price of 1, in fact. I do want to talk about being the mentee, and I want to share 2 examples that I think have been very effective for the mentees. The first person is an associate at my firm, and she asks to meet with me on a monthly basis. She's good at calendaring in advance that meeting. She comes with an agenda of items that she wants to talk about. I don't have to prepare for the meeting, she does. And then when we get together, she asks me about intra-firm activities that she could be or should be involved in. And she makes sure that I know what types of work she wants to do, what she has done, what she would like to see. That way I can be a champion for her in helping to create or steer those opportunities. So that's one example of a positive mentee. The second one is what all of you are potentially to all of us right now, which is we're not coworkers, but we're colleagues in the pursuit of a common interest in an area of law. So there is a young man who reaches out to me every 2 or 3 months. He talks about me. He's followed me on LinkedIn or Googled or some other stalking method that I'm not aware of. But he asks me about a speech I've given, an article I've written, something I've done, and then he asks, why did you do that? What was the professional development or the marketing approach, and how did it work out for you? So that young person has identified how to get somebody to talk about their favorite subject. You ask them to talk about themselves. But he's also gathering input from a mentoring standpoint about how he might build his career. Okay, so transition into practice now in a COVID-19 era in labor and employment law. I want to share 2 aspects with you. First, how do you interact with colleagues that you don't see in the office every day? And second, how do you connect with clients that you no longer see in person? Before I do that, though, a comment about the home workspace. 2 things it must be for everyone. It must be productive. That means it must be comfortable. And second, it must be confidential. Start thinking now about entering a career where it's important that you don't have devices listening to everything you say, whether internally or with clients. As we transition to a work from home environment 6 months ago, it like put the accelerator pedal on the need to be less document dependent, to be more familiar with electronic information and how to marshal resources or pull up information quickly. I learned a great deal from several lawyers about a product called OneNote, which allows you to tab depositions, tab exhibits, link back and forth to documents, and that allows us to practice more efficiently. So I would suggest anything you can do to stay on top of developing software to lessen your dependence on paper products will be helpful in your career. Now, the most important thing, I think, for new lawyers is the opportunity to absorb from senior practitioners. It just so happens that in November of this year, I will celebrate my 1-year anniversary of being inducted into the college. And I couldn't have done that without having absorbed 20 years of incredible lessons from the men and women that I worked with. So how do you absorb that when you're not with them on a day-to-day basis? Well, the traditional advice of get up out of your office and walk around doesn't really apply anymore. So how do you stand out? I've got 3 suggestions for you. First, in team meetings, it's so important to participate. Even if you're one of 12 squares on a Zoom call, it's so important that you learn how to quickly unmute to ask a question, make a comment, or use the feature at the bottom of the screen that allows you to raise your hand. I would also recommend that if you're invited to a team meeting, try to get the agenda in advance. That way you can actually plan for what question to ask or what comment to make. If there's the opportunity, volunteer to be on the agenda. In the era of COVID, I have seen that our team meetings are much more frequent and they're much shorter. We don't sit down in a conference room, order lunch, and spend 2 hours. We do 30-minute weekly updates. And we compress into those 30 minutes an awful lot of information. Back in March, we started this idea of COVID question of the day. You know, what question have employers come to us with about keeping their workplace safe, keeping their employees healthy and productive, how to manage the varying impacts of the law? That has evolved into now hot topic of the day. And even in a group with 80 labor and employment lawyers nationwide, like Cozen O'Connor has, there's an opportunity once a week for every lawyer to have 5 to 8 minutes of the stage. And if you are entering into a new practice area, a new firm with labor and employment law, that's a great way to learn the area and present yourself and stand out. The second way to stand out, I would suggest, is also brand new to the COVID area, and that's the ability to watch or participate in activities you could not have done so before. John Runyon spoke at the beginning of the day about video arbitrations, and Jean Vonhoff talked about how she's done 25 days of video arbitrations. Imagine how much easier it is for a new lawyer to sit in the side room and listen and participate and listen and watch what unfolds. You no longer have to travel to a location to be part of the hearing. You no longer have to incur costs and expense. So the opportunity to watch and observe depositions, hearings, mediations, even court appearances is tremendous right now. So I think the new lawyer that takes advantage of that will also stand out. And then the third way I would suggest is the Zoom events that are happening. Law firms of all shapes and sizes have tried to engage and connect with each other through happy hours, movie nights. A very effective one was the ABA's 21-day Racial Equity Habit Building Challenge. I encourage you to participate in those. It feels like extra hours, but it's important connectivity and engagement with your colleagues. The final thought I'll close with is on connecting with clients in this age. Client responsiveness and expectations have changed. When I started in 1997, email was new. And it was the early 2000s before Blackberries and 24/7 email was ubiquitous. But now it is. Now the expectation is respond within 24 hours, if not sooner. In the COVID era, for many of our clients, whether they're individuals or in-house attorneys, the lines have been blurred between the workday and the weekend. So I remind you to be respectful about your clients and their availability and responsiveness, because my sense is many of them are working harder than they ever have at early morning, late evening, weekends. And while that flexibility is good, there's a strain. And I think we need to recognize that and be part of the flexibility solution, not part of the overload problem. We may not have physical handshakes and dinners together, but lawyers are still engaging with their clients. One of the things that many fellows do is reach out to a client and just ask, how are you doing? Or here's an article I thought you might enjoy. Or here's a webinar coming up that might have some relevant information. If you're in law school, you should know that the way lawyers interact with their clients is evolving. And I would suggest that you can practice for that evolution by doing something as simple as reconnecting with friends, past coworkers, even family members, and practice those habits of, I'm just calling to check in, have something I thought would be of interest to you. And those are the kinds of conversations for lawyers that often lead to work and new relationships. So that's a practice tip you can start building on now. And with that, Catherine, I turn it back to you.
Thank you, Jeremy. So just a couple closing ideas for you that I'm taking from the other speakers, as well as you know, there's going to be a paper coming to you. Susan's going to forward it. Also, I encourage you can reach out to me. From Judge Pallmeyer, be a joiner, be kind. Don't underestimate the power of the written word. From Patrick Deedy, your technical expertise, your Zoom expertise can really help you. From Jeremy, be flexible, be creative. Again, be a joiner. Think about those bar associations. Think of the young lawyer section, but even the technical areas, and think of how you can contribute through writing or speaking. Adele, Jeremy, or Tim, anything else you want to leave with the group before we go to the next breakout session?
Not for me.
No, thank you.
All right.
Nice summary, Catherine. Thanks.
Good luck, everyone.
Okay, we are going to attempt to do breakouts right now. hold on just a second. We've had a little bit of a change in terms of the format because we've had people drop off and I can't kind of reassign on the fly. So we're gonna do an automatic breakout, and it'll assign people. If there's more than, if there's any rooms that have fellows and no students, then I'll reassign you as quickly as I can. So just be a little bit patient with me as I try to work through this all on the fly. And secondly, I will send out the email that Catherine mentioned probably on Monday, just because I'm going to go home after this. So, but I will send that, and what I've been able to do during the day is to cut and paste any of the reference materials or things that were in the chat will also be part of the email that you get, as well as the evaluation form that Marty mentioned in the beginning. So please return that form to us. All the other is just information and attachments that were part of the presentation today. So, so anyway, so all right, so I'm going to try to do this real quick, and hopefully looks like we're good so far. I'm seeing that everybody's got a fellow in a room. Wow, did I do this? No, I didn't. So I'm gonna exchange Joe into 10. So, so anyway, so I'm going to try to do this right now, and hopefully it'll work out. Okay. Thank you all so much. Sherry, if you're there, you can sign off because I did not have you down for one this afternoon. And she is gone.
Than the one I had yesterday.
It looks like what we ended up with was a lot of students that dropped out, and I apologize. So that was, we could not, you know, as it ended up, I was trying to do 2 pre-assigned breakouts and I couldn't figure out how to do that. So we ultimately, with the dropouts that we had and people that weren't there, I ended up just doing an automatic manual. So you're free to sit and chat, or you can go start happy hour early.
Okay.
So
well, Mark and I can chat for a few minutes. Sherry, are you? Yeah, Sherry, are you? I don't even know if Sherry's here.
I don't even know if Sherry's there.
She has her, you know, her screen's off. She doesn't seem to be hearing us.
Right. But in any event, so just don't talk about it.
All right. Well, we'll talk for a few minutes, but then, you know, I am going to go. So if you need me, like, have at it now. But it sounds, I mean, the little bit that I listened to recently, it sounded, you know, great.
Sounded great.
Yeah. It really went well.
Yeah, no, I think the program went really well. And I think that next time, again, this was such a learning thing when it came to the breakout sessions, because the way we wanted to do them, and it was very hard. I spent the entire week was focused on all the background part of this, and it was really hard to figure out how to assign people and the different ways. And like I do with the dinner, I spend a lot of time making sure that people sit where I think they would like, and people that expressed an interest in union side work, and they specifically in Chicago, I was trying to put them with, you know. So in any event, lesson learned. Next time it'll just be random.
Well, truthfully, as we
We're
discussed,
going to have to do it this way one more time.
I mean,
I hope
after
we're going to be
today,
back.
no, this is it. This is it.
No, I think what Mark's asking is, do we think by the next time you do something like this, we'll still be doing it like this?
I hope not, Mark, but I think we probably will. I'm holding out hope. The dinner is next November in Beverly Hills. We're getting ready to re-sign the contract. It just makes me sick at my stomach thinking about, 12 months from now where we're going to be. So
Yeah, I mean, who thought we'd be here after 6 months doing it this way?
exactly. So God willing, we'll be able to be in. I missed my trip to Chicago, so if it has to be, then I guess at least this worked well for the first time out the gate. I'm not upset right now. So
That's right, you're in Annapolis, aren't you?
yeah. So in any event.
Well, it's nice to see your face, Susan, even,
Yes.
this, evening,
I know. Thank you. It's good to see other people. It's weird not seeing people in person, but in any event. So,
Well,
all right,
I'll get used to that.
I'll leave you guys to chat. I'm going to check on a couple of other rooms, and then when you're ready, you can just
Do
log out.
you need us to hang on in case you need assistance with another chat room?
Yeah, if you want to, I'm going to go. I just got a message from one room that they've got 3 fellows and 1 student, so they're probably beating them up right now.
Yeah, okay. All right.
All right, thank you.
Yeah, thanks, Susan.
We'll talk.
Okay, thanks.
Hey, we got a party crasher here. Yeah, well, at least she's muted so that she's crashing our.
Now I'm not muted. I'm never muted, Joe. So no, I was just dropping in trying to check on people, but it looks like you guys have, don't hurt Joe. He's a nice guy, so.
Aw, that's the nicest thing you've ever said to me.
Probably the only time too, so.
That too.
All right, goodbye, you guys. Take care. When you're done, you can just log out. We're not coming back to regroup at all. So.
Okay.
All right, thanks.
Cool.
Hey, Susan.
Hey, Susan.
Hi, I'm sorry. You all, you got a captive audience there with 1 student. I'm sorry, but the way that this all kind of worked out, it wasn't worth trying to go through it to change it because everybody's really got actually 2 students to like 2 fellows in a group.
Well, that's good. We're enjoying our chat. Don't
Okay,
worry.
so you go ahead and just
We're good.
let you know when you all are done, you can just close out because we are not coming back into the main meeting.
Okay.
Okay. All right. Thanks. Bye. Have a good weekend.
I see.
John?
Hey, sorry, I got bounced out. I think somehow, yeah, I don't know what happened, but anyway, I'm back.
I don't know how to put you back in.
Okay. I was in with, I wasn't in with the group you sent me.
No,
I
I
was
know. That's
in with-
because everything kind of changed.
Oh,
So,
it's okay. But they're in with a fellow.
okay. So don't, yeah,
Okay.
although
I'll
I can assign you. Which one was it? Who was
With
the
Mark,
fellow?
Mark, from, I can't think of his, with it.
Kasheri?
Yeah, I think he's in Arizona.
Yeah, I'm gonna go ahead and put you back in there just real quick. Is that okay?
Yeah, no problem.
Because is Mark got his camera on?
He did, yeah, he got it on, yeah.
Okay. Hold on.
Everything was fine. There was some voice issues, but anyway.
All right, I'm gonna try it again. Just one quick
Yeah,
time.
and if I don't get in, I'll just sign, I'll just sign off, but.
Okay, sounds good.
Hang in
Thanks,
there.
John. Okay. Mark, you're good to go. We're done. You're muted. You're muted.
Okay, now?
Yep.
Good. Yeah, I just talked to Jackie for a while, so we got caught up there. But
I'm glad I could help.
yeah, well, stay well and hang in there.
Yep, we are, as everybody comes back on, this is kind of concludes everything for us.
Hey, Mark.
So
Hey, Bert, how you doing?
thank you all so much for joining us today.
Susan, you've been great. You've been great as usual.
Thank you. Was that for me, Bert?
Yeah, I said you've been great as usual.
So
Thank you very much.
have a great weekend, you all, and thank you again so much.
Yeah,
Talk
thank
soon.
you, Sue.
Thanks,
Okay,
Susan.
take care.
Bye. Bye.
Goodbye.